All right, back to you, Susie.
Thank you so much. Good. Back for just a couple of days, but I'm excited to be with you today. We're going to be covering a lot of information today. Looks like, let me just check my internet here just a minute.
Yeah, you did freeze up for a minute.
Yeah, let me just, okay. Just a minute. Just let me know if that happens again, okay?
Okay, yep.
Because I can check. Let me just, I think we should be okay. So anyway, I'm excited to be here, and we have a lot to talk about today. We are going to be taking a break at about 10:30 this morning, about a 10-minute break, and then we'll be taking lunch at noon. And I'd like to restrict lunch to 30 minutes if that's possible for all of you, so that we can be sure that we have enough time to cover all the material. And then we'll take a break later on in the afternoon. As Stephanie said, feel free, if you would prefer, to type your questions into the chat. That's great. I can see it pop up. I can take a look at it while we're doing the session and see if it's something that we want to answer at that moment. If not, what I'll do is I'll be answering the questions after the first break. And if you want to interrupt me, that's fine as well. Feel free to turn your camera on and or just turn your microphone on and just say, Susie, I have a quick question. No problem at all. Let's pretend like we're in the room together, because one of probably the biggest benefits of being in the same room is that we get lots of great questions. And I think that most of us learn from those questions. I know I do as well. It's interesting where I, run into things that I've not heard before. And so if I don't know the answer, I'll let you know. And we definitely will get it for you. But what I have done today is I've customized the training to Michigan law. We all agree that opening new accounts is complicated, and most people who've never opened new accounts have no idea how complicated it is. If you all wouldn't mind typing in the chat, and I'll just kind of look at it as I'm speaking, how many years you've been in banking, if you don't mind doing that. Just give me the number of years you've been in banking. I'd like to get an idea of how many people we have that are, relatively new. I've got 6 years, 8 years, 7 years, 3 years, 29 years, 33 years, a year, 25, 5, okay, 10, 2, 1.5, okay, 6, okay, so that's giving me a good idea. Those of you that have, 30 years experience, if I need to take a break, I'll let y'all jump in and continue. But we've got several very experienced, 35 years, okay, great, you're going to be a candidate to help me take a break. And those of you that are super experienced, I know you have some great examples or scenarios, or you might have some of those more complicated questions. So feel free to, share those with us. Those of you that are new, this session is for you as well. We are going to be getting into some pretty complicated scenarios. And what I find for people that are new in banking is you might say, oh my gosh, this is just like a foreign language. I don't know what we're talking about. And then tomorrow, someone's going to come in and you're going to go, oh, that's what she was talking about. But one of the things that I have provided for you is the manual. And a couple of things you might want to have in front of you might be your signature card, your account agreement that you can reference it while we're going through the training, and then your resolutions and associations for business accounts, because the manual does include for you basically 98% of what I'm going to tell you today. My training style is to provide you really with a pretty robust reference when you finish the training. I know I don't like to go to training where I have to take 7,000 notes, then I get back to the bank and I'm going to type them out and have no idea what I typed. So I want you to know that I'm really going to be going page by page. In the top right-hand corner, you'll see what page number I'm on. And then look at the very back of your manual, the very last 6 or 7 pages, and you're going to see that there's a reference chart, which basically is the entire manual. It walks you through every type of account. It tells you how to title it, tells you what legal documents you need. But in addition to all of that, in the manual there is a section for every type of account we're going to talk about today. So if you want to look at LLCs, LLPs, if you need to look at general partnerships, you want to look at trust accounts, you want to look up, POD accounts, there's a section for every one of those. And basically in that bottom right-hand corner, each section sort of has the same format, a description of what that particular account is, how to title it, what kind of identification you need, what TIN you're going to use, the documentation that's needed. Does it need a resolution? If it does, who needs to sign it? And then what about changing signers on an account? So I've really tried to kind of give you, if you will, my 47 years of experience in banking, having worked with hundreds of banks, having, as Stephanie said, just retired from a bank after being there for 22 years. And even though I was on the investment side, we still open new accounts. The regulations are exactly the same. I've been on the bank side as well for about 10 years with the previous organization I was with. So I've really been in banking for a long time and have seen a lot of those of you that have worked in new accounts. But today, this morning, we're going to focus on business accounts. Then early afternoon, we'll talk about personal accounts, and we'll wrap up with fiduciary accounts like trust accounts and executorships and conservatorships and that type of thing. So this morning, we're going to talk about business accounts. And our goal this morning is to really understand how business structures are different and why there's so many. Why are there so many partnerships? Why do we have 3 different partnerships? Why can't we just have one? How to determine, and this is probably the most important thing we want to do today, how do I know who the responsible party is that can actually authorize this account to be open? And we're going to look at your in-house and out-of-house documentation options. We'll talk about FinCEN, the beneficial ownership requirements. We'll look at opening and documenting those complicated business scenarios where you have the business owned by a business, an LLC that's owned by a partnership, and then the impact on business accounts when an owner or an authorized signer dies. Do we freeze the account? Do we not freeze the account? Or when a business owner is removed from the account, a partner resigns from the partnership. So we have a lot to look at with business accounts this morning, and I'll go through with you the other sections, the personal accounts and the fiduciary accounts, what we're going to be covering at that point as well. So I want you to know that I believe this from the bottom of my heart, because I've worked in new accounts for so many decades, that opening new accounts is the most important job in the bank. And by the time we get finished today, if you don't agree with that, you will, because it all begins with us. If a criminal can't get in the door, they cannot take your organization, they cannot victimize the community. And so that con artist that comes in and tries to cash a check with a teller, I was a teller for many years as well. Tellers, they have the benefit of being able to say, I can't help you, but that lady right across the lobby there in new accounts, you have to be a customer if you want to open an account. So they come over to us, and we all know that feeling. You're sitting at your desk and this person's walking up and you just say to yourself, please don't come to my desk, and they just walk right up, and you're like, this is going to be one of those scenarios I can tell that's going to be kind of weird. And we all have had them. We have that gut reaction. So, sometimes we feel like, why didn't I go to lunch when I had the chance? Darn it, why didn't I go to lunch? Because we get customers coming in and asking us, my company's an LLC and it's owned by a corporation. Can you help me? My company requires 2 signatures on checks. Does your bank allow that? I'm a sole proprietor and I don't want to open an account. I just want to deposit those checks to my personal account. Or I want to use my social security number on my sole member LLC. Can I? I want to use my social security number on my nonprofit homeowners association. Can I? And my company is a limited partnership, and the 2 partners are not humans, but they're an LLC and a corporation. Can you help me? So those of us that are new to banking, these may seem to be very foreign scenarios to you, but they do happen often. And so we do feel like, good grief, what was I thinking? When I started new accounts, as I said decades ago, I had a good solid 20 minutes of training. They literally said, so here's the deal. Here's the pink index card for business accounts, and here's the blue index card for personal accounts. Any questions? And I'm like, okay, the very first customer that comes in wants to open a trust account. And so I'm kind of like, So what's your favorite color? Because I have no idea what I'm doing. That's when I began writing the first new account seminar that I began teaching at our bank, because I wanted it in writing. I wanted to understand exactly what our responsibility was and what the customer's was, okay? So managing risk is really our job. We're going to ask a lot of questions of our customers. What's the purpose of the account? What are you trying to accomplish? Does this person have authority to do what they're asking me to do? So we're going to talk about those questions a lot as we go throughout the day. But one of the things I really want to make sure that, and I find this not to be the case in a lot of organizations, is to be consistent. You know, one branch does it this way and the other branch does it that way. We sort of have, I call sort of the Betty syndrome, where Betty has been with the bank for 35 years. She does it this way and she's not going to change. Her customers expect this. So her branch does it differently. And so we've got to be really careful about waiving policies for customers, because if you have a policy that says we do not cash checks for sole proprietors, but this one branch always has, we're not being consistent. And so when you're not following your own policy or procedure, you are transferring risk from the customer to the bank. And so if there's a problem with that particular scenario, the bank is at risk, because we have a policy that we don't do that. And I realize we're going to make exceptions. I get that. You need to be very, very careful, because I'm going to talk in a little while about how a bank lost $100,000 by waiving a policy for one of their best customers. I call it the good customer syndrome. Been there, done that. It was an account that I opened and our bank lost $100,000. I am not the one that was fired, and I'm going to tell you why. But if you're not going to follow your procedures, you've got to understand what the risk is, okay? So we got lots of regulators. I want to kind of go through this next section somewhat quickly, because I think it's somewhat sort of common sense. We get the regulators, the U.S. Patriot Act in 2001, which may be before some of you were born, but that really did open up a lot of new, more stringent, because of 9/11, requirements of identification, identifying businesses, digging down and finding out who actually own these businesses, identifying the customers, financial record verification, like check systems or Qualifile. If you use that, when do you use it and when you should not use it on customers? And then, of course, OFAC was a huge result of 9/11, where we have to make sure to check this government list to make sure that our customer is not part of a terrorist organization. That's refreshing. So we're going to look at a proper account titling and identifying our customers, and looking at their previous banking history and what kind of disclosures do we have to give them, and comparing with government lists. And then when to use a social security number and when do you use an EIN. So first of all, obvious on the account title needs to match the documentation we're getting. It needs to match the payee on the check. And it needs to match the identification number we're using. And so that sounds pretty obvious, but I have had situations where the documentation, like the assumed name certificate or the documentation from the Secretary of State, doesn't quite match the payee on the check. And your policy needs to be, it does need to match. I mean, that's what a con artist does, is they create a check or they alter a check and they change the name just enough. And then we go online and say, this doesn't quite match. Well, it does need to match. Always going to be exceptions, but rarely, okay? And then our biggest question with a business account is, who has the authority to open this account? What is the capacity of each signer? So I'm going to be using the term responsible party. So what's a responsible party? That's an owner, a partner, a member. Those individuals have the authority to enter this corporation or this LLC or this limited partnership into business activity. And so they're the ones that cannot be deleted without their knowledge or their permission. They are the ones who we need to verify and get documentation on the business. And that documentation is going to tell us then who these people are, who's the owner, who's the partner, who's the manager. Non-responsible parties are like the secretary or an authorized signer on the account, the bookkeeper, the office manager. They are not responsible parties, and so they can be deleted without their permission. So I need to be able to look at a signature card or a resolution and be able to tell who is a responsible party and who is not, who can remove people, who can add people to this account, who can give us instructions on the account based on their authority, okay? So the first thing that we're going to do, and we're going to spend most of our time this morning talking about, how do you identify a business? What kind of documentation can you get from the Secretary of State, on a county level? What kind of documents can I get to tell me who the owners are? And then the next set of documentation we'll talk about is the customer bringing us documentation, like an operating agreement or a partnership agreement. So the sort of phase one is they file with the county or the Secretary of State and get their driver's license for their business. And I'll talk more about that in just a few minutes. And then if those documents don't tell us what we need, it doesn't tell us who the owners are, it doesn't tell us who the partners are, then I'm going to have to dig a little bit deeper and have my customer bring me their operating agreement for an LLC or their partnership agreement for a partnership. So we'll go into great detail about that, but that's kind of the first step, is I'm going to need your documentation to tell me really who you are. Then we'll identify those people, identify responsible parties, identify non-responsible parties, get their date of birth, their driver's license, all of those things that we need to identify those individuals, okay? And then if a customer wants 2 signatures required, I'm hoping that none of your banks allow that. And this is the reason, is because, those of you that are new to banking, you probably already know this, but if you don't, need to understand that we are not verifying the signature on every check that comes through. We used to, and that's Betty, who was in bookkeeping 30 years ago, and she did check every single signature on every single check that came in, and she could tell just by looking at it if it was a forged signature. Today, we don't check those checks. And so if you allow a company to require 2 signatures and you don't say to that customer, if you want to do that, that's great, but we are not going to be checking it. We are not going to be monitoring it. And we are held harmless if a check comes through without 2 signatures. If you don't do that, then you are transferring risk from the customer to the bank. It now becomes your responsibility to monitor those checks. So we do not want to be put in that situation. And if you are in that situation, at least charge them a fee to do that, because you are at risk, okay? But what I find that most banks do is they say just exactly what I said. If you want to do that, that's great. We're not going to monitor it. We will be held harmless. And some banks even have the customer sign a form acknowledging that. It typically is in your terms and conditions. We'll talk about what those are in just a couple of minutes. We need to be sure that our customer understands it's your risk, not ours, okay? And then running people through check systems. Some banks use this, some banks don't. You are not required as a policy to verify a customer's previous banking history. What is that? It's a national database. And so if I overdrew my account with my bank here in Houston, and then I come to your state and I come in, to your bank and I say, I want to open a new account. If you verify me and you pull me up, or my company comes up and sees that I'm on file with Check System Qualify, whatever you're using, this third party vendor, then you can say to me, the bank is not going to know what the reason was. All we know is they're on file. And so you cannot open an account with our bank, Susie, until you get that cleared up. So it does protect your organization from irresponsible customers who've left their bank with $1,000 overdraft or whatever the case may be, and making sure we're not opening accounts for those folks. So the question is this: if you're using a company like Check Systems, for example, Check Systems is a reporting agency, a credit reporting agency. And the question is, if you're opening a business account, so I come into your bank and I want to open the account, and I have Daryl, I see Daryl's name here, and Daryl is the banker. And I have with me my assistant, my secretary, my office manager with me to open this account. And I say to you, I want to open an account. I'm going to be a signer, and Sally is going to be a signer also. So who do you run through Check Systems? Well, legally, you can run me through, obviously, because I'm the owner, and you can run my business through. But are you going to run Sally through? And what the Fair Credit Reporting Act says is, no, you're not going to run Sally through. This is a invasion of her privacy, okay? So if I want access to her Check Systems report, she has to give me in writing consent to do that, okay? Because I don't know if you've been in this situation or not, but I sure have, where in the old days, we used to run everybody through and Sally was on file. And Daryl says, so Sally, can you want a cup of coffee? Why don't you come back here with me for just a minute? Let's get you a cup of coffee. You look like you're really tired. So Daryl and Sally go back in the coffee bar and Daryl says, Sally, we got a problem. You're on check systems. And she goes, is that good or bad? Well, that's not good because you cannot sign on this account. What are you talking about? I can't sign on the account. Well, you're on check systems. I don't know what you're talking about. Oh, right. You know, we all have this attitude that, oh, the person, no, they knew they were on file. So you better tell your employer, Sally, that you are an irresponsible party. Oh, great. So we go out to the desk and Sally goes, I don't know what we're doing here, but I can't sign on the account. So, you know, I say, oh my gosh, you're my bookkeeper, you're fired. So we need to understand that Sally is a non-responsible party. She is not responsible for the account. If the account's overdrawn, we are not going to go after Sally. Okay. So the Federal Reporting Act says that Sally must give her consent for reports to be provided to her employer. And if she doesn't do that, and damages happen to her where she gets fired, that the bank actually can be liable for that. So we need to be very careful about who we're running the check systems. On a business account, we can run the owners, the partners, the members. We are not going to run non-responsible parties through. If you have any questions about that, feel free to pop it in the chat. Okay, so customer notification, we're giving our customers all sorts of things. We've got a notice in our lobby saying we're going to, check your date of birth. We're going to get identification. Eventually it's going to say we're going to be getting your blood type. It's getting pretty serious these days. So we're giving them just a little shopping bag full of stuff. Now, your terms and conditions, that thing that you give your customer, it's probably 10 pages long. If I were in the room, I would ask, how many of you have read that? And what I typically get out of a group of 30 people, 2 people raising their hand. And so, I'm not going to read that. Well, we need to read it. We need to read that. We need to really understand that the signature card, and I'm just going to show you an example of one. I don't sell signature cards. This is a Walters Kluwer signature card, but they come in many different shapes and forms. Those are legal documents. And if your bank is ever sued, those will go with you to the courtroom. Those are your courtroom buddies. Okay. And when I had a consulting firm many, many years ago and doing this new account training from 1976 to 1995. And I had a company called Training Resources and did this training. And during that time, I actually served as an expert witness on behalf of banks when they were sued. And the very first thing I have to ask is, show me your terms and conditions, show me the signature card the customer signed. And many times, on page 6, they had not followed their own terms and conditions. And so if you're not reading that and really understanding, and we're going to be referring to some things today within these terms and conditions, you may as well just get out your checkbook because you have violated your own terms and conditions, okay? So again, I'm going to be giving an example in a little while of some accounts that had some issues. I really encourage you to not only legally, we have to give them the terms and conditions, but give your customer a copy of anything they sign. Because if you go to court, we don't want the attorney that's suing your bank saying, why wouldn't they give them a copy of this legal binding contract? Because that's what the signature card is, the resolutions and so forth. Okay, so give them a copy of anything they sign. We know that we have to run our customers through OFAC, Office of Foreign Asset Control. We have to run them through to make sure they're not a terrorist. And I ask when I'm in a group, how many have ever had a terrorist sitting at their desk? And most people say, never had a terrorist. I've had lots of terrors, people that are kind of yelling at me, but no terrorists. So I get that. Sometimes customers don't like what we're asking for. And so our goal today is to make sure that they understand that we're not trying to be difficult, okay? Now, we are going to spend some time now talking about for business accounts. Remember, I'm just talking about business accounts this morning. Looking at when do you use a social security number and when do you use an EIN? We'll talk about ITINs a little more when we get into the personal accounts later on this morning. But we know that an employer identification number is exactly what it sounds like. It's when someone has employees, okay? And so they go online, they apply for it. What I really want to talk about this morning, and this is probably going to be one of the most important things we'll talk about with respect to business accounts this morning, and that is the sole proprietorship. I see lots and lots of confusion about sole proprietorships and when you use a social security number and when you use an EIN. So when a customer applies for a EIN, they're going to use a form called an SS4. Now, we're not going to see this form. We're not going to, help them apply for it. But the SS4 is how a sole proprietor applies for an EIN. So the first question is, why would a sole proprietor apply for an EIN? Because they have employees, okay? So the IRS, so what they'll do is, let's just talk about the sole proprietor. Let's say that we have a sole proprietor and his name is John Doe, and the name of his business is, he's a pizza company, they make pizza, and the name of his pizza company is Rolling in the Dough, okay? D-O-U-G-H, all right? And so he goes to the IRS and he fills out this form. He does it online, but just to let you know, this is what is going to be asked. So on line 1, if you'll look at that SS4, it asks for the legal name of the entity or the individual who's applying for the EIN. So he has employees and he's withholding on those employees' paychecks. What he cannot do is submit withholding on an employee's paycheck to the IRS using his social security number. He has to have an EIN identifying him as an employer. That's why it's called an employer identification number. So on line 1, he's going to put John Doe, okay? And then line 2, it says trade name. So if he has a trade name and he is using a trade name, a fictitious name, he's not using his name, he'll put Rolling in the Dough, okay? Then he'll come down here to line 9A, he'll check sole proprietorship, and he will put his social security number, all right? So what we need to understand is that when he comes in to open an account, the IRS actually prefers he uses social security number. But let me ask you this question. When the IRS issues his employer identification number, we've got John Doe, Rolling in the Dough, pizza. So when the IRS issues that EIN, in what name are they going to issue the EIN? Are they going to issue it in John Doe's name? Are they going to issue it in Rolling in the Dough pizza? They're going to issue that EIN in John Doe's name. What we need to understand about sole proprietorships is that from the IRS perspective, they disregard the sole proprietorship. They say, good for you that you have a business and you're using a fictitious name, but the business is you. And so we're going to issue that EIN in John Doe's name. So, because let's say that John Doe is John Doe Plumbing, he's not using a fictitious name, but he has employees. He would put on line 1, John Doe, and he's not using a fictitious name because he's using his full name and a description of what he does. So there would be nothing on line 2 of this SS4, but he would still get an EIN. So he's going to get an EIN number, but it's tied to his individual name. So when you open an account for a sole proprietor, you're always going to title the account John Doe, DBA, Doe, Rolling in the Dough pizza. And so John Doe's name will always be first if you use a social security number or if you use an EIN, because the EIN for sole proprietors is linked to the individual's name. And what I find that I bumped into quite a bit with banks is that there's this thought that if a sole proprietor has an EIN, that we're going to open it and we're going to title it Rolling in the Dough pizza and use the EIN. The IRS will not recognize that. They don't recognize Rolling in the Dough pizza. They recognize John Doe. So we always want to link on a sole proprietorship, John Doe's name with either his social security number or his EIN. Let's say he comes in a week later. So he's open Rolling in the Dough pizza. Now he wants to open Doe campgrounds, Doe campgrounds. So he's opened another business and he has employees. Does he have to apply for a new EIN? He does not. John Doe, just like you have one social security number, you have one EIN. It's linked to the individual. So he can have 10 DBAs. He will use exactly the same EIN because it's linked to him, not to the business. Okay, so I hope that helps. All right. And for partnerships, we're going to go into great detail later. We're always going to have an EIN. Corporations, always going to have an EIN. And for LLCs, we're going to have an EIN or social security number. We're going to detail about LLCs a little bit later today. Okay. All right, great. So we know that we have to have our customer certify their social security number or their EIN. They have to validate they're not subject to backup withholding. And that customer can either complete the W-9 from the IRS, or they can complete on your little signature card. There's an area down here where they verify they're not subject to backup withholding and verify their EIN. What I want us to understand, this is going to be real important when we get to LLCs this afternoon, okay? That the W-9 is the official form that the IRS issues where people certify this is my social security number or my EIN, and that I'm not subject to backup withholding. If a bank does not want to use that form, they can use a substitute W-9. And that's what this section is down here. It replicates the W-9. It's the same information on the W-9. It's just consolidated, so we don't have to use two pieces of paper. Some banks do both. They have the customer certify on the signature card, and they also have them certify on do a W-9. So if you want to do both, that's great. You don't have to, but that's going to be real important later today when we understand some things about the LLC as to why this is significant. So I'll get you educated a little bit later on today. And then for a non-US citizen who does not have a social security number, we're going to use a W-8, and then we'll use the W-8E for a foreign entity. Okay. All right. So in your manual, you're going to see, I don't have the page number. It's probably page, look here. It's probably page 23. Take a look at that form, okay? So this is a form that by the time we get done today, you're gonna realize that everything you need to know about what EIN or social to use is on this form. This comes from the IRS. I've printed it up, but it's from the W-9 instructions. We actually had this laminated at our desk so we could, when a customer says, where does it say that I have to use a social or have to use an EIN, this form will tell them that. And we can let them know this is from the IRS. We're not making it up, we're not trying to be difficult. I'm not going to say that to them, but that's really what we're trying to do, is say, I'm not trying to be difficult, but this is what the IRS says. So we're going to be referring to this as we go throughout the day. There are 5 options on here just for LLCs. There are 5 options on here just for trust accounts. So it's going to be a great resource for you by the time we get done today. Okay, let's kind of jump in there. Let's talk about the importance of business account documentation. Okay, so many new account associates really have no issue with requesting a driver's license from an individual. Okay, now when I started opening accounts many years ago, we didn't even ask for a driver's license. We did, but if they didn't have it, we could use their school ID, whatever. Today, of course, we have to have one. And asking for someone's social security number, that was not required back then. And customers could say it's an invasion of privacy. I'm not going to give it to you. Today, we'd have them arrested if they did that. Just kidding, but almost. Certainly wouldn't open the account. So we really don't have a lot of issue with saying, I need a copy of your driver's license. They expect that, or passport, or whatever, a military ID. But requesting documentation from a business customer can be intimidating. And those of you that are new, I know when I was opening new accounts, when I was in my 20s, it was very intimidating. Customers would say, I'm not giving you that. This is my favorite. I have never had a bank ask me for this. And I just would want to say to them, gosh, I wonder what else they were doing wrong. I mean, I'm sure it was fine. But obviously, we need to protect our organization. And so what I want you to walk out of here today knowing is that the documents we're going to talk about today are not optional, okay? They're required by law, all right? And so it is the driver's license for the business. You have to have a certificate of limited partnership if you're going to call yourself a limited partnership. So the question that I have that just popped up is, the customer's social security number is inaccurate on the account agreement. Is a new signed account agreement required? Absolutely, because the W-9 certification is not accurate. So we do need to change the social security number because they actually, I don't know if it was a typo or not, but if it was a typo, it's obviously our problem. Or they just gave it to us wrong. But yeah, they'll need to recertify that. So that's a great question. Okay, thank you. All right, so we understand now my goal today is for you to leave this session, especially for the new folks, or if you've been doing this for a long time, that we understand that what we're asking for is required by law. And so we can ask with confidence. And if the customer says, I've never had to, nobody's ever asked them before, I understand, but this really is to protect you, most importantly, and to protect our organization as well. So let me explain to you why we need it, okay? Okay, can we use the W-9 in lieu of the account agreement? You can. So you can use the W-9 if you want to use that to certify the EIN, or you can. So I don't know if this is related to the previous question, where we're saying, can we do the W-9 to fix this EIN? We do need the signature card to be accurate. We don't want to have an incorrect EIN in that document. But to kind of answer your question, Shelley, yeah, Sheila, some banks use the W-9. They don't use the section on the signature card. Some banks use both, and some just use the section on the account agreement. So it really is up to you. They're the same thing. Okay, no problem at all. And I have had some organizations who have said, we've just had problems with our account agreement where it's just not right. They don't sign in the right place. They didn't check it. Whatever the case may be. So yes, some banks are more comfortable using the actual W-9. So yeah, you can use that instead of the account agreement. Absolutely. Okay, so let's talk about, so there are a couple, we're going to talk about getting information from a public database. We're going to look at LARA website and that type of thing. But let's first of all talk about your in-house documentation, the account agreement, the signature card. Those are kind of the same thing in a lot of organizations. The account agreement is a signature card. We refer to it as both, or sometimes it's not the same thing. A resolution for a business account, the beneficial ownership form, your depository account documentation, that little shopping bag you're going to give them of documents, and the terms and conditions. Now, we're going to request first the documentation to validate the business. You're going to walk out of here today knowing exactly what documents you need for every type of business account that comes in. And then once I identify who has authority to authorize the account to be open, it's the members, it's the partners, it is a managing partner, it is a managing member. We'll look at all that today. We're going to then identify those individuals and all signers on the account. And then we're going to give them our in-house resolution, whereby this is where they authorize us to open this account. The resolution is the most important form that you will use when you open a new account. Okay, so the in-house document, the resolution, this is your permission slip. Okay, this is if a customer, if we are sued, if there are changes, they want to change signers on the account, this is how they do it. This is our authorization. And these are just examples of some of the resolutions that organizations use. So we're going to walk out of here again, understanding who signs where. Now, some banks use what we call a blanket resolution, where if I came into your bank and opened a corporate account, I would fill out a resolution, and some banks would use that resolution for every account the corporation opens. I do not encourage that. I like a resolution for each account that is opened, so that each one is tied to an account, because if the signers are not the same on all 10 accounts I open, and you have a blanket resolution, that's going to be a challenge. So we say, oh, well, for that account, we'll have a separate resolution. I think it just creates a lot of risk. And I like to have account resolution, account resolution, account resolution. And so let's talk about why. I mean, how easy is it to lose $100,000? It's pretty easy if we don't follow our procedures. So this account I opened for our customer, okay? And I do have a scenario for you, but just kind of in your manual, but just kind of watch me as I go through this, okay? So we had a good customer. You guys have good customers, right? We had Bob. He was a good customer. Everybody knew Bob. He was a great guy. He was the Lions Club. He was, he was a great guy. And so he was president of the corporation, and they had 6 accounts with our bank, 6 corporate accounts. Great customer. And he came into the bank and he wanted to open an account. Okay. So I have somebody asked, what about large municipalities that have 10 to 20 accounts, need a resolution for all 20? That's a little bit different. I know you understand a little bit different because typically, and we're going to talk about those public fund accounts later on today, they typically have a contract with the bank, and they're typically are not additional signers. There are specific people who can sign. So when we get a little bit later on to public funds, we'll address that. So I completely understand where you're coming from. Okay, thank you. Okay, so Bob was a good customer, came in the bank, wanted to open an account, no problem. And Chuck was his lender, senior vice president of the bank, and they were buddies and everything was great. So I was relatively new to new accounts, although I was writing all these policies and procedures for our bank, and we had quite a few we'd implemented. And one of them is that we have to have the signature card and the resolution back in the bank before we can open the account. Okay, before we even accept the deposit, okay, before we can open the account. So Bob came in and I said, great, no problem, we're opening the account. Everything's wonderful. He had a check for $100,000 payable to the corporation. And I said, so Mr. Bob, I've got everything ready to go, but what I am going to need is, we've got the corporate resolution here, and you're telling me you're going to be the only signer on the account, so you will sign this first page of our resolution. But what I am going to need is on the last page of the resolution, I will need the secretary of the corporation to sign, authorizing this account to be open. Now, she's not authorizing it, just as a side to you all. She's not authorizing it. She's just telling me that the board of directors have authorized the account to be open. So I need the secretary to attest that the board of directors have approved the account to be open. And then we'll need another attesting officer to verify the secretary's signature. So I go to hand him the resolution. He's like, wait a minute, this is ridiculous. We have 6 accounts with your bank. I will bring you the resolution. Go ahead and get the account open, take this deposit. I'll take it back to the office. I'll get it signed and I'll bring it back to you. So, well, I'm just so sorry, Mr. Bob, but we can't do that. We do need the resolution back in the bank before I can open the account. Well, that's ridiculous. So he gets it from my desk, storms across the lobby over to Chuck, senior vice president, and says, Chuck, I don't know what's going on. I don't know what's going on over here. But Susie over here in new accounts told me she's not going to open this account. We've got 6 accounts with your bank. If you don't open this account, the bank across the street would love to have this account plus our other 6. So Chuck gets up from his desk and storms across the lobby to my desk. And what does he say? What's going on over here? Open it. And I'm like, so Chuck, let me share with you what's happening here. We do need an authorization from the board of directors to open the account. Chuck, even though he's president, he cannot authorize us to open this account. Susie, this is ridiculous. Just open it. We're going to go. He'll bring us the secretary's signature. Don't worry about it. I said, well, I really can't do that. And so I said, I'm going to need for you to authorize the account opening without the secretary's signature and the attesting officer's signature. He signs off right there on that signature card. He signs off that we're going to go ahead and open it. So we do. We open the account. Bob, we deposit the check. Bob goes off, and 2 days later, Bob does a wire transfer. All the money is wired out of the account. And then on the next day, who comes in the bank? Steve. Steve came in the bank. Well, who the heck is Steve? Well, Steve was actually the new president of the corporation. And he wanted to meet Chuck. He'd heard a lot about him, and he wanted to meet Chuck. And the very simple question that he asked Chuck was this: show me where your bank had authority to open this account for our corporation. So we pull out our permission slip, which is our resolution. And he says, I'm really sorry to see that, because what I need for you to do today is credit our account, gave us the account with our $100,000, and you can go after Bob to get your $100,000. Is exactly what we had to do. Bob, in the meantime, was literally in Tahiti, toasting Chuck in the sunset, saying, thank you for falling for the good customer syndrome. So guys, it is tough. In new accounts, we are told what to do. Get this account open. We don't want to accept this guy. We don't want to upset this customer. Do you know who this is? And we do, but we also have policies to protect our bank and to protect the customer. So, ideally, everyone in the bank goes through this training. And ideally, we all are on the same page, because what Chuck should have done was come over to my desk and say, with Bob, I understand you're upset and I'm very sorry, but Susie is following our bank's procedure. And so we will need to get that resolution back. Not trying to be difficult at all, but we will need to get the resolution back before we can open the account. That's what he should have done. So we're all on the same page, instead of, and I know you've been there, you feel embarrassed, you feel humiliated, you know, you're told what to do and you know it's not right. I know. I've been there, and I bet all of you are going, been there, done that. Hopefully not, but it's not a good situation. And unfortunately, Chuck was fired. Who would have been fired if I'd not gotten that signature? Me. So if you're going to waive a policy, we're going to both agree you're waiving a policy, and I need for you to sign off on it, send me an email, however you want to do it. But I'm not going to do this until you authorize me to do it. Okay? Get a little intense there. I get it, guys. It's a little intense. Okay. So let's take with us then how we protect the bank. So we're going to talk about documentation outside the bank. So the inside documentation, this is going to tell us how we complete that documentation. So we're going to have assumed name filings, assumed name filing for sole proprietorships and general partnerships, and those are done on a county level. And then all the other businesses like LLCs and corporations and all the other business types, limited partnerships, they file on a state level through the Michigan Department of Licensing and Regulatory Affairs. We call that LARA. And Corporations, Securities and Commercial Licensing Bureau Corporations Division. So you can see why we just call it LARA. So that's where, and it is part of the Secretary of State, where we're actually going to have those documents filed. So if a corporation wants to do an assumed name, Training Resources Consulting LLC, I'm an LLC doing business as Rolling in the Dough Pizza, I would file in your state with LARA, that DBA. So yes, a business can also use a DBA. We're going to talk about certificates and articles and foreign entities as well. And then sometimes those documents from the state don't give us all the information we need, may not give us the names of all the members. It may not tell us who the managing member is. So we're going to have to then ask our customer to bring us partnership agreement or operating agreement, give us minutes, a charter, different types of agreements. So we'll talk about that as well. Now, there are two ways we can get documentation from our customer. Most banks, or I don't know about your bank, but some banks require the customer to bring them the documentation. I want you to bring me your county or your state required filing, bring it to me. Okay, that's one option. That's called documentary verification. A non-documentary verification is where you go online to the Secretary of State LARA website and you perform a search. And there's the information to do that. And so most banks, or a lot of banks, prefer to require the customer to bring it in. And then we can always go online and verify things, but if they don't have it, it's kind of like a little bit of a red flag. Why wouldn't you have the documentation for your business? Why wouldn't you have it? So we kind of like to make the customer bring it, and then we can go online and verify, or you can just verify online. It really is up to your organization. The county filing, we can't go online to verify, but this is a lot of words here. But basically, a person cannot do business under a name other than their own unless they file with the county, an assumed name filing. Okay. And so this is an example of one from Huron County, a certificate of assumed name. And then for our partnership, the general partnership, they'll file a certificate of co-partnership. So this is for two individuals that are just a partnership. The limited partnership is different. We'll talk about that later. But for a sole proprietorship and a general partnership, if they're using a name other than their own, so Suzette Jones Plumber is not an assumed name. I don't have to file this, but Jones Plumbing is. What Jones? Is there one Jones, two Jones, Susie Jones, Sally Jones? Who is the owner? So we can request they bring us these documents. And the nice thing about these two documents, it does tell us who the owners are. It's right there. It tells me exactly who the owners are. So for that co-partnership, the question is, do I need a copy of their partnership agreement? Maybe not. We'll talk about that. Okay. And then for a business using an assumed name, they're going to bring us their document from LARA. This is an assumed name filing. for a certificate of assumed names. That's for corporations, limited partnerships, LLCs, that will use that document to file an assumed name. Okay. All right. So I do want to clarify that a DBA cannot create an entity. So what do I mean by that? So we've got John Doe here, and John Doe has a business called John's Bakery. All right. So what John cannot do is file an assumed name with the county that says John Doe doing business as John's Bakery, Inc. You cannot make yourself a corporation or an LLC or limited partnership by adding it on to a DBA. You cannot do that. And I've seen it often. People don't realize that. They're going to add Inc. to make themselves sound a little bit more official than they really are. So you cannot create an entity with the DBA. And then we can also verify if a business is in good standing. We can verify management changes on the LARA website. So we can get a certificate, not to get a copy, but we can validate whether or not the business is in good standing by looking up the business on the LARA website. And these are called certificates of good standing. They're also called a certificate of status, or not canceled is also another form we'll see for limited partnerships. So we can, again, go online and verify that. And every year, those businesses have to file an annual report, and that indicates change in management or change in officers, okay? And if you have a co-partnership, they're going to have to amend their assumed name filing with the county. All right. So this is an example of a profit corporation's annual report, and can't see that real well, but it does indicate down here who the officers are. Okay. There's the president and the secretary. So I went onto the LARA website and I looked this up for Gary Imhoff. Okay, so I looked it up, and it indicates who the officers are for this particular this business. Okay, for a corporation. If a business is a foreign entity, in other words, a business that is outside of Michigan, if I come into your bank and I want to open an account because I'm doing business in Michigan, I have to notify the Secretary of State, hey, I'm an out-of-state business doing business in your state. And so this is called an application for certificate of authority to transact business in Michigan. Okay, so I've got to fill out that form. I've got to notify the Secretary of State that I'm here. They will, Michigan, LARA, they will go to the Texas Secretary of State website, or I will provide them with a copy of my good standing certificate from Texas. They want to make sure that I'm in good standing with my state. So we have a little bit of a help from the Secretary of State. If the business is filed with the Secretary of State with Michigan and they're a foreign entity, we get a little bit of help from the Secretary, from LARA, because they have validated that this entity is in good standing. Okay, here's an example of one that I looked up online. This is the Elkin Family Partnership, LLP. They're a foreign limited partnership. Right there, it tells me, okay? So this actually tells me this is actually an entity from Colorado if they came in to open an account with your bank. All right. Now let's kind of take a step back, and we're going to talk about for a few minutes. If anybody has any questions, feel free to jog them in the chat, and I'll take a look at them. But the primary areas of concern, what we're going to look at now for about 5 minutes, is something we're going to take with us with every business. And what I find a lot of people say is this really helps them understand, number one, why there's so many businesses. And number two, why I'm getting an EIN or why I'm getting a social security number. Okay, so if you start a business, and I'm going to be breaking up every account, every type of business we're talking about into two categories: the personal risk and the taxation. So on one side, if you were starting a business, one of the very first things that we think about is, well, what kind of risk is there? So if I am an artist and I paint, I probably don't have a lot of personal exposure with my business. So I might want to be either a sole proprietorship. If I have a partner, I could be a co-partner or general partnership, or I could be a limited partnership. Those three businesses expose the owners to 100% exposure. So if I get sued, they not only can take the assets of my business, but they can also take the assets of my personal assets. If I had a boat, my car, my ranch, my whatever the case may be. And so those three business entities, the sole proprietorship, the co-partnership, and the limited partnership, general partners and owners have 100% exposure. Compared to, let's say, I'm a doctor, or I'm an attorney, or I'm a consultant, like I do here. I want to limit my risk, okay? So the way that a business can put a wrapper of protection around the owner is by becoming a limited liability partnership, a limited liability company, or a corporation. And so what that does is, if I get sued as an LLC, the only assets that they have, that the suer has access to, are the assets of my company, not my personal assets. So as a business has more exposure, you'll see that they're going to be opening an LLC or an LLP or a corporation. So we'll go into more detail about that. The second side of that is, how complicated is it going to be from a tax perspective? Am I going to have to pay some CPA, $500,000 a year to do my taxes? Well, let's just talk about this for a minute, because this is an interesting concept that, again, we will take with us. Okay, so there are kind of two ways that a business can be taxed. So first of all, let's look at the left column here. Let's say that you and your best friend make cookies in your kitchen and you sell them. Okay, and so you're clicking along and you're just a little co-partnership and you're selling these cookies. And when it comes time to pay taxes, your partnership doesn't pay any taxes. You do. It's called flow through of income. So you add up all your income, and you guys did such a good job that you have $100,000 profit at the end of the year. So you're going to file a tax report. We'll talk about it in a minute. It's called a Schedule C. It's just a report that said, this is how much money we made. These are our expenses. Here's the net. But that net income, each of you will fill one out, one for partner A and one for partner B. You each will fill out a Schedule C, and that income, that net income of $50,000 each, is going to roll over to your 1040. Okay, so it's very simple. You're not double taxed. And so the two of you, you're really growing. My gosh, your business is getting so big, and you go, yeah, we're actually selling food. Maybe we do have some risk. So why don't we incorporate? So the two of you incorporate. Well, now as a corporation, it's a little different. A corporation does file a tax return, and it pays taxes on that $100,000. Okay, then if you distribute it to yourself as income, or you make a dividend distribution to the shareholders, the two of you, you will pay tax on it again. So corporations are taxed twice. So think about Amazon or Exxon or Google, these huge companies. Maybe you own their stock and you get paid a dividend. So all that income that they have, they pay taxes on. And then when they distribute it, the corporation does get a deduction, but the individuals pay tax on it again. So we're going, oh my gosh, we are two people. We're not going to pay double taxation. So the IRS says, okay, great. You don't have to because you're small. So if we have a small corporation, it is referred to as an S Corp. That S stands for small. And so what you all, the two of you can do is you can, so you're a corporation, you filed with Laura, you are a corporation to minimize your risk. But on the tax side, you're going to go to the IRS. And you're going to say, hey, IRS, we want to limit our taxation. So you file to become an S Corp. And what an S Corp means is that you don't pay double taxation. All the income flows through to the two shareholders, the two of you. So if a corporation is small enough, if it has 100 or less shareholders, it can apply with the IRS to become a C Corp. An S Corp. So I want to go back now. Remember our two sides here. We have managing risk and we have managing taxes. For a corporation, no matter how big it is, they will file with Laura to be authorized to be a corporation. Then on another page, they will go to the IRS and they will apply for the S Corp election. So you're opening, if I come in and say to you, I'm an S Corp, yay, I don't really care. I can check S Corp on my application, but we really don't care. This is a C Corp that has made the election with the IRS to be an S Corp. Okay, so that's an IRS election. So this is the form. We're never going to see this form, but I just want to show you how easy it is for a C Corp to apply to become an S corp. Okay, so great. If you're an S corp, that just means that's a tax decision. It is not a regulatory state mandated decision. Laura doesn't care. Secretary of State has no record that you're an S corp. They do not care. So I'm not really quite sure why we even have S corp on our application, because we really don't care. But you can check S corp, but you're still opening it the same documentation you would for a corporation. Okay, so let's kind of walk through just real quickly. You're a sole proprietor. You do flower arrangements, you sell flower arrangements, you do parties and things like that. End of the year, you've got $50,000 in income. So you're going to fill out a Schedule C. And so this says profit and loss from a business. You're going to put all your income there. You're going to put all your expenses, and you're going to have your net income. This is not filing taxes. This is just a report that you're going to attach to your tax return, your 1040. It's just a schedule. Then you will take that $50,000 in income and you're going to put it on Schedule 1 that attaches to your 1040. Okay, so you'll see here on line 3, business income, Schedule C. We're not going to see these form guys, but I'm going to be talking about Schedule C's later. So we need to understand it's very, very simple for a business who is a sole proprietor to file a tax return. For a partnership, it's very similar as well. A little bit later, we're going to talk about partnerships, but a partnership files a 1065. It is a tax return, but it does not pay income. So a partnership says, here's my income, here's my expenses, here's my net income, $100,000, $50,000 to each of you. Okay. And so what happens is the partnership then completes a K1, and the K1 goes to each partner. So it's $50,000 each. The partner will then take that K1 to their personal tax return and say, I got $50,000 in income from my partnership, and it goes on to the 1040. So again, I just want us to understand that the business, setting up a business, it's a pretty serious decision. Am I going to be a partnership? Am I going to be a sole proprietorship? Am I going to be a corporation? But we're going to be talking about this a little bit later. Okay, great. So let's kind of take that with us and understand that the two key considerations when opening a business is managing risk and ease of taxation. So let's talk about the sole proprietorship first. Okay, so sole proprietorship we know is a pretty simple business. It's one person, they're doing business. The IRS, though, says you're not really a business. You are not a separate business from yourself. So let's just stop for a minute. From a risk perspective, you are a sole proprietor, and all the risk is on you. You have 100% exposure. From a tax perspective, the IRS says, we're going to disregard you. Great that you are rolling in the dough plumbing. Good for you. Everything is taxed to you as an individual. So you're going to file a Schedule C. You're going to tell us how much money you made, but you're going to pay the taxes when you file your 1040. Okay. So the owner has 100% liability, and all the income is taxable to them as well. So we got a sole proprietor, one person, and they can have authorized signers on the account as well. Okay. Now, let's talk about a husband and wife. Let's talk about a couple who own a business together. Okay. Let me kind of jump ahead here for a second. Okay, I'm going to go back to those in just as well. Let me just do this. Okay, so if you have a husband and wife and they want to open an account, this is where we bump into a little bit of I call it kind of confusion. They both work in the business. They are both owners. And so often what happens is one spouse files a Schedule C for both of them. Okay, so they come in the bank and they put the husband on as the owner, and the wife is put on as an authorized signer. Later today, we will talk about what if they want to put her on as a POD beneficiary. I will address that a little bit later today when we talk about payable on death accounts. But they want to put her on just as a signer. Now, what does that mean? So what happens if the husband passes away? So if the wife is on the account as an authorized signer and not designated as an owner, at the owner's death, we're going to remove all authorized signers. She's not going to have access to the account. We're going to freeze the account, and we're going to wait for the estate representative, executor, administrator, whatever the case may be. Excuse me. But if that wife is a co-owner, then we're allowed to continue for her to have access to the account. Also, the other issue, excuse me, let me just mute you guys for a second while I kind of clear my throat here. Just a minute. Also, one of the issues with the husband and wife, and you're not going to discuss this with them, but just so that you know, because I had a banker in one of my classes say that was me and my husband. So if only one spouse is designated as the owner and only one spouse completes the Schedule C, that one spouse is getting credit for Social Security and Medicare, not the other working spouse. And so the other spouse, even though working, gets no credit. Now, if they stay married for 10 years or more, then she could eventually file on his benefits. Okay, eventually she could file on his benefits. But if they're not married for 10 years, she cannot. So it's just significant. And this banker said, my husband and I worked in the business. We had, we both worked in the business. We both, worked hard in the business, but we filed one Schedule C for him. We were married for 8 years and she had no credit then whatsoever for Medicare and Social Security. So what about opening an account for married sole proprietors? So in your manual, there is a description that talks about how a married couple, that the IRS does allow them, married couples, to be what's called a qualified joint venture. So if you have a business and it's just a married couple, husband and wife, just a married couple, does not have to be a man and a woman. Just want to clarify that, but you have a married couple, and the married couple works in the business. Then you actually can open the account as a sole proprietorship account. And you can, if you want to, you can use one spouse's name, John Doe, DBA Doe Plumbing. You could use both of their names if your system allows that. But we want, and if both are going to be signers on the account, they both will sign the signature card. But here's the main thing. On the resolution, we want both of them to sign as owners. We want both of them to be reflected as owners if both of them are. And so for TIN purpose, use one of the spouse's Social Security number. If they have an EIN, use whichever spouse applied for the EIN, use their name on the account. And so presumably, they have employees, that's why they have an EIN, but one of the spouses applied for that EIN and it's in one of the spouse's names, not the business name, okay? So we're going to title the account, John Doe DBA Whitewater Rafting. Again, if a married couple chooses, we could put both of their names or one of their names, but we are still going to indicate, that it is a sole proprietorship. So, do not enter only the name of the business in the account title. We talked about that earlier because for TIN purposes, if they have an EIN, it's attached to the individual. Either use the Social Security number or use the EIN, but title it with John Doe DBA. Okay. And so here we have sole proprietorship. Use the owner's Social Security number. Okay. On that form, we look back on page, I think, 22. Okay. So now, the documentation, we're going to ask for a trade name certificate, a DBA, and here's an example of it. Okay. So if we have a husband and wife, a married couple who are the sole owners of the business. Okay. There is an indication here. We can put both their names on it. Okay. So this is a certificate of assumed name. It doesn't say a certificate of sole proprietorship, just certificate of assumed name, but they're not a partnership. Okay, so they are a sole proprietorship in your state. In every state, the IRS says that a married couple, even though there are two of them, do not have to be a partnership. They can each file a Schedule C. They don't have to file a partnership tax return. They can each file a Schedule C, divvying up the profits. They each get credit for Social Security and Medicare. So on their certificate of assumed name, there is a place there to put both of their names. That's what we would prefer if they're telling us that they're both owners. Okay, and then it'll be signed, and they'll both sign signature of all persons listed above. So it does allow more than one person on that assumed name filing. Okay, so they do not have to be a partnership. And so we're gonna have them complete the resolution. And so let's just kind of walk through the resolution. let's kind of look at, I'm going to look at an example of the Walters Kluwer's resolution. And yours may look different than this, but at the end of the day, this is the deal. They're going to attest they are, or this person is the owner of the business. I, Susie Jones, or I, Susie Jones and Randy Jones, certify we're the owners of the business. Whoever's going to be a signer on the account signs here. But then the most important thing we're going to do is we're going to ask the owner, look at this, says certification of authority. Okay, so this is where the owners certify that they are authorizing the account to be open. That's the most important part of this document. Okay, and so certification of authority, they're actually going to sign here authorizing the account to be opened, either one person or the two. All right. And then let's just talk about a couple of things. We'll take a break here in just a couple of minutes. So can a sole proprietor add a POD beneficiary? I'm going to walk through this quickly because I actually would rather wait until we get to the POD. But there are some issues with this, okay? And they really have to do with the fact that a POD account is a revocable trust account. And so if a beneficiary, though, comes in the bank and wipes out the account, it may leave no money to pay bills or pay for payroll for employees, or if there is withholding in this account, it's not submitted to the IRS, huge problem for the estate. And so unless the customer tells their family it's a POD account, they may not know. But for us, operationally, I think it just creates some issues. And that is that our new people that are in banking may say, well, if a sole proprietorship could add a POD, then why can't a sole member LLC? And they may actually allow someone to do that. Sole member LLC cannot. Most importantly, it does override the customer's will. They may not understand that. And it does not leave the business to the beneficiary, it just leaves the money in the account to the beneficiary. So we'll talk more about that a little bit later on this afternoon, but I really do not encourage you to allow a POD beneficiary to be added. Okay, all right. So now let's just wrap up with a couple of things. Is it okay to cash checks payable to a business, a sole proprietorship? Is it okay to allow them to deposit checks in their personal account? I wish I could be in the room and ask how many of you allow sole proprietors to cash checks. And this is where I get a little bit of the Betty syndrome, where we've always allowed these businesses to cash checks. They're good customers, but that is really sort of coming to an end. I think there are some regulations looming that do require us to report checks that are cashed to businesses, okay? Because here's the risk. How do you track that? All right. So tracking cash checks activity can be difficult. Some banks it's not. If the individual has an account with us, hopefully, and it's tagged to that account. But here's the deal. If you have a husband and wife and they have that sole proprietorship, and he's coming in every Friday and cashing checks payable to the business, and the wife doesn't know it, and they get divorced, and but her attorney contacts the bank and says, we want all activity on this sole proprietorship account. We want to know every check he's cashed the last 5 years. We may not have that information. Okay, so we're also possibly enabling the check casher to commit tax fraud. They're not reporting this as income, embezzlement, or even money laundering. So frontline personnel become responsible. So anybody ever been a teller in the drive-through? I have. You got that microphone, and this individual runs a check through, and it's for $500 payable to an entity, Doe Plumbing. And so the teller has to know we only cash checks for sole proprietors. So she says, by the way, it's Friday afternoon, payday. Cars lined all the way up to the end of the block, and he's in the very last line. And you say to him, Mr. Doe, are you a sole proprietor? And he goes, yeah, or I don't know, yeah. Well, we only cash check for sole proprietorship. So you were sole proprietor? Sure, yeah, sure I am. So the great thing about the drive-in is you can turn the microphone off, turn around and go, oh my gosh, somebody help me. What's going on here? So it's just not a good idea to allow individuals to cash checks payable to businesses for the more serious reasons of embezzlement, fraud, tax evasion. Tax avoidance is legal, tax evasion is not. So I strongly encourage you not to allow your customers to cash checks payable to their business. Okay. All righty. I have in your manual a little sample of a check cashing form and a big description of that in your manual. If we are going to let people cash checks, let's make them sign this form every single time, which hopefully will be enough to discourage them and have them just deposit it into their account. But this basically says, this is the amount of the check. I am still the sole owner of this business, and I indemnify the bank and hold it harmless for cashing this check. And I understand if the bank, and so you have a copy of this, take a copy of the check, put it in the file. So when you are notified by the IRS or by the attorney for that spouse, you can give them copies of all of this, okay? It's a hassle. Just make them deposit in their account, okay? That would be ideal. All right, so why don't we take about a 10-minute break? I've got 10:20 your time. Let's take a break until 10:30. We'll come back. If you have any questions, feel free to put them in the chat. Thank you. I'll see you in a couple of minutes. All right, let's go ahead and jump back in. Any questions anybody want to ask before we jump back in? So the stuff we've covered so far this morning has been, I think, relatively simple. We've kind of gotten the foundation now of kind of how businesses are taxed and sort of what the risk is and that type of thing. So now we're going to jump into some of the more complicated scenarios. And so when we talk about a partnership, as a business grows, so does the tax liability, the business disruption, the complexity of transferring ownership, and probably most importantly, the personal exposure. So if we had those two individuals that were baking cookies in their kitchen and kind of selling them in the neighborhood, that's one thing. But as a business grows, so does that personal risk. So let's just kind of talk about sort of the three different partnership options. We have the general partnership, or excuse me, the co-partnership. We have the limited partnership, and we have the limited liability partnership. Let's talk about each one of those and sort of how they sort of grow in complexity. So let's go back to our individuals who are baking cookies. They have a co-partnership, they both control the business, and they have 100% personal liability. Things are clicking along, everything's great, and they decide they'd like to grow their business. So they come to all of us and they say, would you all like to invest in our business? And we say, absolutely. But we don't want the same kind of risk you have. We want to limit our risk. So our little co-partnership folks go from a co-partnership to a limited partnership. So the co-partnership we know filed with the county, and now as a limited partnership, they're going to file with Laura, with the state. So what's a limited partnership? So our two partners, the two bakers, they control the business and they still have 100% personal exposure. They bring us on and they say, would you be interested in investing $10,000 each into our business? And we say, yeah, but I want to be limited to $10,000 risk. So we become limited partners. So we have no management control, no management responsibility, but we do share in the financial risk up to $10,000. So if the business fails, we'll be accountable for $10,000 each. The general partners are accountable personally for everything else. So our partners say, this isn't feeling real good. Our co-partners, our general partners saying, this isn't feeling real good. We want to limit our personal risk. So as a co-partnership, a general partnership, or a limited partnership, what they can do is they can go to the Secretary of State and they can become a limited liability partnership. So any partnership can register as an LLP, and the partners maintain the control, excuse me, and limit their personal liability from the debt and liabilities of the partnership and the negligence of other partners. So if our cookie bakers, if they didn't want to do a limited partnership, they could just, as a co-partnership, register with the Secretary of State as an LLP and put that wrapper of protection around themselves. So this helps us understand why people might not want to be a co-partnership, why they might not want to be a limited partnership. You might be opening more LLPs than you have in the past, but you're opening more LLCs, and we'll talk about how is that different. But from the perspective of a partnership, those are our three choices. Let's kind of look at each one of those separately, because there's a separate section in your manual for each one of them. But first of all, I want to talk about what is a managing partner. Let's go back to our partnership here. If we had a co-partnership that had 20 partners, and they're just kind of, they're all artists. We've got, 20 artists, and I use artists. My daughter's an artist. There's not a lot of personal risk when you're painting or making art, because there's not a lot of personal exposure. Let's say we have 20 artists who come together to form a co-partnership. Those individuals decide, it's a real hassle. Every time we open a bank account, for all 20 of us have to go in and sign the resolution to authorize the account to be open. So we're going to appoint a managing partner. So we're going to appoint a managing partner. We're going to make Teresa that managing partner. I see Teresa's name here on the board, and we're going to make her the managing partner. So whenever we open a bank account, she'll be the one to go in and open the account, and she's going to be the individual. We're going to authorize her to act alone. and she'd be responsible for opening the account. And the same thing for a limited partnership. If they have 20 limited general partners and 100 limited partners, we don't really care about the limited partners, but they have 100 limited partners, general partners, they also could appoint a managing partner, and the LLP can do the same thing. So they kind of appoint this person as the financial person who's going to be responsible for opening bank accounts and entering the partnership into contracts. Okay. So the question is, can the managing partner sign the resolution alone as well? And yes, they can. Great question that popped up here is yes, they can sign. As a matter of fact, they would be the only one who would have to sign the resolution. They could also be the only signer on the account. But one of the things that we're going to want to do is make sure that they're authorized to sign alone. So when we look at the documentation that is provided to us for co-partnerships, limited partnerships, an LLP, it does not tell us who the managing partner is from the perspective of what's filed with the county or with Laura. It doesn't tell us who the managing partner is. We would have to get a copy of their partnership agreement telling us who the managing partner is and can they act alone. Okay. So let's talk about the co-partnership just real quickly, because it's really pretty easy. We know that a co-partnership is a partnership between two or more people. Okay, keyword, two or more people, and that the owners have personal responsibility. We know that all the income is going to flow through to their personal tax return, and they can appoint a managing partner to act on behalf of all the partners. So the owners are the co-partners. That is our responsible, looking for the responsible parties. Who are the partners? We either need to have all of them come in and sign the resolution, or that last page where they're authorizing the account to be open, or get the name of the managing partner. I'm going to title the account just Whitewater Rafting. It could be Whitewater Rafting, a Michigan general partnership or a Michigan co-partnership, but it's just going to be in the name of the business. The owners will not be in the account title because the partnership will have an EIN. We're not going to use the social security number of any partner. They have to have an EIN. And so we're going to get a certificate of co-partnership, which we know is filed with the county clerk in all the counties in which they're doing business. And that does require all the owners to be listed, which is pretty nice. So generally, partnerships, I want to emphasize this, are not required by law to have a partnership agreement. Hopefully most do, because it's really helpful if one of the partners dies and that type of thing, but they're not required by law to have a partnership agreement. And so, but if they do appoint a managing partner, we do need something in writing from all the partners telling us that, that Teresa is the managing partner and Teresa can sign a loan. Okay. And so here's the certificate of co-partnership. It does ask for the name and the address of all the co-partners. If they have to attach another sheet to that, use the reverse side for additional co-partners. And so it does give us the name of the partnership, and it does tell us who all the partners are, which is great. Okay. And then we're going to have them complete the resolution. So on the first page, it's going to list all the general partners. Okay. All the general partners of this co-partnership. And whoever's going to be a signer on the account is going to sign here. And then there's also this page on the resolution that limits the authority of any particular partner. Maybe they don't want all the partners to be able to borrow on behalf of the partnership. Maybe they just want this individual to be able to, deposit checks, endorse checks, and open accounts. So we need to make sure that the activity is listed there. And then we either need all the partners to sign that certificate of authority or the managing partner. Okay. All righty. So changing signers, I'll just quickly go through that. If the individual we are removing from the account is not a partner, they're just an individual, any authorized signer can be deleted without their permission. Although we need a new resolution, new signature card. Although a partner cannot be removed without their permission, or documentation amended indicating they're no longer a partner. So if we have a co-partner, they're going to remove a partner, they need to amend their certificate, their trade name registration with the county to remove that individual. Okay. let's talk about limited partnerships. So what's a limited partnership? So I was very confused when I started in banking with a limited partnership because it's called a limited partnership, but limited partners have no authority. They are just investors in the business. We're always going to deal with general partners, whether it's a co-partnership or a limited partnership, we're always dealing with general partners. And so who are the general partners? They control and manage the business, and they have personal liability. The limited partners, as I said a few minutes ago, they're just investors. As a matter of fact, if a limited partner starts dabbling in managing the business and signing on bank accounts and that type of thing, the IRS may say, and the state may say, you're not a limited partner, you're a general partner because you are involved in the management of the business. Your limited liability has been removed, not just $10,000, you've got 100% personal exposure as well. So rarely do we see limited partners sign on accounts, okay? And I do also want to point out that you can have one general partner. The co-partnership has to have at least 2 partners, but a limited partnership can have just one general partner and one limited partner, or it can have 100 general partners and 100 limited partners, but it'll be opened with 1 or 2 or 3 general partners. And so the management, the general partners, or they might appoint a managing partner. We're going to title the account Whitewater Rafting Limited Partnership, or LP. And then we're going to use the partnership's EIN. Now we've moved from the county to the state level. And so a limited partnership files with Laura and they get a certificate of limited partnership. And the general and limited partners are listed on the filing document. We don't really care about the limited partners, but the general partners are listed. And so if they have a managing partner, we would need a copy of the partnership agreement. But if they don't, it's really up to your bank. Do we really need a copy of the partnership agreement? I need to know who has authority to enter this business into contracts, and it's the general partners. And so they're listed on the partnership, they're listed on the certificate of limited partnership. But if they say, no, we have a managing partner, then I am going to need a copy of their partnership agreement to verify who that managing partner is. So here's a sample of the certificate of limited partnership used for domestic limited partnerships, not foreign. Okay, and so here's the name of the partnership, what they do, the name and address of the limited partnership, and then also, let's see, where does it ask for the partners' names? The right, the limited, and then it's coming up here, I'm sure. So on this last page here we have, it indicates where we're going to be listing, they're going to list all the partners. So it's going to have the type of partner, we're looking for the general partners, we don't care about the limited partners, and they're going to list all the partners, okay? So this goes up to, they can add as many pages as they need to. And what I also like about that is the partner has to sign. So it's awesome, 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 the certificate of limited partnership, okay? Then we're going to list all the general partners here on the front of our resolution. Whoever's going to be a signer will sign on the account. And then we're going to have either all the partners sign the authorization, or we're going to have just the managing partner if they can sign alone. Okay, so again, managing partner is not listed on our certificate, and so we are going to need the partnership agreement to tell us who the managing partner is and they can act alone. Okay, great. Now let's talk. So removing a partner, we can always remove an authorized signer on a limited partnership. We're going to have a new resolution, new signature card signed. And if a partner is being removed or added, we need amended documentation from the Secretary of State reflecting this change. This individual has been removed as a partner. And then we will have a new resolution and a new signature card. We're also going to need a new beneficial ownership form, possibly completed if the beneficial ownership changes because of either added or removed a partner from the account. We'll need an updated one. Okay. All right. So the limited liability partnership, what is that? As we talked about a few minutes ago, it's where the general partnership or the limited partnership says, we don't like this 100% personal risk. We want to limit our liability. So it's called a limited liability partnership. Pretty clever, huh? And so they're going to register with Laura. So that co-partnership, I apologize, I'm using co-partnership and general partnership interchangeably. The co-partnership and the limited partnership will register with Laura to become an LLP, and the general partners are the owners and they manage the LLP, or they can appoint a managing partner. Same song, second verse. Actually, the co-partnership and the limited partnership don't really change. They are just registering with Laura to get that wrapper of protection around the partners. So we're going to title the account Whitewater Rafting LLP or limited liability partnership, and we're going to use the partnership's EIN. They will not get a different EIN. They're going to use the same EIN they had before. The co-partnership's going to use their EIN, and so is the general partnership, the limited partnership. They're going to use the same EIN. It just becomes the EIN for the LLP. Okay, and so they're going to fill out an application to register as an LLP. Now that document doesn't really tell us much. So if I come into your bank and I want to have no other accounts with you, I want to open an LLP. That simply is where a co-partnership or a limited partnership has registered to protect their partners. The underlying partnership still exists. So we're going to ask for their application to register for an LLP, and we're going to ask if they were a co-partnership for their assumed name filing with the county. If they were a limited partnership, their certificate of LP. So this is what that's going to look like. Here is the application that they're going to bring us, the application, and you can see that it does not list all the partners. It just lists the name of the underlying entity, Doe Plumbing, that was a co-partnership, or Doe Plumbing Limited Partnership. So it does indicate the name of the business, okay? But then we'll ask them, so we're going to ask for that form, that application to register as an LLP. If they were a co-partnership, I also need their trade name, their certificate of co-partnership. If they were a limited partnership, I also need their certificate of limited partnership, because those two entities still exist. They just now have an umbrella or a wrapper around them that protects their general partners from personal liability. So that's the documentation that we need for an LLP. All right, great. Okay, and so here's an example of one, domestic limited liability partnership. There's an example of it. And I asked for all filings, and I looked at the application, and that's what it looks like. Here's the name of the business, and it indicates, one person signed. Doesn't tell me who the partners are, so I still would need that underlying documentation. Okay, and then same thing for our resolution. Going to list all the partners. Anybody who's going to be a signer of the account will sign down here, and then either all the partners will sign, or they will have a managing partner. So we're kind of clicking along here, kind of hopefully it's all making sense. Okay, any questions about any of those so far? Let me just open up the chat, or feel free to ask me any questions at this point, because now we're going to get into the LLC, which is probably why you're here. The LLC, and I'll just kind of watch for the chat if there are any questions. So the LLC, I am an LLC. And so let me just kind of share with you why people love LLCs. And I'm going to take you back to when I worked for a bank back in 1972 to 1976. And I left that company in 1976, that bank, to start a training company, because I felt like there was a lot of need for training in new accounts. And so I started that company in 1976. LLCs were not available. So I became a single member corporation. Didn't want to be a sole proprietorship because of the personal exposure. It was only me, so I couldn't be a partnership. And so I established a sole person corporation. So at that time, it is a formal entity. It did have a wrapper of protection around me. You are required, if you have a corporation, to have board meetings. So I'd have to have an annual board meeting by myself. I'd have to take minutes of my meeting by myself. At that time, I did take advantage of the S Corp. So I was a corporation that I filed with the Secretary of State. Then I went over here to the IRS and I said, it's just me. I don't want to pay double taxation. So I filed an S election. So I was a corporate to manage my taxes. So from the risk side, I was a C Corp. From the tax side, I was an S Corp. And I had that shield of protection around myself and did not have double taxation. Okay, so then I went to work. I had that company for 18 years, went to work for a bank for 22 years, retired, came out of retirement to start this company. And now I started as an LLC. Why didn't I just become a sole member corporation again? Because LLCs are less formal. They do not require meetings. They do not require minutes. And the flow through of income is also available. So we're going to see in just a minute that the tax filing is very simple for LLCs. And so, but the most important thing is the members have that shield of protection around themselves. So that's why we're seeing more and more LLCs. LLCs are managed by members, kind of parallel to partners of a partnership. LLCs have members, and they can either be member managed, just like a partnership can be partner managed, manager. It can be, we can have a managing partner. We can have a member managed LLC. So you are required to have at least one member of an LLC, just like a corporation can have one member. Okay. So, and a limited partnership can have one partner. So an LLC is member managed, and it can either be member managed or manager managed. That's the first thing we need to find out. Is this LLC member managed or manager managed? Okay. And members can appoint a manager to represent all the members. Exactly the same thing as a managing partner. It's just a managing member, okay? So there are three types, there are three ways that an LLC can be owned, okay? One is as a single member LLC. And so it's one person, they're one member. Now the IRS, so let's just stop here for a minute. From a risk perspective, a single member LLC goes to Laura and they fill out all the same paperwork any other LLC would. They're just a single member LLC. So they are an entity, a legal entity with the state, and that's what they are. They're an LLC. But from the IRS perspective, the IRS says, good for you that you're an LLC and you filed with the state, but we're going to disregard that from a tax perspective, because you're just one person. So you're actually going to file a Schedule C just like a sole proprietor. So all your income is going to flow through to your personal tax return. So the IRS says, good, you're an LLC. So from a legal perspective, from a protection perspective, that single member has a wrapper protection around them because they are an LLC. They have managed their risk. From a tax perspective, it's very simple. It just flows through to their personal tax return by completing a Schedule C. A multi-member LLC is more than one person. This is me and my husband. We are a multi-member LLC, 2 members, okay? And if there's more than one member, the members can be individuals. It can be entities. You can have a corporation and a limited partnership be the members of a multi-member LLC. But when my husband and I go to file our taxes, the IRS says, great, you've gone to the IRS, you filed with the IRS, you've gone to the state, you filed as an LLC, you have the wrapper protection around you, you are an entity. But from a tax perspective, we're going to tax you as a partnership, okay? Because there's more than one of you. So we're going to tax you as a partnership. And so therefore you'll do a partnership tax return. So what I've just told you is that when LLCs were created by the states, and we look at for the risk management, they wanted to allow business owners to not have personal exposure. You don't have to be a sole proprietorship. You don't have to be a partnership. You can be an LLC and get that wrapper protection around you. But from a tax perspective, the IRS said, we are not going to create an LLC tax return. We're going to tax these businesses the way they're owned. If they're owned by one person, we're going to tax them like a sole proprietor. We're going to disregard the entity for tax purposes, and they will complete a Schedule C. If it's a multi-member LLC like me and my husband, great. You can file with the Secretary of State. You can get that protection, but you're going to complete a partnership tax return. Now, that sounds great. Got it, Susie. But what about when you have a single member LLC that's not owned by an individual? Have you ever had that happen? Where a company comes in, they want to open an account, and you have a LLC that is owned by a corporation. It's a single member LLC, not owned by an individual. So why would somebody want to do that? Okay, remember I talked about managing risk? So we have this corporation, and the corporation makes seat belts, and the corporation has $1 million in equipment that they want to protect. So what they do is they set up an LLC down here, and this LLC makes all the seat belts, they do the marketing, they manufacture the seat belts using the corporation's equipment, okay? So the corporation has a wrapper around it, and the LLC has a wrapper around it. They are two separate entities. And so the seatbelts don't work. And so XYZ, the LLC, gets sued. And the deal is that when the LLC is sued, they're going to get the assets of the LLC. And there aren't any, because all the equipment that's being used to make these seatbelts is owned by the corporation. And so it's called managing risk. A lot of us may be familiar with the term asset protection. That's what this is. It's a way to manage the risk, to protect their assets. So you've got a corporation, you got an LLC that have filed with the Secretary of State, even though the LLC is owned by the corporation. Okay. Now, what about taxes? This is going to be a real important concept for us to get here. So you've got this LLC that is owned by a corporation. Now, what the corporation can do from a tax perspective is they can disregard the LLC for tax purposes. So what the corporation can do is what the corporation says is what we're going to do is we're going to file one tax return for both of us. So we're going to take all the expenses and all the income of the LLC and roll it up to the corporation and file one tax return for the two of us. So they disregarded it. So if that's the case, if the LLC is not filing a tax return, it does not need an EIN. It will use the corporation's EIN. However, if the corporation says, I'm going to file a tax return and we're going to separate out this LLC and having them file their own tax return, then the LLC will have its own EIN. Okay, so if ABC Inc. files one tax return for themselves and the LLC, called disregarding for tax purposes, would not disregard for risk purposes, want them separate, but for taxes, they're going to commingle their income and their expenses and file one tax return. Okay, so that's going to impact us when we're opening this account. Are we going to use the corporation's EIN, or are we going to use the LLC's EIN? Okay. So the types of LLCs, there is a domestic LLC. So what we've just talked about is how LLCs are owned. Is it owned by an individual? Is it owned by more than one person? Or is it owned by a non-person? Okay, but there are different types of LLCs. So Susie, if I'm just one person, I'd be a domestic LLC owned by one person. It also could be a domestic LLC owned by two people. You could have a multi-member domestic LLC. Or you can have a professional LLC that's owned by professionals. And a lot of professionals set up LLCs, medical practitioners or architects, engineers. So you can have one person who's a single member LLC that is a PLLC. When they go to file with Laura, they're going to file as a single member LLC, as a professional LLC. And now you also have what's called a series LLC. I don't want to lose you here. Hang on with me. And I'd love to see if you could put in the chat, has anyone ever opened a series LLC? If you have, you'll know what I'm talking about. Anybody ever opened a series LLC? Yes. Anybody in the chat? Okay, I see one little lonely person out there. Yes. Anybody else ever opened a series LLC? Michael, no. Okay. Sheila, what I'm excited about is you're still at the bank. You didn't quit. That's good news. Okay, so we can survive this. Okay, let's talk about what it is, because like Sheila, you will bump into it. So a series LLC is where the most important characteristic of a series LLC is the liability protection of each series. Let me kind of walk you through an example. Let's say that we have a LLC, and we'll call it the master LLC or the parent LLC that owns 10 buildings. Okay, so it's an LLC and it owns 10 buildings. So these 10 buildings. And building number 2, what the series does is it separates each building with a little blanket of protection around each one of them. So I've got these 10 buildings, and each building is separated from all the other buildings in the series. And building number 2 catches on fire, people are hurt, property is damaged, and the potential litigation and the risk, though, because it's a series, is contained in building number 2. And so the risk does not spread to the other buildings in this series. So we've got the master LLC, and then we have series number 1, number 2, number 3, number 4. It could have its own name, California series, a New York series. They can name their series anything they want to. But in our example, we've got 10 series. So this is managing risk. So the LLC has 10 buildings, and they manage their risk by putting each building in its own series. Now, do they have to file 11? Got a question here? This would be perfect for property owners or multiple properties. Exactly right. If you're an owner and you've got 15 rental properties, you could put each one in a series without having to set up, 10 corporations or 10 separate LLCs. You can have the master and then have the underlying entities that are protected, okay, from each other. Now, what about taxes? Are they going to have to file all these tax returns? Remember a few minutes ago, we kind of talked about the concept of disregarding for tax purposes. And what this does, guys, is it kind of plugs into us what EIN we're going to use, okay? So we have this master LLC. And the master LLC, what they can do for tax purposes, they can disregard all 10 of these buildings. They can have all the income roll up to the master LLC, okay? Roll up to the master LLC, all the income, and the master LLC will file one tax return for all 11 entities. And so if they do that, then obviously these series LLC, they're not filing tax returns. They do not need an EIN. So when we open this account, we're going to open each series. In a minute, I'm going to show you how to title that account so this will work. You're going to use the master LLC's EIN because they didn't disregard them. They disregarded them for tax purpose. They did not want to file 11 tax returns. And this is the IRS's default. The IRS assumes they're going to default to filing one tax return through the master. If they do not disregard these 10 buildings for tax purposes, then each series will have its own EIN and the master will have theirs. So when I come in to open an account, your question is the LLC set up differently with Laura? The LLC series, what they do is they set up the master LLC and then they indicate that they have series. And we'll look at that in just a couple of minutes. So it is set up differently with Laura in that they have to indicate that they have series LLC. So that's the risk side. Absolutely. We're going to set up the master LLC. We're going to set up each series and tell the state with Laura that we have these LLCs, or from a tax perspective with the IRS, we can either do one tax return. And when I open the bank accounts, I'm going to use the master LLC's EIN, or when I open these 11 accounts, each LLC will have its own EIN. And let me ask the individual that opened the series LLC, did they have one EIN, or did each series have its own EIN, and how many were in the series? Do you remember? So my question is, did they disregard the series for tax purposes and have one EIN, or did they not disregard and each series had its own EIN? If you remember, Sheila, let us know. That'd be great. Because in my classes, I've had individuals say, Susie, one woman said we opened 40 series. We opened the master series. There were 40 businesses in the series, and they used the same EIN for all 40 of them. And again, in a minute, I'll show you how to just one EIN. Great. There were 3 in the series. Love that. Thank you, Sheila. And so now we understand why we were using the same EIN, the master EIN, because for tax purpose, they were simplifying it. Everything rolled up to the master and they filed one tax return. Okay. Fantastic. Hope this is all making sense, guys. All right. So, and page 79 just walks you through what I just said, is that if they disregard the entity, the IRS, remember the IRS, when LLCs were created, the IRS said, good for the states, they'd created an LLC to minimize risk for the owners. We're not doing a LLC tax return. We're going to tax the entity as it is owned. And so if it's owned so here's the deal. We have to ask the customer how they're taxed. So why? And it's just so silly because we don't care how they're taxed. But earlier this morning, I said, remember the W-9 is one way an individual can certify their EIN, or the IRS says you can use your account agreement, but it must replicate the W-9. Well, on your form, I'm not sure if you're using Wolters Kluwer's or not, but on the form where it says here, and I don't have this copy of this particular form in your manual, but right here is where the most form, or this particular form vendor has replicated the W-9. It says LLC. So if I come into the bank and I'm a single member LLC, you will check single member. If I'm a multi-member LLC, you will check partnership. If I am an LLC owned by another entity, you will check LLC, and you'll indicate whether a C Corp owns it, a partnership owns it, S Corp, not really sure why that's there, but if they tell you they're an S Corp, you can check S Corp. What's so ridiculous, guys? This information goes nowhere. We don't care what their tax classification is. So some folks, and this is fine as well, if I come in as a single member, you check single member. If I come in as a multi-member LLC, you might check LLC and then check partnership. That's fine. But obviously, if it's an entity owned by an entity, we're going to check LLC and indicate who owns it. Okay. So that's why we have to get this information. And the IRS has talked about eliminating that because we do not care how they are taxed. We sort of do because it does impact what EIN we use, but yeah, no, this is just silliness. So in your manual, I kind of described for you with the single member LLC, we're going to use the Social Security number or the EIN of that sole member. If it's owned by an entity, we'll use the entity's EIN unless that series has its own EIN. Multi-member, they're going to have an EIN like me and my husband. We're taxed as a partnership. Our LLC has its own EIN. Now, here's something I want to talk about, which maybe some of you have bumped into, and I'll ask you in a second if you have. Let's say that you have a multi-member LLC that would be taxed as a partnership, me and my husband. I'll use us as an example. So we're taxed as a partnership unless we choose to be taxed as a corporation. Any LLC can be choose to tax as a corporation. Why the heck would we want to be taxed as a corporation? We talked about earlier how C Corps are double taxed. Well, here's the deal. Corporate tax rates are lower than individual tax rates. So a corporation's maximum tax rate might be 20%, an individual's is 35%, 36%. So if I could be taxed like a corporation, that'd be great. So what the IRS has said is, well, LLC, if you want to be taxed as a corporation, you can, but here's the deal. You cannot take any distributions from the LLC. So I had a woman in my class who said, Susie, that was me and my husband. We have an LLC on the side, and we both have jobs. I work at the bank. He works someplace else. We both have W-2 income, and we're making, plenty of money to live on. This LLC is just as a side business. We take no withdrawals from the LLC. Everything stays in the LLC. So if they choose to be taxed as a corporation, then the tax rate they'll get on that LLC is corporate tax rate, maximum 20%. Whereas if they had everything roll over, like me and my husband, we file a tax return, we file a partnership tax return, get a K-1 from our LLC, it rolls over to our personal tax return. It could actually increase your personal tax return rate. So you could have a customer come in and say to you, we are a multi-member LLC, but we are taxed as a corporation. Here is our corporate EIN. Has anybody ever had that happen? Anybody have an LLC come in and say, we're taxed as a corporation? Anybody? Sheila, you seem to be the series lady. Anybody? Well, tomorrow, just wait, it'll happen. Oh, got my little person. It was Sheila, no. Okay, great. No problem. But yeah, this definitely could happen. So not very common. Had somebody come in, some as an S and a C. Great. So 692, whoever that is, you have had it happen. So they will tell you that they're being taxed as a corporation, and you'll come back to your manual and go, okay, what were we talking about there? What I have for you here is a chart. I'm all about charts and giving you information to help you really kind of have a cliff notes. And so this walks you through each one of the entities. Down here, LLC electing to be taxed as a corporation, you're going to use the corporation's EIN, and the tax classification will be corporation. If you have a single member LLC owned by an individual, the individual's owner's social security number, and the single member LLC. You have one not owned by an individual, owned by an entity, and it's disregarded, which is typical. We're going to use the owner's TIN, the partnership, that corp or that S corp, and we're going to use the owner's tax status. If you have an LLC where it is not disregarded, then the LLC will have its own EIN, and we'll use a single member LLC and so forth. Series LLC, use the TIN unless the series LLC has its own EIN. So I hope that's a helpful sort of cliff notes what we talked about. And then let's take a look at what's going to become our favorite form on the planet, because this is where it really validates this for us, okay? So look at number 6. Because I think the question comes up is, can a single member LLC use an EIN? The IRS says we would prefer they not do that. Because number 6 says, so remember we said sole proprietors are going to use their social security number. And then it says, or disregarded entity owned by an individual. That is a single member LLC. A single member LLC, remember the IRS disregards it for tax purposes. Yes, they file with the secretary, they file with Laura, and they are an entity, but the IRS disregards a single member LLC owned by an individual and asked to use the owner's social security number. Now, if they want to get an EIN, they're going to get it in their name because they don't want to use their social security number for business. They don't want to be giving businesses their social security number. They want to use an EIN, they would still get that EIN under their individual name, just like a sole proprietorship did. And then number 8 is a disregarded entity not owned by an individual. That's an LLC owned by a corporation, because the IRS says if you're an LLC owned by one entity or one person, we're going to disregard you, and you will use the entity's social security number. Same thing as an individual, unless they choose to disregard them for tax purposes. We're going to use the owner's social security number, okay? And then number 10, a corporation or an LLC electing corporate status, use the corporation's EIN. And then number 12, partnership or multi-member LLC, use the partnership's EIN. So that's me and my husband, we're taxed as a partnership, we use the partnership's EIN, okay? So hopefully that was helpful. A lot of information. If you have any questions, feel free to ask. So let's kind of whip through not whip through, but just kind of look at this quickly. The account titling for these businesses can get a little messy. For a single member LLC that's owned by an individual, we are using the owner's social security number. And so we can title it Whitewater Rafting LLC or we can title it John Doe Whitewater Rafting LLC. In order not to put John Doe's name in the account, and I'm pretty sure most of you are doing this, is that we're going to title it Whitewater Rafting LLC. We're putting John's social security number on the account or an EIN that was attached to John's name. And we're going to link on your system, maybe you use the term alternative EIN or alternative social security number, or alternative TIN. And we're going to link that to John Doe and his social security number, or John Doe and his EIN. Okay, so you can title it just Whitewater Rafting LLC, but we do need to link that to John Doe and his social and his EIN. For the single member LLC not owned by an individual, XYZ LLC or ABC Inc., XYZ LLC, do not like that because it looks like a joint account. So do not like that. So what we really want to do is we want to title it XYZ LLC and then use an alternative TIN and link that TIN to ABC Inc. They are the owner. We're using ABC Inc.'s EIN because it is a single member LLC not owned by an individual. And for tax purposes, it's a default, and we're going to use the corporation's EIN. Multi-member LLC is simple, Whitewater Rafting LLC. And then for the series LLC, let's talk about that for just a minute. So for the series LLC, remember, let's go back to that chart that we had where we had, there's 10 buildings. And the question is are we going to open the account using the master LLC's EIN, or is each LLC going to have its own EIN? Well, the example I'm going to use is, the first one is the master LLC is ABC LLC, and the series is XYZ series. So the typical scenario is where the master LLC disregards the series for tax purposes, and they file one tax return. So the way, and therefore we're going to use the master LLC's EIN. The way we're going to title the account is ABC LLC, comma, XYZ series. So we're going to use ABC LLC's, the master LLC, their EIN, comma, XYZ series. The next account, ABC LLC, number 1 series, ABC LLC, number 2 series, because we're using we're using the master LLC's EIN. If instead the master LLC disregarded the 10 in the series and each one of them has their own EIN, we're going to title the account XYZ, a series of ABC LLC. Okay, so we're going to put ABC first, ABC, a series of XYZ of ABC LLC. Okay, all righty. So I'm hoping that we all understand what I'm talking about. I'm sure you do, but it's a lot. And this is why I try and put really everything I'm telling you in the manual, so you have a resource, because a lot of these complicated scenarios don't come up that often. You're probably typically opening single member LLCs or multi-member LLCs. Do not go to lunch if somebody comes in and wants to open an LLC owned by an entity. It's a fabulous learning opportunity. And it's just so fun. Okay, so we're going to ask for articles of organization filed with Laura, and we're going to verify whether they are manager managed or member managed. The LLC Act states that the LLC shall be managed by members unless the articles of organization state that it's managed by managers. If the LLC is managed by managers instead of members, they're going to insert a statement to that effect in Article 4 of the articles. Look at that in just a second. The articles, see, my phone does this when I'm talking about Series LLC. It tells me Siri pops up. It's a lot of fun. Siri, calm down. I'm not talking to you. Okay, so let's take a look at the articles of organization that are filed with Laura. Do not provide the names of the members, the name of the member or the managing member. So we are going to need to get a copy of the operating agreement no matter what. Let's take a look here. So here is the articles of organization, the name of the LLC, and you'll see talks about the purpose of it, the duration. It gives us the resident agent. And then in Article 4, you'll see excuse me, Article 5, I think I said 4 in the middle, but Article 5, it says insert any additional provision. This is where they would indicate that they have a series LLC. So in Article 5, they're going to indicate they have a series LLC. Okay. This is for a professional LLC to the right here. All right. So for the LLC, we're going to use the LLC authorization. So Jack Jones, certify that I'm the manager or the designated member of the above named LLC. Anybody who's going to be a signer is going to sign here. Now, one thing that's a little bit different for LLCs as compared to the other business we've talked about, we're not going to ask all the members to sign. We're going to ask either for the managing member to sign or 2 members to sign. A member and then an attesting member, okay? So we either need 2 members to sign or the managing member to sign. If they can sign alone, if they can't, then the managing member and 1 other member as well. Okay, so removing members as signers. We're going to need amended LARA documentation or the operating agreement documentation reflecting the ownership change. We've added a member, deleted a member, and then possibly do a beneficial ownership update as well. And then also we're doing a new signature card, new resolution. All right. Now, what happens if a single member LLC, what happens to it when the sole member dies? So you've got a sole member LLC and the sole member dies. Then the LLC is now memberless. And so the LLC, a single member LLC, is the personal property of the deceased member. And the bank is seeking a replacement member. Who has the authority to act on the account, which can either be the executor or the administrator of the deceased member, because it does become an asset of their estate, okay? There might be a successor or an interim member named in the operating agreement, but the bank is most likely, we're going to freeze that account until we're notified by the authorized individual representing the deceased single member is an executor, administrator, successor, successor named in the operating agreement. So the operating agreement is important. We might, at that point, if we didn't get it initially, which we are actually going to get it because we need it to find out who the members are. So here's the fun one. Okay, and we haven't talked about revocable trust yet, and we'll talk about more about this. We do revocable trust, but here's the deal. You've got a sole member LLC. So here's a freak out moment. Come into your bank tomorrow and I want to open an LLC account. And the sole member is a revocable trust. This is definitely where you go to lunch. It's like, I know it's only 9:30 in the morning, but I go to lunch early. Let me get somebody over here who can help you. You get over here and open this account. I'm not doing this. Okay, so sole member is a revocable trust. That's what we say, oh my gosh, good grief, can you please just stop the agony? LLCs are fun, okay? All right, so sole member of an LLC, I'm going to give you an example. So we've got a couple that owns rental property. They own 10 rental properties, and they've established a revocable trust to avoid paying probate. And we're going to talk about that later today. But basically, when they die, everything is like having a named beneficiary. Everything goes to the individual's name in the trust. They put all their assets in this revocable trust. Okay, so let's focus on that. So they've got rental property in their house and their boat and their bank accounts. Everything goes into this formal revocable trust. And so when they die, everything goes to their named beneficiaries without having to go through probate. Okay, so the rental property is in there. Now, because the trust is revocable, the grantor, the person that set it up, maintains control of it. So they can still, use the rental property. They can still live in their house. They can do whatever they want with their assets. But because they still have access to everything, what if somebody's at the rental property, the beach house, and they fall down and get sued? Okay, they fall and they sue the owner of the property, and the owner of the property is a revocable trust, and that revocable trust sees through to these individuals. So everything the individuals have is at risk. So the way that they can eliminate that risk is they can put their rental property in an LLC. And so if the renter or the guest gets hurt, they may sue. If the rental property is held in the individual's name or the name of their trust, Any claim against the trust is a claim against the individuals. So an LLC puts a layer of protection around those members. So the revocable trust, the trust creates an LLC, and the LLC, the rental property is the sole, the revocable trust creates an LLC and is the sole member. So the trust is the sole member of the LLC. And what they do is they put their beach house in this trust. They put they put their rental property in the LLC. So the rental property is transferred to the LLC, Jones Family Beach House LLC, and the LLC is now the owner. So if the LLC is sued, I fall down and I hurt myself, who owns this property? An LLC does. Well, what does the LLC own? I want those assets. The LLC owns a beach house. That's the only asset that will be at risk. I fall down, I'm going to sue the owner. Who owns this beach house? The LLC. Well, what kind of assets does the LLC have? The LLC has the beach house. That's the only asset that is at risk. Okay. So the question is, does an LLC have to complete a beneficial ownership certification? This LLC is an entity that files with Laura. If a trust owns 25% or more of an LLC, and in this case, they do, they own 100% of it, the beneficial owner is the trustee, and therefore the beneficial ownership form is going to reflect the trustee is the control person and the beneficial owner. When we talk about revocable trust later on today, we'll pull this back up, but I want you to know it's in your manual because I am seeing it come up more and more where where we come in and open an LLC and the owner, the sole member, is a revocable trust. All right, let's kind of jump in with corporations now. Let's talk about, so any questions on the LLC? Okay, you feel it great. You can't wait for people to come in and one, give me a high five or give me a frowny face. How are we feeling about LLCs? Feeling good? No response? Give me an answer in your chat. Anybody? How you feeling? Hand, thumbs up. Okay, let me see. I see a thumbs up, good. What if the trust has multiple trustees? Do you need, you'd need to, need to ID all those trustees. Yes, Joe. Thumbs up. You're not going to run if somebody comes in and wants to open one tomorrow. You're going to go, I am so glad you are here. I'm ready for you. Fantastic. Okay, great. So yeah, Joe, if the trust has multiple trustees, would all the trustees be signers? That depends. All the trustees will sign the LLC resolution, but they can have just one person be a signer on the account. So we're going to get the LLC resolution, and we know that the responsible parties are the trustees of the trust that owns the LLC. And so, yeah, we're going to have all the trustees sign that last page of our resolution, but whoever's going to be a signer is going to be a signer. And it may not even be a trustee, but typically it is. Okay, great. All righty. Corporations, these are relatively simple, but there's a little bit nuance with corporations, okay? An entity, the corporation, as we said earlier, when I was a corporation, a sole person corporation, I had a huge wrapper of protection around myself. I was an S Corp, didn't have to pay taxes twice. And so corporations are great because of the risk management, okay? And so the shareholders form a corporation. So let's say that there are 5 of us, we want to form a corporation. So the 5 of us go to the Secretary of State, go to Laura, we file to become a C corporation. Then we elect a board of directors. The 5 of us are the board of directors. And then we elect officers. We elect a president, a secretary, and a treasurer, maybe a vice president. And the officers then carry out our request, the things that we approve, okay? So the officers carry out the approved board actions. So the one thing that I want to make sure we understand, kind of 2 things here. Opening an account, adding or deleting signers to a corporate account with a bank is authorized by the board of directors and carried out by this corporate secretary. So I want to make kind of one thing clear. Officers do not have authority to do anything that the board has not approved. So just because I'm president of a corporation, I have no inherent authority to say, we're going to do this, we're going to do that. Just because I'm a secretary of a corporation, I don't have an inherent authority to say, we're going to open a bank account. No, it is the board that approves that action. We're going to open an account at First National Bank on this date. We're going to approve it on this date. And then the secretary comes to the bank and says, this is what the board approved. And we're also going to want somebody else to attest to the secretary's signature. Okay. So it can be any number of shareholders. We can have 1 million shareholders. We can have 2 shareholders. We can have 1 shareholder. The directors and officers elected by the shareholders and the members. We're going to title it Whitewater Rafting Inc., Whitewater Rafter Corporation. The corporation will have an EIN. And then there are different types of corporations. There's a for-profit corporation. There's a professional corporation. There's a benefit corporation that is coming soon to your state. Not available yet, but you do have pending legislation, House Bill number 6903, where benefit corporations will be approved. And benefit corporation is a combination of a for-profit and a nonprofit. So it is a for-profit corporation that does philanthropic work. So it's a benefit corporation. It benefits the world or the community, but it does it for a profit. Okay, so you might bump into those in the next year or so. And then you have nonprofit corporations. Now, not all nonprofit corporations are 501c3s. I'm going to use myself as an example. Okay, I have a nonprofit 501c corporation. Let's go back to our basis we talked about. To mitigate risk, I have a nonprofit corporation called Flight 25, and we mentor students, a group of 30 children that we choose from a middle school. They go to high school from 9th grade to 12th grade. We meet with them once a month as a group. We mentor them. We have speakers come in, talk about different job opportunities. We educate them about how to apply for scholarships. These are all at-risk kids. So when we started that, went to Laura, if I were in your state, and I got approved. I applied to be a nonprofit corporation. So a nonprofit corporation, and that's great. I am an entity. But when people donate to my corporation to help us with these kids, they don't get to deduct it. I have to go to step 2, which has to do with my taxes with the IRS. Okay, so I managed risk over here by being a nonprofit corporation. Now I'm going to manage my taxes. And so I go to the IRS, and this 501c3 is the IRS regulation number that when a nonprofit corporation applies to be a 501c3 tax exempt organization, they file with the IRS, then my donors can deduct donations to my nonprofit corporation. So for you guys, when I come in to open a corporate account, I am a nonprofit corporation. Great if I'm a 501c3. You really don't care. It has nothing to do with opening the account. I am a nonprofit corporation who happens to also be a 501c3. So if that matters to you, if you give them a different service charge because they're a 501c3, that's great. Okay, so again, I hope you walk out if you're really kind of segregating in your mind, managing risk by filing with the IRS and managing taxes and how those things have to do with, I manage my risk by filing with the state, by filing with Laura, by getting permission with the state to be a nonprofit corporation. And then I get permission from the IRS to manage my taxes, okay? So the difference between these two is that nonprofit status refers to status under state law, and tax exempt status refers to IRS status. And we actually don't care if they are a 501c3. It might matter to you, service charge, type of account they can have, but they are a nonprofit corporation. And you can actually look up any nonprofit on the planet. You can go to the IRS website, and I've got the instructions. You can look at my nonprofit, Flight 25, you look up any nonprofit on the planet and see if it is a legitimate entity. Okay, so we're going to title the account Whitewater Rafting Inc. or Jones Medical PC Professional Corporation. We're going to use the corporation's EIN. We're going to ask for their articles from the Secretary of State, going to ask for their bylaws, their minutes, and we're going to complete a resolution. So corporation files with Laura by filing articles of incorporation. Those articles do not tell us who the officers are, so I am going to need minutes from them to verify who the officers are. Remember, the board of directors had a meeting, they elected officers. And then when do you need the bylaws? So what if we have a corporation that says, we don't have a corporate secretary? We don't have a corporate secretary, okay? There're just two of us, we don't have one. So what you would do then is you would ask for a copy of their bylaws, because the bylaws do not tell you who the officers are, the people, their names, but it does tell you who is playing the role of the secretary, who is responsible for attesting to documentation for this corporation. Is it the president? Is it the vice president? Is it, the treasurer? Who is the person? So if they don't have a corporate secretary, that's fine. Just give me a copy of your minutes, of your bylaws that tells me who is that person that fits that role, okay? So who's the individual who can sign the bank's corporate resolution validating the board's authorization to open an account? We're going to ask for a corporate resolution, signature card. Let's take a look at that resolution. Well, let's look at the form first. Here's our articles of incorporation, gives the name of the corporation, does not give us the name of the officers, but it gives us all sorts of good information about the entity, okay? And then we're going to have the corporate resolution, I, Susie Jones, and the secretary, or it gives you the option if they don't have a secretary, the clerk or the person. Here's our EIN, and our board met on this date. Here's the deal guide. This actually should not be the date they opened the account. It should be the date they had the board meeting, but we're just going to go with that. Unless they had the board meeting driving over to open the account, we met on this date and authorized an account to be opened. Here's the signers, who they're going to be. And then we're going to have the secretary sign, and we want an attesting officer to sign. So now you understand why when Bob said he would just sign on here, Bob doesn't have the authority to sign. Bob cannot sign. Bob is president, does not have inherent authority to authorize the account to be open. The board of directors does. Okay. All right. Okay, so let's kind of go through a couple of other types of accounts. So far we've talked about very specific accounts that file with Laura. Next couple of accounts we're going to look at are a little unique. Okay, so somebody might come in and want to open an escrow account, and it's referred to possibly as a 1031 exchange. Let me just give you an example of what that is. Let's say that you bought a building in downtown Lansing 20 years ago, and you paid $100,000 for it. Today it's worth $1 million. And you're going to sell it, and you're going to take that $900,000 profit, and you're going to buy another building. Now, the key is that $900,000 is taxable income because it's a profit. It's a capital gain on the building. And you say, well, I'm not going to take the $900,000. I'm going to put it right into another investment. The IRS says as long as you don't touch that $900,000, then it will not be taxable. So what happens is you have this intermediary. Okay, and the intermediary works with the client. And so the client sells the building, and the intermediary, called a qualified intermediary, they come in, they open the bank account on behalf of the customer. That qualified intermediary opens the account, the money stays, and they have like 60 days to find another building. It might be 90, but 60 to 90 days to find a new building. Once they find the building, the intermediary then sends the money over to the mortgage broker, or the individual who's buying the building, and they send the money. So they're intermediary. That individual who's selling the building does not touch the money. And so we're actually opening an account with the intermediary, the qualified intermediary, ABC Inc., as qualified intermediary for John Doe. John Doe's not opening the account, the intermediary is. And so we're going to identify the intermediary. If it's a corporation, you're going to get the corporation's documentation. You're going to get their EIN. You're going to do all of that. Now, sometimes the intermediary might say to you, we want to open an interest-bearing account for the 60 days. It's $900,000. We want to earn interest. And so, but we want the interest to be reported in John Doe's name. They could bring you John Doe's Social Security number. They could bring you a signed W-9. You may want to request John to come in and get his identification. He's not a signer on the account, but we are going to be using his Social Security number. Okay. And so we're going to get the qualified intermediary's documentation, and we also might want to get a copy of the agreement between the two individuals indicating that that John Doe is indeed the individual who owns the money but is allowing this intermediary to open the account. All right. You also have prepaid funeral escrow accounts in your state, and it's either going to be opened for an individual. So the individual comes in to open the account for this prepaid funeral or cemetery sale, and it's opened either in as a pooled account for multiple beneficiaries or not pooled. So John Doe prepaid funeral escrow account by ABC Funeral Home Agent, okay? Or I'm sorry, I've got these reversed on my slide. I apologize. The first one is non-pooled and the second one is pooled. So if it's non-pooled, check your manual there and make sure that on page 111, I don't have those reversed. The first one should be, because we're putting John Doe's name, John Doe prepaid funeral escrow account by ABC Funeral Home using John's Social Security number. Or if it's not pooled, ABC Funeral Home for the benefit of John Doe prepaid funeral home escrow account. So they're going to bring you a W-9 provided by the bank, signed by John Doe, with a signed contract showing who should receive any excess funds for the funeral above the funeral cost. Okay. All right. Let's talk about nonprofit associations, social clubs. These are always fun because they're pretty much clueless as to what's going on. So softball team, class reunion, fun run, you know, a pack, a troop, Lions Club and Kiwanis could be an entity. They could be a nonprofit organization, actually normally are, but a homeowners association is an example of an unincorporated association. These are member run solely for the benefit of the members. These are not 501c3 nonprofit corporations. They're just informal entities, okay? And so we're going to title the account exactly as it's payable. I come in, I want to open an account for the class reunion of 1972. And so I want to open the account. You're not going to use my Social Security number. You will require me to get an EIN for the entity. Because if you put my social on the account and I'm collecting all this money, let's say I've collected, you know, $10,000 for our class reunion, and you put my social on the account, and a couple of days after I open the account, you get a garnishment or some sort of hold on my Social Security number, you're going to tie up this account. Not pretty for the class reunion. We're now not going to Las Vegas. We're going to have it in my backyard. Anyway, so we do want the association to get an EIN. They're going to say to you, where does it say we have to have an EIN? You're going to whip out this form. You can look at number 11, association, club, religious, charitable, other tax exempt organizations, use the organization's EIN. And they say, well, how do I do that? And you say, well, you go to the IRS website. They won't complete the SS4, but this is what they're going to ask for. It takes about 4 minutes if you have, even if you have slow internet, and they're going to ask you the name, name of the entity, of the organization, not a trade name, just the name, class reunion of 1972. And we're going to indicate on here other, and we're going to say the only reason I'm getting the account is for banking purposes. We need an EIN, okay? And then we're going to identify the individuals opening the account. Probably not a lot of formal documentation. The larger entities like a homeowner association, they might have minutes, they might have a charter, but a lot of times these people don't really have anything. And so the most formal document for this nonprofit association is your resolution, okay? And so we're going to whip out our resolution. A lot of institutions use a resolution of lodge, association, or other similar organization. And we're going to put the name of the organization up here. I, Susie Jones, am the secretary or the clerk of this organization under the laws of Michigan. And we had a meeting on, yesterday, and whoever's going to be a signer on the account will sign here. And then we're going to ask 3 individuals to authorize the account to be open. That is the ideal scenario, because we all know the problem with these accounts. They change signers every 15 minutes. It's just a nightmare. So we'd like to have hopefully at least one human being who was still associated with the organization still there if they come in to change signers. So is there a secretary and attested by 2 other officers, a clerk? This is ideal. Not saying it's required by law, but would be lovely at least 2 people to sign authorizing the account to be opened. Okay. Okay. Political campaigns may not open a lot of these accounts as either, but basically we're opening an account for a candidate who is running for judge or governor or, some sort of county position. So they need to open a bank account. This is not a business. It is really a personal account for this candidate, because any money left over, they get to keep. And so we're going to use, for example, Friends of Sam Jennings campaign. You're going to identify those people who are going to be signers on the account. And a lot of times that's going to be the treasurer and the candidate, or the candidate can be the treasurer on this account. The tax ID number, you can use the individual social security number, or if they want an EIN, if it's required. Okay, so a tax exempt organization like this political campaign doesn't have to have an EIN unless they're required to file a Form 8871. And an 8871, who's exempt from filing that, if the donations are going to be less than $25,000, which is very often the case for these small local campaigns, or it's a political campaign of a state or local candidate. Okay, and so let's see what's happening here. I'm not okay. So what we can do is we can go online and you can actually verify a candidate. You can go to the Michigan Secretary of State and they have an elections section, and you can click on candidate information, and you can in that left bar you can search for the candidate's name, and you can actually get a little form like this, affidavit of identity and receipt of filing. It'll be filled in and tell you all about this little candidate. Okay, so if you want to do that, you can do that as well. And so the resolution, if you're going to use one, a lot of banks open these campaign accounts just as individual accounts for the candidate. But if you want to use a resolution, you can. And a lot of banks use the resolution of lodge, association, or similar organization. So if they want to make it more formal and have a resolution, that's great. Or you can just open it as a personal account, because we are titling it John Doe candidate, and we're using John's social security number. Okay. All righty. And on the resolution, we're going to fill that out. And then we would like 2 or 3 people to authorize the account to be open if you're going to use a resolution. Okay. Let's talk about IOLTA accounts. So an IOLTA account, do any of your banks do all of your banks open IOLTA accounts? If you do not open IOLTA accounts, can you put it in the chat? If you do not open them, let me know. Yes, you do. Okay, great. Anybody not open them? Okay, great. Looks like we're all opening them. Fantastic. So for those of you that are new, you don't see these accounts very often, but it stands for interest on lawyer. I forgot trust account, interest on lawyer, trust account, IOLTA. Now let me just first say, very beginning, you're opening an account for the law firm. That's what you're doing. You're going to get all the documentation for the law firm. If it's, Jones and Jones, attorney at law, you're opening an account for Jones and Jones, attorney at law. If they're an LLC, if they're a corporation, if they're a partnership, that's what you're opening. But the difference is it's going to go into an interest-bearing account. And so the purpose of this account is that the Michigan State Bar says, we've got these attorneys all over the state who are getting very small settlements for their clients. They're getting like $5,000 and $6,000 and $10,000, not $1 million. And it's number one, a pain in the neck for the attorney to open an account for all these people. And so they just don't. They just put it in their trust fund account. They have a trust fund account for their clients. So all over the country, the state bar said, why don't we do this? Why don't we have the attorneys all over the country put these small nominal deposits into an interest-bearing account, and let's have the interest not go to the law firm, not go to the client, but go to a nonprofit foundation. And those funds will be used for legal aid. So the bottom line is the bank is opening an interest-bearing account for the law firm with the interest going to this nonprofit foundation. And they use it for people who cannot afford to pay for legal assistance, legal aid, that type of thing. So it's all over the country. Obviously, if an attorney gets $500,000 for their client, they're going to put that on an interest-bearing account and let their client earn interest. But it's $500 or $10,000 or whatever. It's just a pain in the neck. So title the account William Smith Attorney at Law. That's the name of the firm, IOLTA, or William Smith Attorney at Law IOLTA Trust Account. If you want to add that to the account title, we're going to identify the law firm, and we're going to use the law firm social EIN, but we're also going to use the foundation's EIN. Okay, so your state bar's foundation number, which that is. There is no 1099 reporting, so we do not need a W-9 on this account because this account is exempt from filing because it is a 501c3 and it's tax exempt, okay? So from a documentation perspective, get the documentation for the law firm, and then also ask them for this form, okay? You're going to ask them for this IOLTA notice to eligible financial institutions. And you'll fill in your information, you'll fill in the law firm's information, and either you or the attorney can get that original. Actually, the bank keeps the original, and then you'll send a copy of it to the state bar, or the law firm can send it to them, okay? So that's what an IOLTA account is. It's a really neat type of account. Public funds or government unit accounts, let's talk about those. Somebody mentioned that earlier. So I have in your manual, I don't think I'd have it up here, but I have in your manual that these public fund accounts are, the bank actually bids for these deposits. And there is typically a person or an individual, a department in your bank that handles these. Because what's unique about these is that public funds are actually the municipalities, all of these types of accounts you might be open, are collecting money from the public. That makes sense, right? And the money is used to pay for roads and, you know, all sorts of things that the public benefits from, bridges, that type of thing. So when we open this account, what is unique about this account is that the deposits must be insured. Any amount over the FDIC limit must be insured, must be collateralized. So they're insured up to $250,000. Anything over that, the bank must collateralize. So in my former bank, in our investment department, we actually handled all the public fund accounts, millions and millions and millions of deposits. We had the city of Houston as one of our clients. 422 accounts for this, just the city of Houston. And we had obviously a computer program that tracked those accounts, that if they had deposits that exceeded the 250,000, we had to pledge collateral for those deposits. If it dropped below the 250, we had to release that collateral. It is a complicated scenario. So having said that, Bob Doe is not going to walk into the bank tomorrow and say, I need to open an account for the city of Lansing. They're just not. The bank is expecting these deposits. The individual who handles these accounts has been expecting these deposits. And so typically from a documentation perspective, the bank probably already has the documentation, someone in your bank who's handling those deposits. If it's incorporated, we're going to get corporate documentation, and many of these municipalities and so forth are incorporated, obviously, for risk protection. But if they're not incorporated, then we'll need some sort of minutes from a meeting with the officers where the individuals were appointed. A lot of banks obviously use a corporate resolution if it's incorporated, but a lot of organizations have resolutions specific for these public funds. A lot of these organizations have obviously the client and the bank are going to have to sign a contract because all this pledging of collateral. So you can see it's a kind of complicated account, and one where we're going to be partnering with. What's more likely to happen is the individual who is opening these, the individual who's managing these accounts for the bank, that's someone's going to come to you to open the account, not the individual representing the public fund. Okay. Anybody who works with public funds who wants to add anything to that, please feel free to jump in if you have any questions. Okay, let's see if we can wrap up FinCEN beneficial ownership before we go to lunch. So because we're going to go to lunch at noon, okay, I've got about what? Well, we're not going to be able to wrap it up. We'll get as much as we can before we go to lunch at 11. excuse me, at noon your time. So before 9/11, there was not a lot of scrutiny about the owners of businesses. But as time went on, and after 9/11 and other events that have happened, the federal government realized that a lot of businesses were being used to hide criminal activity by having the owners be terrorists, terrorist organizations, and having an individual front the organization. Okay. So where the owner of an LLC was 3 different businesses. And so how much of the organization do these businesses own? So we are now required in our bank to ask who owns the business. And that is required for any legal entity. So if we have a corporation, an LLC, a partnership, so basically any entity that files with the Secretary of State. Obviously in your state, general partnerships do not, but all partnerships do need to complete the certification. So proprietorships do not, these associations we're talking about do not, and most trusts do not, unless it's a business trust or a trust owns 25% or more of a business. So let's look at that. There are 2 people, there are 2 groups we're looking for from an ownership perspective. We have the control prong, which is who is one person that you're going to tell us that we can actually refer to, go to, that has control over this business. And we probably already have that. We have the responsible parties' names, we have the president, we have the members, we have the partners, we have individuals representing the corporation. So who is that person? So that's going to be the control person, and we'll ask a representative of this entity to complete that for us. Then we want to know who owns 25% or more. That'll be the ownership prong. And so some businesses or some accounts that open an account, we only get the control prong. Like you might have a business, a church. No, not a church. I'm trying to think. We'll get to it later when we get to the business entities. But so you got a control prong and you have the ownership prong. So who owns more than 25% or more? I guess a revocable trust would be an example of that. If a trust owns more than 25% of an entity, then we're going to get that control prong information. And then let's take a look at what information we're going to get of those individuals, their name, their date of birth, their address, their social security number. So with my LLC that my husband and I have, I am the managing member. So I come into the bank and I want to open an account. I'm the managing member. I'm going to be the only signer. So I say to you, I'm it. I'm the only person you need to deal with. Okay. So I sign, I complete the resolution. I indicate that I'm the managing member. I authorize the account to be open. I'm the only signer. Then you slide this beneficial ownership form over to me. This is where you find out about Randy. Okay. So I'm going to tell you that I'm the control person, and the ownership prong is me and Randy. We both own 50%. So now you're going to get his name, his address, his date of birth. And most importantly, he doesn't have to be there. Okay, I'm going to give you all the information. He does not come into the bank. I give you the information, but you are going to run him through OFAC. So you're not going to run him through check systems, but you are going to run him through OFAC. You're going to identify him, and you're going, because he's not a signer on the account, not going to run him through check systems, but you are going to run him through OFAC. Okay, that's what the government wants. They want these people run through OFAC to make sure that they are not a terrorist. Okay. So the certification form looks something like this. I don't know if you're actually using this in your bank, but there is a section for all the persons who own 25% or more. And then there is a section for the control person. Okay. Great. So if you're using this form, great. If you're not, then it may look different, but it does request all the same information. So I would be the one to fill this out. Okay. Let me see if there's a question here. What about if a business is owned by a business, which is also owned by a business, which is then owned by a trust? How do you obtain the information? You actually go to lunch. You actually don't do that. In a few minutes, well, actually, when we come back from lunch, that's a great question. And you're just going to have to keep digging, Sheila. You're going to have to keep digging. If a business is owned by another business, and when we come back from lunch, I'm going to walk you through an example. A trust is not one of the owners, but we could put them certainly in the prong. But we're going to walk through after lunch how to open an account from a certification process and a documentation process. If a business is owned by one business, if it's owned by two businesses, how do we dig enough so that we can identify the beneficial ownership? So great question. And you have kicked us off to lunch. You guys, if we can take 30 minutes for lunch, I would truly appreciate it. You will come back at 12:30. We will jump in and we will answer Sheila's question. Thank you. I'll see you at 12:30. Okay. Just about ready to get started. Okay, why don't we go ahead and jump in? I hope everybody is back. I'm going to give you just a minute or two to get everybody situated. Okay, so before lunch, I'm trying to get this out of the way here. We had a great question about setting up someone coming in and they have a business that's owned by a business, that's owned by a business and owned by a trust. So let's go on down. Let's kind of keep going here. Let's look at complicated business structures and how we, first of all, look at the beneficial ownership information, and then we'll talk about looping them into how to identify them. So you might have an individual who has from a beneficial ownership scenario, who owns individual corporations, LLPs, LLCs, and so each entity is going to stand on its own for beneficial ownership certification. So that makes sense. And then you might have an individual who has a ton of DBA. So Training Resources, Consulting LLC, DBA, Doe Plumbing, DBA, Whitewater Rafting, DBA, I have all these DBAs. Well, the DBAs don't really count. So we're going to be, my LLC is the beneficial ownership responsible party. So that's who you're going to be tying it back to the parent entity and getting their certification. So DBAs don't really count. They're just doing business as it's the same entity. Okay. But then you have entities that are owned by other entities. And so we need to look at the beneficial certification and tying it back to who is the owner. So if we have an LLC owned by a corporation or a partnership owned by an LLC, let's kind of talk about that from a beneficial ownership perspective. And then we'll look at it from a documentation perspective. Excuse me. So if we have an LLC and they want to open an account and they're owned by a corporation, so this one is somewhat easy because we know the owner is one entity. And so what we're going to have to do is to drill down. And I do want to make it clear that we do not have to have the customer. We're not the ones who's validating the ownership. The customer is. And when I had complicated scenarios like the one that was described, where I have a business owner, business owned, business owned by a trust, I would ask them to provide me with a schematic. It's not my responsibility to go in and figure out who owns what. Now, from a opening account perspective, I definitely need to get the documentation. But from a beneficial ownership perspective, it is their responsibility to certify the form. And so I need for them to give me a spreadsheet telling me exactly how this works, which would also help you with the documentation. But in this scenario, for example, Mary owns 30% of the corporation, therefore she owns 30% of the LLC. John owns 40%, Mike owns 30%. So all three of those individuals own more than 25%. So they will be indicated on the certification form. Okay, so we're going to have to we don't have to see them, but we do need to get their identification, their date of birth, and run them through OFAC. And then for a layered business structure in a scenario where you have an LLC that's owned by two corporations and corporation. So we've got the LLC, and we've got ABC LLC is owned by two corporations, each owning 50% of the LLC. And so who owns the corporation? Who owns 25% or more of the corporation? Well, the first thing that's going to have to happen is this ownership of Mary and John and Mike, it'll be cut in half because this corporation only owns 50% of the LLC. So Mary's, we're going to add, they would add 5% of corporation A, and then 17.5% of corporation B. So for example, so corporation A here owns 50% of the LLC. And again, you don't have to do this kind of spreadsheet analysis unless you just want to, but you can certainly ask the customer to give you this kind of backup. Okay, so if Corporation O, Mary owns 50% of Corporation A, so we're going to attribute 5% to the LLC. And then Corporation B, she owns 17.5%, so we're going to attribute 17.5, excuse me, Corporation B, she owns 35%, so we're going to attribute 17.5% to the LLC, so she owns 22.5% of the LLC. So she obviously would not be included on the beneficial ownership form, whereas John and Mike would, because 50%, even 50% of their ownership of the corporation cut in half, they still own at least 25% of the LLC. Okay, so again, that's one way to kind of figure out who the beneficial owners are. So now let's talk about opening the account and kind of documenting those complicated business structures. So step one is if I have a corporation, if I have a general partnership that's owned by a corporation, I'm going to identify each entity that is an owner and then request that documentation. So we're going to go through an example here. Then I'm going to determine the responsible party that can represent each entity owner. And then I'm going to identify the responsible party of the entity and then have the responsible party sign the resolution. So let's look at an example. Go to page 135. So I come in and I want to open an account and I'm ABC LLC. And so the first thing you're going to ask me is, are you member managed or manager managed? And we'll talk about in a second then what difference that makes, but you'll ask them that. And then you're going to ask them, who is the owner? Well, in this scenario, the owner is XYZ Inc. Okay, so that's the owner. So just like any other owner of a business, you're going to have to identify them. So the first thing we're going to do for this corporation is we're going to request LARA formation documentation, and we're going to request minutes or access LARA website to verify the officer. So now we need to figure out who is XYZ Inc. and who are the officers. Because, excuse me, what we're looking for, the question that I get a lot of times in this scenario is, are we going to do an LLC resolution and a corporate resolution? The answer is we're going to do one resolution. We're going to do an LLC resolution. The corporation is not opening the account. The LLC is opening the account. So we need to get permission from whoever the responsible parties are of ABC LLC to sign our resolution. So when you look at XYZ Inc., someone from XYZ Inc. needs to sign the LLC resolution, authorizing the account to be open because they are the owner. So the first question I ask is, now that I see that XYZ Inc. Is the owner, so is this LLC, this ABC LLC, are they member managed or are they manager managed? Let's go down the right side. If they are manager managed, then the LLC manager will sign the resolution, Betty White, managing member. So we've gotten a copy of their operating agreement telling us who the managing member is, okay? If the LLC is member managed, then we need representatives from the LLC, the members, to sign the resolution. So we have two corporate officers will sign the resolution. So our question is, for ABC Inc., who is the secretary and who is the president? So Mary Smith is the secretary. She's going to sign on behalf of XYZ Inc. For the LLC. She's going to sign Mary Smith, secretary, XYZ Inc. member. And then John will sign John Doe, president, XYZ Inc. member. So we either have the managing manager of the LLC sign the resolution, or we have two representatives from the owner, from the Inc., the owner, sign the resolution, okay? But nonetheless, we're still going to have to identify the corporation, but then once we do that, who's going to sign the LLC resolution, okay? Now, on the next page, page 136, this is where we have a general partnership or a co-partnership that is owned by an LLC and a limited partnership. And in the example that we're asked about, what if, and I think that maybe the example you were giving, maybe it sounds like that XYZ LLC and ABC LLP are owned by a trust because it kind of rolls up. So we'll talk about that in just a second, because basically if that's the scenario, what we're really talking about is the example I gave earlier. If I have a revocable trust, we have a corporation that comes in and it has we have an LLC come in, they want to open an account, and they have an LLC number 1, LLC number 2, and both of those LLCs are owned by a revocable trust. That's the example I was giving earlier of how this revocable trust is trying to protect its assets. So they're creating businesses that could possibly roll up to another business. So let's just kind of look at how that works. So I've got this general partnership that's owned by XYZ LLC and a limited partnership. So the first step is going to be to identify the partnership and identify, get Smith and Smith's trade name affidavit, because remember, they're not going to be filing with the Secretary of State, with Laura. Get their trade name affidavit, and it's going to tell me who the owners are, XYZ LLC and ABC Limited Partnership. So I'm going to go through the same thing I would for any other account opening. I'm going to identify XYZ LLC. The first question we always ask for an LLC is, are you member managed or are you manager managed? So I'm going to request their Laura formation documentations for the LLC. And if it is member or manager managed, if it is manager managed, then the manager, Jack Smith, managing member, XYZ LLC, will sign the partnership resolution for Smith and Smith. So I'll say that again, XYZ LLC, are you manager managed or member managed? I'm going to identify XYZ LLC, and then I'm going to ask them, are you member managed or manager managed? And if they are manager managed, I would have seen their operating agreement that tells me who the manager is, and that person's going to sign on behalf of XYZ LLC on Smith and Smith General Partnership Resolution. If they are member managed, then I want 2 members to sign the resolution, John Doe member, XYZ LLC, Mary Doe member, XYZ LLC. They will sign the partnership resolution for Smith and Smith. The same thing for ABC Limited Partnership. Going to identify the partnership. I'm going to ask, has limited partnership appointed a managing partner? If they have appointed a managing partner, that will be the person. Beth Wright, managing partner, ABC LLP. She will sign the partnership agreement. And then Judy Jones, partner, ABC LP, Linda Smith, ABC LP, they both will sign the general partnership resolution. Okay. So if we have layers below that, we're just going to do the same thing. And so going back to your question on the documentation, we're going to identify each of the entities. And so if they're all owned by a revocable trust, then we're going to get identification for the revocable trust. We'll get the trust certification. We'll have them sign a trust certificate. We'll have them sign an in-house trust certification. We'll talk about it in a few minutes. And then we will figure out who has the authority to sign on behalf of the trust. And it's probably a trustee. And so they would sign the resolution, the partnership resolution on behalf of Smith and Smith. If they own these 2 entities, so if they own 100% of themselves, obviously, and they own 100% of these 2 entities, then they are 100% owner of Smith and Smith General Partnership. All righty. In your manual, the very last page of your manual is a chart. And I'm not going to go through this line by line, but it's there as a reference for you. And this is what happens when an owner of a business dies, just some guidelines on the way to handle that. So I first have in the first column is the name of the entity. The second column is if the deceased signer is either an owner or just an authorized signer. So what is the impact on the bank? Does the account continue for sole proprietorship? A sole proprietorship ends at the death of a proprietor. So if it's just one owner, it ends. We're going to freeze the account, and the bank is going to take direction from their personal representative of the deceased proprietor. And that if they had an authorized signer, their access ceases. So going back to that wife, if she was just an authorized signer, her access would cease. Okay. Then the general partnership is where we have 2 or more partners. And if a partnership agreement exists, it will govern the treatment of the deceased partner's share in the viability of the business. It may say that the deceased partner's ownership is transferred to his wife. And so now she's the other partner. Okay. So we could allow If there are 10 partners, it would basically have no impact, allow the surviving partners continued access until we're notified otherwise. If the general partnership is not required to dissolve, we're going to require amended regulatory filings, which would be with the county, reflecting the revised ownership. Okay, so if we have a partnership that's owned by 2 partners, then there's no reason not to let the other partner continue to have access until you're notified not to. No reason for this business to shut down because one of the partners passed away. I can assure you that if there is an issue, the parties that have that concern will be in the bank pretty quickly. Okay, so and then the limited partnership. Remember, I said earlier that a limited partnership can have 1 general partner. So if there's just 1 general partner, they're going to have to freeze the account. If there are 2 or more general partners, we're going to let those general partners continue to have access to the account, because the general partnership, limited partnership can have just 1 partner. But when it comes to changing signers and so forth, we're going to need updated documentation, updated certificate of limited partnership, and we'll do a new signature card and a resolution. So what about the sole proprietorship joint venture and one spouse dies? Does the living spouse have, yes, the living spouse. So the question is, does living spouse have full ownership? I don't know that they have full ownership, because certainly the gentleman in his will could have left his half of the business to his children, but she has continued access. That probably is the most important question. If we have a husband and wife, they're both owners on the account and one of them passes away, there's no impact on the account. It's just now a sole proprietorship with 1 owner, okay? But we don't know about the ownership. We can't make that assumption, because it could be, like we said, it could be decided if the individual had a will, and may leave it to his children, may leave it to somebody else. Okay, question? Great. Yeah, thank you. Okay, good. That's what she meant to say. Got it. Okay, and oops. So, and then for the limited liability and limited liability partnership, we know that if a partnership agreement exists, it might, share what's supposed to happen to this account. But at the end of the day, we can allow surviving partners to continue access. You're really going to go back up to the limited partnership and the general partnership, because a limited liability limited partnership is either a general partnership or a limited partnership that has simply gone and had that wrapper of protection placed around the partner. So it really does depend on which the underlying entity was. Okay, basically, we're going to let those partners to continue to have access, their surviving partners, until we're instructed not to. And then the very last page of the manual, on page 230. Sorry, I did that to keep y'all awake. Thanks, Sheila. Yeah, this chart I'm looking at is the very last page of the manual. And then a corporation is not impacted if anyone dies. A corporation is perpetual, it never dies. And so if a shareholder dies, or an officer dies, secretary dies, we just get new signature card and new resolution. And then the nonprofit association, if an authorized signer dies, the organization continues. We just need to get a new resolution and a new signature card. Okay. Any other questions on that? Okay. Well, don't. You can still ask questions about business accounts. We're just going to jump in here. We're going to jump into personal accounts, and then we'll wrap up with fiduciary accounts. So, personal accounts, we're going to look at. We're not going to talk about all 6 steps. We're going to talk about a couple of the steps, because everything else is the same as we talked about this morning. Account titling and ID that you get, and we verify everybody on check systems and doing the OFAC. We're going to look at verifying a W-8 and W-9, back at withholding, and then we're going to jump into impact of ownership options during lifetime and at death, how ownership impacts what happens to a personal account when a signer on the account dies, when an owner or party to the account dies, who has access during lifetime, and who has continued access if one of the signers dies on the account. Okay, and we'll talk about agents and power of attorneys, and actually we're going to do opening accounts for minors a little bit later. Okay, so this question that I had, what's the purpose of the account? What are you trying to accomplish? Is really magnified when we talk about personal accounts. And does this person standing in front of me have the authority to do what they're asking? okay? Because these ownership options with survivorship, without survivorship, all these options that a customer has can override a customer's will. They can increase insurance coverage for sure. They dictate who has access to the account and ownership during lifetime, who owns the funds. If I add my daughter to my account, does she own the money in the account now? And determines who can legally receive information upon the death of an owner. Okay, so our most important job is to provide information and advice, information and options, not advice. And I know that's so much easier said than done, because what happens is customer comes in, you describe all the options with survivorship, without survivorship, you can add her as an agent, you can blah, blah, blah. And then they say to you, so what do you think I ought to do? And we really can't answer that question because, as I said, some of these ownership options replace a customer's will. Okay, so we're going to look at on the personal accounts. We're going to identify all the signers on the account. We're going to do that. We're going to verify prior banking history for all the signers on the account, all the parties to the account. We're going to give them all this fund documentation, and this is magnified enormously with personal accounts because this little account agreement overrides a customer's will if they set it up with right of survivorship or POD. And so what I would say to my customers is this document is a legal document. I strongly encourage you to put it in your safe deposit box with a copy of your will, any power of attorney, any other documents you may have, okay? So yeah, it's important. We don't want the heirs to come into the bank and say, my mom had no idea this account overrode her will. She would have never done that. Well, gave her the terms and conditions, gave her a copy of the signature card where she indicated that it was with right of survivorship. So sorry, can't help you, okay? And then we're going to run everybody through OFAC. We know that. And then on the account agreement, we know that this is going to go to court with us. We want to give our customer a copy of it for sure. And then we're either going to use a social security number or an I-10 when it comes to these personal accounts. Okay, that's kind of how they're the format. 990 is going to be for the I-10. So U.S. persons use a social security number, and most non-U.S. persons use an I-10. And let's go back to the customer can either sign the W-9 or they can do your substitute W-9 on your account agreement where they're actually certifying this is my number and I'm not subject to backup withholding. And so we know that this is the W-9 and that the account agreement has that substitute certification down there. This is my social security number and I'm not subject to backup withholding, okay? And then we have the W-8 and the W-8-BEN. The W-8 is for a foreign person. And so the question is, does a foreign person always sign a W-8? And the answer is no. And let's talk about that, okay? So if an individual is a legal permanent resident, they would sign a W-9, not a W-8. And there are two criteria that must be met to be considered a resident alien, okay? They're going to hold a permanent resident card, and so that's called a green card, or they pass the substantial presence test. Now, the green card it's not really called a green card anymore. It's called a permanent resident card. We used to call it an alien registration card. My mother was from England. I was born in England, but I was naturalized because my father was a U.S. citizen. But my mom had a green card her whole life, and so super important. If she left the United States and lost her green card, she could not get back in. So the green card is a very good piece of identification and one that a lot of foreign individuals will use. She never got a driver's license because she never learned how to drive, but she did get a state ID from the Department of Public Safety. So she did have a substitute driver's license. Or if they pass substantial presence tests. Now, the bank is not responsible for performing this test. I do know some banks that do. They have a little module that pops up and they ask the customer the information and they complete it. But it's basically based on the number of days the individual has been present in the United States for the last 3 years, okay? They have to be physically in the United States 31 days of the current year, 183 days of the previous 3-year period, basically, and basically during the previous 3-year period that includes the current and the 2 previous years, okay? So I have a little chart that kind of helps us decide when do you use a W-8, when do you use a W-9. So if they're a U.S. citizen, obviously, we're going to use a W-9. If they're not a U.S. citizen, are they a permanent resident? They either have a permanent resident card or they meet the substantial presence test. If that's the case, they would use a W-9. However, if they do not meet the permanent presence test and they do not meet the substantial presence test, they don't have a permanent resident card or substantial presence test, they would complete a W-8 and they would complete it with an I-10. Okay. So what is backup withholding? Just cut to the chase. Backup withholding is not a penalty, not a penalty. You know that half of your paycheck that's gone every 2 weeks, you know what I'm talking about? Well, that paycheck is backup withholding. Basically, the IRS says, while you have Susie's money that belongs to us, go ahead and take it out of her paycheck and send it to the IRS. And when she files her taxes, if she's paid too much, we'll refund part of it to her. So that's really backup withholding. This is a scenario where an individual's Social Security number doesn't match the IRS records. So the IRS says we have no way of confirming whether or not this individual has paid the income on their interest they've earned, because we can't match it up. We can't match their name with the 1099 that the bank is sending because it's a mismatch. The name and the Social Security number do not match. So backup withholding is when the bank is notified, want to let you know that Susie Jones, the social you sent us doesn't match her name. So that from that point on, the bank is going to have to withhold a percentage, 24% of the interest I earn if I'm a US citizen and 30% if I'm a foreign person, send it to the IRS. And when I file my taxes, if they withheld too much, I will get a refund. Okay. So that's backup withholding. Okay. And again, we'll talk about page 22 again. We'll talk a little bit more about this chart as we go through some of these accounts. Okay, so let's talk about opening an individual account, a joint tenants account, joint tenancy by entirety, and the Michigan statutory joint account, which does anyone know, does anyone use the Michigan statutory joint account? Anybody out there? Ever heard of it? Does anybody use this Michigan statutory joint account? Okay, maybe you're not sure. Okay, well, we're going to talk about what it is and why you may want to consider using it. So this is where you've heard of it. Do you use it? Okay. All right. Well, let's talk about it. Okay. So I have an answer, and the answer is we can open, but I have never. Okay, great. Yay. You are a little great example. So you can open it, but you never have. And I bet after this training today, I bet you will. We're going to talk about it. Yay. Thank you for sharing that. Maybe some of you others in the same situation. So I walk into your bank and I want to open an account. We're going to talk about the ownership options, and later on we'll talk about authorized signers and power of attorney. So ownership of an account is simply created by checking a box on a signature card. It's terrifying. Okay, absolutely terrifying. So you're going to check with survivorship, no survivorship, individual, and so forth. So why is account ownership so important? Well, they're really, as I said just a minute ago, which box is checked and how the account is titled can actually replace a customer's will and disrupt an entire estate plan. I've been a financial planner for about 37 years, and I've done many, many, many financial plans for clients. Okay. And so it is amazing to me when I would ask my clients, so tell me a little bit about how your accounts are owned at the bank. I see you have 2 checking accounts, you've got 5 CDs, you've got 3 savings accounts. If I ask you, how are your accounts owned? You may know, you may not, but our customers do not. Many of them have absolutely no clue. And so they just checked the box, we slid it across the table, and they signed it. So one of the things in that 20 minutes of training that I had many, many years ago, one of the things they said was, so Susie, here's the deal. This box says with survivorship and no survivorship. Everybody wants with survivorship. So you need to just go ahead and just check that box for them. You don't need to explain it. That's what they want. So that's what I did. Not knowing that with right of survivorship overrides their will. And so I literally was writing free wills at my desk, no charge. Didn't give them an option. You're going to do with right of survivorship. And a lot of our banks are in that situation, or you're doing an alternative, which we'll talk about in a few minutes. So this individual that we're opening an account for has a will and wants everything to go to, their 3 children, wherever the case may be, not this account. This account will not be distributed according to their will. They have a very elaborate estate plan where they've got trusts set up. They're going to be funded by some of these CDs, not these accounts. These accounts are going to go to the other signer on the account. So we'll look at that in just a minute, okay? So an account ownership also determines if an account goes through probate or not. And so our checking a box literally determines how the money in the account is going to be distributed when the account owner dies. So what is probate? So probate is a process where when an individual dies, they go to court and they take the will and they get the will is approved by the judge. And then whatever it says in the will, that's how the funds are distributed. And so the process can be lengthy. You got to, proving in court that the will is valid. You're going to identify and inventory all the deceased person's property, not you, but the individual, the executor or administrator that's been named, and distribute the property according to the will. And that may be exactly what the customer wants. I've got 6 children. This kid's going to get that. This kid's going to get this. This kid's going to get that. And so the bank accounts that we are opening that will go through probate are individual accounts. I'll look at that. We'll look at that in just a minute. Our individual accounts and without right of survivorship accounts. So the 2 accounts that we open that will go through probate are the individual account and will be governed by the individual's will, or the joint account without right of survivorship. The deceased person's part of that account will be driven by their will. The other type of account is the accounts that do not go through probate. And so it bypasses probate. And so bypassing probate means the assets are distributed directly to named beneficiaries or joint owners. So it bypasses the individual's will. Generally available immediately to the surviving joint owners. If I'm a joint signer on the account a signer on the account passes away, I typically have immediate access to the account, non-probate, and available to named beneficiaries within a short period of time after presentation of the death certificate. And so the accounts that are impacted by these 2 options on the left there, accounts that will go through probate is the individual account and the joint with no survivorship, and will not go through probate, will immediately be distributed to the beneficiaries is an individual account with POD, joint tenants with right of survivorship, and joint tenants with the POD. So the ones on the right are override the customer's will, and they need to understand that that's what's happening. So we'll go into great detail more about that in just a couple of minutes. So ownership is created by checking a darn box. That's all they have to do, or by account title. Suzette Jones and Randy Jones, joint tenants with right of survivorship. That's another way that the ownership can be created. So on an individual account, it's pretty simple. One name of the title, owner social security number, one signer on the account, and the signer is the owner, okay? And so what if an individual owner wants to add signers on the account but does not want them to be an owner? So we're going to talk about an individual account owner adding an authorized signer or a power of attorney. That it's still an individual account. And so they've not bypassed their will, they've done none of that. And so we just need to be sure that when I look at the signature card, I understand what the capacity is of each signer. Are they an owner? Is it a joint account? Or are they an agent? Or are they a power of attorney? So we'll jump into that in just a little while. Okay, so a joint account obviously has more than one party on the account. A joint signer cannot be removed without their permission. So if I come in and say, take my sister off, you can't. You can let me close the account and open a new one, but I cannot remove a signer from an account. It requires all signers to authorize somebody to be added. If I came in and said, I want to add my son to the account, my sister would have to approve that as well. And can a signer delete themselves from an account without the knowledge of other signers? Most banks will not let an individual delete themselves without all the other signers knowing it. okay? Because I just wrote a check that's going to overdraw the account, $50,000, get me off that account. And so typically we don't let somebody take themselves off without the other signers on the account knowing it, okay? So the joint account ownership available in Michigan, like I said, is joint tenants with right of survivorship, tenancy by entirety. That's only for married couples. That's also with right of survivorship and the statutory account. So let me just say this. This is a fact. I think you're going to agree with me. When we're opening joint accounts at the bank, really sort of any account, but when we're opening joint accounts at the bank, there typically is not a lot of issue or problems while everybody's living. But once someone dies, it can get pretty complex because of this ownership that we are inflicting on this account. Is it going to bypass probate? Is it going to override a will? Is it not going to bypass probate? So it's very significant and imperative that we understand, what happens. Can the bank continue to allow the surviving co-owners access to the account once they know that somebody has died? We got a joint account and one of the signers died. Do we freeze the account? Do we not freeze the account? Does the ownership of the funds in the account change? Does the account ownership override a deceased person's will? So let's talk about that, okay? So first of all, I want to use a really important word, and the word is party. Is the individual, when we're looking at a signature card, who is a party to the account and who is not, okay? So a party has a present right, subject to request, to payment from the account. Give me money, okay? So both joint signers on the account would be able to instruct you to give them money. Now, if a beneficiary is named on an account, they don't have a present right. They only have a present right when the owners on the account die. Okay, so that's what a party to an account is. Let's say that we have A and B, and A dies, and A's executor comes into the bank and wants to take A's part out. Is A a party to the account? Is the executor a party to the account? It depends. In some cases, you would be able to let them make a withdrawal, all of it, the deceased person's part. In other cases, you would not. So let's jump in. So love this. I know you've heard this. I want to add my daughter to my account in case something happens to me. Okay. So here's my question for that customer. What is the purpose of this account? What are you trying to accomplish? Because we don't have an account that your daughter could only access in case something happens to you. And I know I used to get that all the time. If I go in the hospital, I want my daughter to be able to sign, but only if I go in the hospital. Well, we don't have an account ownership. She's either a signer and has access, or she's not, okay? She's either a party or she's not. And so we could add her as an authorized signer, but we don't have an account where it just says, just in case mom goes in the hospital. That doesn't exist. So what are you trying to accomplish? So does the mother want to add her daughter as a party to the account? Does she want to be able to remove her daughter without her permission? So if the daughter's a joint signer, she can't remove her. If she's an authorized signer, she can, okay? Does she want to allow her daughter to deposit her own money into the account? Does she want to allow her daughter to have access to the account only as an agent, like a power of attorney? Does she allow her daughter to have access to the account if she passes away? Or does she want the account frozen if she passes away? And what's the purpose? What are you trying to accomplish? Okay, let's go back to mom. So mom has, I forgot to mention, $100,000 account, and she wants to add her daughter to her $100,000 account as a joint signer. Okay, so I, like probably many of you, I was that daughter. I was the daughter that lived in town. I was the banker. My sister's in California, my brother's in Colorado. And so my parents lived here. And so I was the person that took care of all the stuff for them. So we go into the bank to open an account. And so what is the impact of adding me to the account as a with survivorship or without survivorship? So the first question is access during lifetime. So if the daughter's added as a joint signer on the account, and here's the question, can the daughter withdraw from the account? Sure. Can she spend the money she withdraws? Yes, she can. Can she deposit her own money into the account? Yeah, it is a joint account. Yes, she can. Can she be removed as a signer? She cannot, not without her permission, because it is a jointly owned account. Okay, so that's access during lifetime. So what about ownership? So access during lifetime and at death. So we're going to read this together. Bear with me, okay? But when a deposit is made in any bank by any person, so mom or daughter, in the name of such depositor, and in the form to be paid to either or the survivor of them, such deposits become the property of such persons as joint tenants and can be paid to either during lifetime or both, or to the survivor after the death of one of them. And such payment shall be a valid and sufficient release and discharge to said banking institution for all payments made on account of such deposits prior to the receipt by said bank of notice in writing not to pay such deposit in accordance with the terms thereof. So your regulations state that on a joint tenants account, which by the way is with right of survivorship, a joint tenants account, is that anybody can take money out, anybody can withdraw, and the bank is relieved of any liability unless we have put in writing that there's a problem with the account. And we're going to talk about that in just a minute, okay? So what happens when an account is opened and only one party contributes to the account? So we've got mom, she's got $100,000, and the daughter's a signer on the account, and she's not put one dime in the account, not one dime. It's got to be clear to the mother and the daughter when they're sitting there opening the account that whether an individual contributes to an account, that daughter has access to all the funds during lifetime and might, depending on the account ownership, own the funds at death of the contributing account, possibly overriding mom's will. Okay, so they've got to understand this, that she can withdraw the money anytime she wants. You cannot take her off. And depending on the ownership, she may actually own these funds when the mother passes away. Okay. And this tenancy by entirety, basically it applies only to married couples. And it basically is with right of survivorship, that if one spouse dies, the other spouse owns 100% of the account. Okay. If just the two of them are on the account. So is there an option for a customer to create a joint account where joint tenants with right of survivorship is not automatic? Because as I described earlier, if you're not describing to your customer other options other than with right of survivorship, you're doing a huge disservice, because our customers don't understand that by adding my daughter to this account for my convenience, that I've just overridden my will. Okay. And that may not be my intention. All right. So is there a way to add the daughter to the account where she's not an automatic owner when the mother passes away? And this is the Michigan statutory joint account. Okay. So this particular statute, one or more persons can create this statutory joint account. And by signing the joint account contract, the bank is going to be agreeable to the contract, obviously, but allows a customer to define access during lifetime, ownership at death, and access at death. And let me see if it's here. I'm going to flip a couple of pages here. The form is on page 144. Okay. And so this is actually a form that is provided by the Michigan statute. And you can either, well, you have them sign this form. This is the contract. And I know it looks like a pain in the neck. And I know it looks like, oh my gosh, why would I want to have this signed? Because in Texas, we have a form almost exactly like this, and it's required on every account that we open, where the customer has to tell us, do you want with survivorship? Do you want without survivorship? Do you want, so take a look at number 5. And, oh, I'm sorry, my dog is coming. Let me just mute just for a minute. I apologize. I will be. The mailman came. I apologize for that. You probably can relate because he is going to kill us every day. Okay, so look at this form. Name of the financial institution, nature of account, blah, blah, blah. name and address of person designated A, name and address of person designated as B. So here's the question. Who can withdraw funds during the lifetime of A and B? You can say A only, B only, either A or B. Now, I realize that the challenge for us in this scenario is, gosh, does the bank have to keep up with this? Well, A is going to be the only signer on the account. Okay, so they're not going to be able to withdraw funds during the account. Who can revoke the contract? Both of them or just one of them? But what I really like is who owns the funds during lifetime. And so we say we own it equally, or A owns 100%, B owns nothing. Who owns the funds and has the right to withdraw if A dies? So if mom dies, it's mom and daughter, and mom dies, does B take it out, or is it A's estate? So I know that it looks complicated. I know that it looks kind of yucky, but there are situations, believe it or not, where a husband and wife do not want joint with right or survivorship. And so, and the reason for that is because they have kids from a previous marriage. So a wife has a $100,000 CD, wants her husband to be able to have access to it in case they need it, but she doesn't want him to own it when she dies. So I think a lot of banks don't use this form because it's a little bit of a nightmare. And instead, they revert to using the authorized signer or the power of attorney. So I can see why you may not want to use it, the banker that said we have it available, but there might be situations where you want to pull it out, okay, where I want my daughter to have access while I'm living and have access while I die, when I die, but I do not want her to own it. That would be a perfect example. I want her to be able to pay my bills. So basically, if the daughter has access while mom is living, does not have access when mom dies, this is basically a without right or survivorship account. There is no survivorship. The daughter does not own the funds when the mother passes away, okay? I just wish I had without right or survivorship as an option. Does anyone have without right or survivorship on your signature card, where it's not a statutory joint account, it's just those are two options on the card, with survivorship, without survivorship? Does anybody have without right of survivorship on your signature card? Okay, Amy, great. Do you use that ownership when you're opening accounts? Amy, no. Sometimes, Sheila, not yet. After today, maybe. Rare sometimes. We don't use it. Okay. No. The past institution I have never used it either. Okay. And so I think that the challenge with our organizations is maybe we don't quite understand what without right or survivorship is. So forget the statutory joint account here. What we're talking about is an account that is at death, ownership doesn't change. So if you have with right or survivorship and we have mother and daughter, when mom dies, the daughter owns 100% of the account. On a without right or survivorship, when mom dies, mom's estate owns mom's part and the daughter owns her part. And so the dilemma and the hysteria is, are we supposed to keep track of that? And the answer is absolutely not. You don't have to keep track of that. That's between the customer and the customer, okay? So withdrawal of funds, liability of the bank. So basically a bank can honor withdrawals of funds pursuant, this is the statutory joint account contract. Let me get past this. So on the, what I'm going to do is, well, let me keep going and then we'll talk about it. So on a joint account with survivorship, two or more parties have access during lifetime, mother and daughter. All the parties contribute, have 100% access to the funds at any time. So this is mom and daughter, they both have access, and the purpose of the account is for everyone to have access. During lifetime, the bank is not responsible for keeping track of who owns what. At death, ownership changes, and 100% of the funds pass to surviving parties. So 100% of the account is owned by the daughter. It bypasses mom's will, and the bank is protected when you release the funds. Okay. So A and B are parties to an account. A dies. Here's the question. Does B have access to the account? And the answer is yes, because it is with right of survivorship. Now, unless you're put on notice, because we saw that earlier, unless you're put on notice of a conflict, but let's talk about that also. I'm sorry, I'll add something to that in a minute. So if it's with right of survivorship, absolutely, the daughter owns the money in the account. And B, the daughter owns 100% and her sisters own nothing. So this is an example of mom who has 3 daughters. And she has a will that says everything's to be divided a third, a third, a third between her 3 daughters. Not this account. This daughter owns everything in the account if you are checking with right of survivorship. Okay. And I suggest you have access. Some banks might freeze the account to stop perhaps payments coming in and that type of thing for the mom. But the daughter does own the account as a joint tenant with right of survivorship. Now, this is the statutory account, but the statute, so on with, let me go back up here. I don't have without right of survivorship in your material. So I'm going to go back up here and talk about with right of survivorship using this example. So if this were without right of survivorship, okay, the purpose during lifetime is still exactly the same. 2 or more parties have access to the account and 2 or more parties can contribute to the account, exactly the same. Same thing, during lifetime, the bank has no responsibility for determining ownership of the funds. But at the death of a party, the difference here is that ownership does not change on without right of survivorship. It does not change. So mom's estate owns mom's part, and the daughter owns her part. And so we know in this scenario that the mom contributed 100% of the account. So mom's estate owns 100%. It does not bypass the mom's will. So this account is still subject to each of the daughters getting their third, and the bank is protected when you release the funds. Okay, so if we have the scenario, A dies, mom passes away, does the daughter have access? She does have access, even if it's without right of survivorship, because we're not responsible for knowing who owns what. Now, if we're put on notice by those 2 sisters in New York, freeze that account, we will. We're put on notice there's a conflict, we will freeze the account. And what part does the mother's estate own? Excuse me, what part does the daughter own? She owns none. In this scenario, she owns none because it's without right of survivorship, and the heirs own their part. So I know that's a little bit confusing to look at, but at the end of the day, the Michigan statutory account allows you to create a without right of survivorship ownership, or if you have without, what I would encourage you all to do for those of you that have without right of survivorship, very simply go into your terms and conditions, and there should be a description of what without right of survivorship is. And what it's going to say is that without right of survivorship means on the death of a party, their portion of the account is owned by their estate. So without right of survivorship, ownership does not change, okay? But everybody still has access because we don't know who owns the money. So yes, mother passes away, we know that. We can let the daughter continue to have access to or put on notice by a party to the account that they can freeze it, that we need to freeze it, okay? So hopefully a few of you will go out and kind of do a little research as to why you have without right of survivorship on your signature card, and what exactly, how would we handle that, realizing that your state statute says that anybody has access to the account until we're notified that there's a conflict. And so even on the with right of survivorship, even if you're notified that there's a conflict, the daughter, if it's with right of survivorship, is still going to get the money, okay, because it does override a will. Okay, so our key takeaways is that many times customers do not know the effect of an account ownership selection. They don't have any idea. And it's important that they understand that joint tenants, that joint account, the with right of survivorship, bypasses a will and an estate plan. And so especially if they're opening an account with a non-spouse, all right? And so don't assume your customer understands that joint tenants overrides their will, because most do not. Just assume they do not, all right? And then as a part of that conversation, when opening that new account, you want to consider gracefully informing the customer that this ownership overrides their will. So I would say to my clients, This account, this ownership, this with rider survivorship does override your will should you have one. Okay. I'm not asking if you have one, but should you have one? Amy, when you say the laws of joint account ownership, I am not, yes, I do. Oh, excuse me. And the laws are in your manual, but I think what I'm trying to describe is that I'm confused with signature cards in your state that have without rider survivorship on them, because it looks like the only way to create a without rider survivorship option is to do the statutory joint account. And so I think that the bank signature card is either not accurate or we're missing something, because you're exactly right. There is no statute specifically in Michigan for without rider survivorship, but there is the statutory joint account that allows a customer to effectively create a without rider survivorship. Does that make sense? If you want to open up your mic, feel free. The son was the account with mom and son was in an accident. Can mom's assets be affected? Yes, great question. If mom and son are on a joint account as either with or without rider survivorship, whichever, and that son is in an accident and son gets sued, yes, mom's assets could be engulfed in that. Absolutely. Great question. So I think that what I find with most banks in Michigan is they just don't mess with this without rider survivorship. They don't mess with the statutory account, because it's just very confusing, and that's unfortunate, because the customer either has to have a joint account with survivorship that overrides their will, or we're going to talk about what the other options are, or they don't want this person to become a joint owner. We don't want to mess with statutory ownership. Instead, we're going to offer the customer an authorized signer or perhaps an in-house power of attorney. So I want to add my daughter to my account, but maintain control. So the mom says, I don't want to put her on as a joint account with rider survivorship. I don't want to have to contact her to take her off. I don't want her to own the money when I die. So what's the other option? Well, the other options are that the customer wants to add her daughter, but maintain the ability to remove her. And she wants to add her daughter without the person becoming a party to the account. So effectively what we're really looking at, and I think what I see in most banks, I didn't mean to confuse you with the without rider survivorship and all the statutory joint account, but we do need to be aware that the only option we're really offering is with right of survivorship. Even though we do have an alternative with a statutory joint account, it's just, it appears to put too much responsibility on the bank. So we have a joint account, but only A can sign, only A can make withdrawals. We have a joint account, but only B, so it gives a lot of options to the customers, but puts a lot of responsibility on the bank. So banks say, never mind, not going to do that. We're going to do with rider survivorship, or we are going to do authorized signer, power of attorney in-house, or power of attorney out of house. Okay. So the authorized signer designation is very simple. It's created in-house on your signature card. Typically, you might have a separate form or the back of a form, but typically it's created on the account agreement or the signature card. And your terms and conditions are going to tell us what that individual has the right to do. But typically, the owner is going to be present for sure. It ceases when the bank is notified of the death of the owner. So let's talk about mom and daughter again. Mom comes in with her daughter, adds her. Once we're notified mom passes away, we're going to remove the daughter. The authorized signer is not a co-tenant, not a co-owner. They have the same withdrawal rights as the owner, but they're not supposed to use it for their own purpose. We don't track that. And they can't deposit their own money into the account, and they don't want to deposit their own money into the account because they can be removed without their permission. So don't put your paycheck in there, buddy, because I may take you off and you don't have access to it. So the account owner can remove that authorized signer anytime and is responsible for their actions. So if that account owner, the account is overdrawn by the authorized signer, it's the account owner that's going to have the problem, okay? Because they are the responsible party, not the authorized signer. Okay, so this may look familiar. You all may have something like this. We have a little area down here for an authorized signer. I find that most banks only allow an authorized signer on a joint account, but I'm not saying that that's the case. You could put it on a joint account if your bank allowed that. Okay, so how many of you use authorized signer? Can I see some yeses? Maybe a better question is, how many of you do not use authorized signer? Anybody not use authorized signer? Amy, no, and Joe, no, you all do not offer authorized signer. Is that what I hear, Amy and Joe? You do not offer authorized signer, correct? Okay. Okay. So maybe in a little while we'll open up the mic. Oh, you do offer it. Okay. Okay, Joe, you do offer it. Okay, great. So if you don't offer it, then do you have it? Well, we'll get to in-house. What about a power of attorney? Okay, let's talk about that. So a power of attorney is where a customer mom gives her daughter the authority to be her okay, great. You offer it and the POD. Perfect. Okay. So the daughter, the mom gives her daughter permission to sign on her behalf. Okay. So one person's the principal and the other person is the agent, the attorney. In fact, we even sometimes call that agent the power of attorney. So Amy says they have a power of attorney, but never heard of an in-house. But yeah, some banks do actually offer an in-house power of attorney, but we'll look at that in just a second. So the agent is the daughter, and she's the person appointed by the principal. An attorney, a power of attorney can be durable, which means that it's not terminated by the principal's incapacity. So if mom becomes incapacitated, it continues. And incapacity means that the person is mentally impaired. They don't have the ability to really evaluate information, to communicate, to make decisions, properly. They might be missing. They might be in prison or outside the United States and unable to return. That could be some definitions of incapacity. So I could bring in my mom's power of attorney and say, no, she's not in the hospital, but she's in a foreign country. And because of COVID, she can't get back. That would be an example of being incapacitated. Okay. Okay. So when I come in with this power of attorney, who is the customer? When an account is opened by an individual who has a power of attorney for the person who's named owner of the power of attorney, who is the customer? So I'm going to talk about in-house in a minute, really looking at out-of-house right here. So a customer, according to the regulations, it's a person that opens a new account. So that's the customer. Or an individual who opens an account for somebody who lacks legal capacity. So if somebody is incapacitated, then a power of attorney, then the agent is the customer because the owner of the funds is not capable of coming in. So they become the customer. Okay, so we're going to identify them, get their driver's license and so forth. All right. So in-house and out-of-house power of attorney. So the in-house power of attorney is exactly the same thing as the authorized signer. Customer comes in, they add the person using a in-house power of attorney form, and the bank honors that POA signature until they're notified that it is to be revoked. Okay, so and the agent signs as agent. So here's a sample in-house durable power of attorney, and so on a power of attorney, when the individual, let me see if I have the next page here. Yeah. So does the attorney, in fact, sign their own name when they're representing the principal? So let's go back to, for just a minute, the authorized signer on your signature card. I just signed Susie Jones, and I'm an authorized signer. I'm an agent, whatever designated signer, authorized signer that's on your signature card, that little box at the far bottom right corner, I just signed Susie Jones. But when it comes to a power of attorney, either in-house or out-of-house, I do not sign my name. I'm signing on behalf of the principal. So we've got the principal's John Doe, and the attorney, in fact, is Mary Smith. So Mary will not sign Mary Smith. She's going to sign John Doe by Mary Smith as agent, POA, AIF, when she's signing checks, when she's endorsing checks, when she's signing anything using the power of attorney. So the only difference between the authorized signer and an in-house power of attorney is the way the individual signs. The authorized signer signs their name, and the in-house power of attorney, they sign on behalf of the owner, okay? So those of you that offer the out-of-house power of attorney, excuse me, those offer the authorized signer, you might offer the in-house power of attorney. Those are great options for that mother who does not want to add her daughter on a joint with right of survivorship. Okay, I hope you're maybe like me, when I had that 20 minutes of training, when they said, like I said earlier, they said, always check with right of survivorship. I was thinking of the hundreds of customers of accounts I had opened where I hadn't given them a choice. And so, that's why we want to give our customer a copy of the signature card, because if mom came in with her daughter and the only option you gave her was with right of survivorship and she dies, and the daughter now owns the $100,000 account, and her two sisters from California or New York come running in that bank and they say, our mother would have, here's the will, here's a copy of the will, everything's to be divided a third, a third, a third. And so the customer didn't know what they were doing. And these two sisters are furious, but unfortunately, the two sisters are not going to have recourse because joint tenants with right of survivorship overrides the customer's will. And they can certainly sue her. That's why it's important that the customer get a copy of everything they signed. So we can say, this is what she didn't know what that was. We explained it to her. It's explained in the terms and conditions. And so the bank really needs to protect itself, because there's hardly ever a problem on an account until someone dies. Happens every day, I can tell you, every day. Okay, so let's talk about the out-of-house power of attorney, and then we'll maybe take a little break. We came back at what, 12:30, 1:30. We'll take a little break at about 1 o'clock, okay? So there are different types of out-of-house power of attorneys. You're sitting at your desk, minding your own business. I walk up and I say, good morning. I have a power of attorney for my mother, and she's a customer here at the bank, and I need to close her $500,000 account. Can you help me? And that's when you say, what? With me, just on the way to lunch, be happy to get somebody who can help you. Yeah. So there are several different types of power of attorney. There's a general power of attorney, which the agent has authority, to do all sorts of things, but it ends if the principal becomes incapacitated. So it's just while the principal is competent. A limited or special power of attorney is for a specific purpose or a specific period of time. I would have customers, and I'm sure you have, who would come in and they're going to go on vacation for 2 weeks outside the country, and they want to put their two daughters on as their power of attorney for that limited period of time in case something happens, they need to get to the account. Okay. A durable power of attorney is the most common power of attorney we see, and this is a general power of attorney that does not cease when the principal becomes incapacitated or mentally unstable. Okay, it does not cease; it continues. That's typically why most people have a power of attorney. And then a springing power of attorney is a power of attorney that only goes into effect when the principal becomes disabled or incapacitated. So if I bring you a springing power of attorney, it only goes into effect when the principal is incapacitated. So I'm going to have to bring you evidence that the principal is incapacitated. So typically the bank's going to request that I bring you one or even two, depends on your bank policy, letter of incompetence from their doctor stating that they are incapacitated. And then that letter is a precondition before I can actually use and execute any activity using the power of attorney, okay? And so when you're accepting a power of attorney, it's a little frightening. It's like, up until about probably 10 years ago, banks were infamous for not accepting power of attorneys. I know when I was in banking, 20 years ago, we had these silly reasons why we could not accept a power of attorney. It's stale. It's more than 6 months old. Well, think about that. People get a power of attorney, they put it in their safe deposit box, and they don't go get it every 6 months and refresh it. It's there until you need it. And so attorneys who were drawing up these POA documents were livid. They're like, this is ridiculous. And the bank says, we have no way of knowing if it is still valid. This thing is 10 years old. We have no way of knowing if it's still valid. So the states all over the country the legislators created regulations to protect banks, and Michigan has that protection. Okay, so the statute for a durable power of attorney says, how is the bank protected? Well, there are a couple of ways. The bank is not liable to the principal or any other person because the third party, the bank, has complied in good faith with instructions from the attorney in fact named in a durable power of attorney, whether or not the attorney in fact is executed an acknowledgement. So let's just stop there. Basically, the statute says you can accept an out-of-house power of attorney. You can believe that it's accurate unless you're notified otherwise. But alternatively, what most banks do is we actually ask that individual, the third party, the bank, is not liable to the principal of any other person if the third party, the bank, requires the attorney in fact named in the power of attorney to sign an acknowledgement complying, saying this power of attorney is still valid. Okay, so the attorney in fact is also protected. If the attorney in fact signs this affidavit saying that the thing is still valid, based on my knowledge, I haven't been fired, I haven't been removed, the individual is not disabled, the individual is not deceased, all of that, the attorney in fact is also protected, which we don't care, we just want to be protected. Okay, so I have a sample of an in-house agent certification form. I'm sure that all of you have one of these, but this is a form that you can whip out for the agent to sign. It's an in-house power of attorney certification affidavit. The form is still valid. The individual has not deceased. I have not been fired. They're not incapacitated. Even if they are incapacitated, the power of attorney is a durable power of attorney. So all of that protects the organization. So the statute says if you get the customer to sign an agent certification acknowledging all this information, you can accept the power of attorney, even if it's 10 years old. Okay. So can an agent open a joint account with a principal? And there is a statute in your state that says a durable power of attorney, before exercising authority under a durable power of attorney, attorney in fact, that daughter, shall execute an acknowledgement of the attorney in fact responsibilities that contain all this language, substantially the same. And one of them says they will not open a joint account with the owner. Okay. So here's an example of a Michigan durable power of attorney. Okay, and let me back up on that. Unless the principal wants them to be able to open a joint account, that doesn't make sense because they're incapacitated. Okay, so page 1, page 2, they can, if you see that second page, the powers, so they have powers to do banking. They have powers to look at the bottom there, manage or deal with my retirement plan, my retirement accounts, because any withdrawal from an IRA account is taxable income to the principal. So they have to be authorized to be able to transact on the IRA account. We don't need to worry about taxes. A lot of people think they've got to check that box for IRA accounts. They do not. You need to check retirement accounts for that. Okay, so the individual, then the principal signs that, and then we have this acknowledgement of the attorney in fact. Okay, so they acknowledge what I just showed you on the previous page. This is actually part of the power of attorney document. This is not the same acknowledgement I just talked about, where the bank has the customer, has the agent sign a form, an affidavit. This is the attorney in fact signing, saying, I will not do these things. I understand that I'm limited to doing these things. And take a look at that and you'll see, let's go back up to that for just a minute. The attorney in fact is acknowledging that, take a look at D, they can't make gifts of the individual's money. Let me look and see, I'm looking for one particular thing. Okay, anyway, that's what the individual signs, the attorney in fact signs, that's how they are protected. Not by signing our acknowledgement, but by signing their acknowledgement that's part of the power of attorney form. Okay. All righty. So I provided in your material a power of attorney review and checklist. If you have a lot of branches, and this is just kind of a guide that you may want to customize for your organization, but or you're welcome to use this one. But basically, what we want is for our team that's on the front line to be able to kind of scan this power of attorney and understand, are we even going to be able to accept it? Not that they will be the one to say that we're not going to take it, because what I find typically happens is, unless you're the person who approves these documents, that the new account person would say, we're going to take a look at it. I'll need to send it to our team that looks at these, and we'll get back with you. But if they look at that power of attorney and they see that the principal is not a customer of the bank, most banks would not accept the power of attorney because we have no information, no documentation, nothing about the principal. So most banks, the very first thing they require when accepting an out-of-house power of attorney is the principal was a customer. Now, you may say, well, Susie, if the agent's a customer, we do it. Well, that's fine if you want to do that. But definitely, I think the principal should be a customer. That really, I think it's a better strategy, but either way works, okay? So what kind of power of attorney is it? And if it's durable, not durable, what kind is it? When is it going to affect? They can scan it. So this thing, then it might have an effective date a year from now. Okay, so we need to make sure that it is in effect. And how many agents are designated, and can they act independently? Are there successor agents named if the first agent becomes incapacitated or quits or gets fired? And then confirm that authority. Can they transact on bank accounts? Can they transact on the customer's business accounts? Can they enter their safe deposit box? Can they transact on retirement accounts? All of that. So that's just an example of something that you may want to do, to allow the customer to kind of verify, help your individuals kind of double check and see if we can even go farther on this particular account. Okay, so I also have in your manual, I'm not going to go through it line by line, but on page 167 forward, I've got several scenarios where an out-of-house power of attorney is presented. And it kind of breaks up into sort of two scenarios where they want to open a new account with a power of attorney for an existing customer of the bank. Okay, so they want to open a new account using the power of attorney for an existing customer of the bank. They've got some checks they want to deposit, whatever. They want to add an attorney, in fact, to mom's existing accounts. The other scenario is the principal's either competent or incompetent, and they're present or they're not present. Because if I come into your bank and I want to open an account for my mom using a power of attorney, but she's competent, my question would be, can she come in? Because if she's competent, she's the customer. Remember, we said that if they're incompetent, then the power of attorney is the customer. But if mom is competent, she's the customer. So she is the one who really needs to open the account and add her daughter to the account. But if mom is not competent and not present, that's fine. That's kind of the whole purpose of having the power of attorney. Okay, so I kind of go through 5 or 6 scenarios where the customer is competent and not present. We're going to wait. If mom's competent, we're going to get her to sign on the account and so forth. Okay, wonderful. Okay, so just in case something happens to me, I'm going to go through just a quick scenario. And we're going to pull all this together. And then we're going to talk about trust accounts after our break. So mom has 3 daughters. 1 daughter lives in town, and mom has a will that says divided everything between my daughters, and she has a $100,000 account. And she wants to add her daughter that lives in town to the account. So it's without survivorship, with survivorship, authorized signer, power of attorney, which one is better? You all don't have without right of survivorship available, but you could create it, if you will, on the statutory account. So I'm not really going to go through the second one, with the statutory account. Okay, so let's just stop here. So I've got a joint account with right of survivorship. So I sit down with the mom and I say, Mom, and daughter, they're both at my desk. We've got a couple of options that we can offer you. What I hear you saying, so help me understand what the purpose of the account is. Well, I want to add my daughter to my account in case something happens to me. Well, let me just share with you, we don't have an account that works exactly like that, but we can add your daughter to the account. And I'm going to walk you through sort of what the, kind of what the options are. I'm not going to say pros and cons, good and bad. I'm just going to say, I'm going to share with you sort of the details of each one of those options. So the first is the joint account with right of survivorship. And what that means is that it allows your daughter access during lifetime and at death, unless we're put on notice that there is an issue. And I'm just going to, going to use this example, so please bear with me. If you pass away, your daughter would still have access to the account, certainly during lifetime, and then at death. Guys, that depends on your bank policy. You may not allow access at death on a joint account, so you would say we would freeze the account and whatever the requirements are to be able for that daughter to be able to take the money out. Some of the things I want you to think about is that your daughter is a co-owner on the account and she could not be removed without her permission. So I just want you to understand that. And if you have a will, this account would override your will. That's all you're going to say. And then she's going to say, what now? Well, I just want to make you aware that if you have a will, this ownership, this with right of survivorship actually overrides your will. So I just want to make you aware of that. And then any legal action against your daughter would impact this account as well. So if we get a garnishment or a lien, this account would be attached also. Okay. And then on the statutory joint account, we could chat about that if we wanted to. It could allow your daughter access, may or may not override your will. So I think you guys aren't offering that. So we'll just kind of park that because it depends on how the account is set up. Now, we also could add your daughter as an authorized signer. So I want to make you aware that this is pretty easy to accomplish. It's on a separate account agreement. She would not sign on the signature card. And I want to make you aware that you would maintain some control where you could remove your daughter if you wanted to. In the previous scenario on the with right of survivorship account, the joint account, you could not remove your daughter, but you certainly could close the account and open a new one, but we could not take her off of the account because she is a joint owner. But on the agent, adding her as an authorized signer on your account or this in-house power of attorney that we have, she'll have access during your lifetime. It does not override a will should you have one. And any legal action against your daughter would not impact this account. Okay, so I just want you indicated that you want your daughter to be able to have access should you pass away. This account, she would not have access if you passed away. And then lastly, if you have a power of attorney document you'd like to bring in and add your daughter to the account as a power of attorney, if you have a separate document your attorney has drawn it, we'd be happy to add your daughter as a power of attorney, as an agent on the account. So that's kind of a scenario walking through. I've given her all the choices. I've not made a recommendation. Okay. Any questions on that? Well, page 171 gives you a little chart. I'm getting big into charts. And what it does is it walks you through sort of the features, I guess, of each of these ownerships. So who can modify signers during the owner's lifetime? Who can access the account when you're notified of a signer's death? Okay, so I'm saying all survivor, also you look at this second column here on joint with right of survivorship, all surviving owners, unless we're put on notice that there's a conflict. Okay. And then ownership at the owner's death, 100% owned by the surviving signers on the account. And then what actions can be taken when the bank is notified of the owner's death. Okay. So authorized signer, power of attorney, just kind of walking you through those are pretty much the same. That individual has no authority really to do anything. They cannot, modify the account. They can't change signers, and their authority ceases at death. All right. Okay. Okay, let's take about a 10-minute break. It's 10 till 2. We have an hour left to cover a lot of information. So if we will take a break, come right back at, let me see, what time is it? 53. Let's come right back at 1 o'clock and we'll continue. I guess it's 5 till 2. If you don't come back at 2 o'clock, just come back as soon as you can. I'd like to start at noon, at 1 o'clock. Sorry, guys, I'm in Central Time. Thank you. See you at 1. All right. Let's go ahead and continue. Any questions before we continue? The comment that someone made have had never heard of an in-house power of attorney. Not a lot of banks have them because they use the authorized signer instead. It's just easier and cleaner and more clear as to exactly what the capacity is of that person. But guys, if you're only offering with right of survivorship and you're not offering the authorized signer, I really encourage you to think about that. I think I've made my point that, you know, as a financial planner, when individuals are not made aware of the ownership of their accounts, I can't tell you how many times we discovered that they had all their CDs and, you know, all their accounts set up as with right of survivorship, when they actually had trusts that were to be funded with the wife's half of the account or whatever the case may be. So speaking of that, let's talk a little bit about trusts, about fiduciary accounts. So a fiduciary obviously is somebody who holds legal and ethical relationship of trust. And so if I'm my mom's guardian, if I'm my mom's power of attorney, I'm a fiduciary. And so you have to prudently take care of that person and the assets of the other person. So we're going to be talking about all these different individuals, talking about trust accounts, guardian, grantor, trustees, revocable, irrevocable, formal, informal. What does all that mean? We're looking at court supervised accounts like guardians, conservators, estate representatives. We'll look at voluntary fiduciaries, which are individuals that take on the responsibility of managing Social Security payments or disability payments or veterans payments. And then we'll talk about how nursing homes do that as well and might come in and open an account. And then we'll talk about opening accounts for minors, custodians, and the Uniform Transfer to Minors Act account. So we got a lot to talk about in an hour. I'm going to try and not talk too fast. I may skip a couple of things in here because I want to make sure that we have enough time to talk about the things you probably do most often. But when you're opening a fiduciary account, everything else is the same except for what identification you get and who you run through check system, who you run through financial history, okay? So we're gonna, first of all, if I walk up to your desk and say, I wanna open an account for my mom, I wanna open I'm a Social Security representative payee, I'm the trustee of a trust, we're gonna determine, does this person have the authority to ask what they're doing? And so we're going to ask for their legal documents. And that's the whole purpose of this session, is to figure out what documents do I get? How do I verify this person has the legal right to do what they want to do? So does the individual have the control they're wanting? You know, identify the individuals who have the authority and have the control over the account. So who is the fiduciary who controls the account? I've got a chart in your manual that kind of walks you through. For the primary fiduciary accounts, we're going to be looking at the Uniform Transfer to Minors Act account, the Social Security Rep Payee, Veterans Affairs, estate accounts, guardianships. This is the fiduciary, the custodian, and what they're called, personal representative. We're going to be looking at each one of these in detail. But at the end of the day, what I find is that most institutions, except for the UTMA, if it comes to an estate account or a guardianship account, they're not running these people through check systems. I mean, they are a court-appointed fiduciary. They do not have a choice, and they don't own the funds. They do control them, but they don't own them. But they're controlling them in the case where they are a fiduciary. Okay, so on a UTMA account, the custodian's the only signer. The child's not a signer, so we would run them through check systems. And then for the rep payee and the Veterans Affairs, they're going to be the only signers on the account, and but the funds are not owned by them. So it really is a matter of what your bank policy is. But I find that for especially the estate account and the guardianship account, running those folks through check systems, they have to sign in the account. So you certainly could monitor the account, and if they do start overdrawing that account, they've got bigger problems than check systems because they are breaching their fiduciary duty. And so they're acting in a different capacity than an individual. Really, all of these people are. And so you may want to consider not running any of them through check systems, okay? So like I said, most banks do not run those folks through check systems, although all of these people, all the signers on the account, the custodian, the rep payee, the PR, and the guardian will run through OFAC, okay? And then when do we use the social security number? We're going to go into a great deal about this. When do I use the social security number? And when do I use an EIN? Because there will be situations where you'll use an EIN on a fiduciary account. We've got 2, 4, 6 options on our favorite form on the planet that we'll wrap up with to show us when we use the social and when we use an EIN. So who are the parties? Let's talk about trust accounts. Who are the parties to a trust? Okay, so we have the grantor or the settlor. When I use the term grantor, I'm also talking about a settlor. But when you see grantor, think of the word giver. That's where the G is. They're the individuals giving the money to the formal trust. Okay, the trust is a legal entity that holds the assets. And then the trustee is the individual that manages and is responsible for the trust. They are the fiduciary. If they mess up or, do something wrong on the account, they are breaching their fiduciary responsibility and they have personal risk. Okay. We can have a trustee or successor trustee. A successor trustee is one who takes the place of the trustee when the trustee dies or resigns or is fired. And then, of course, the trust beneficiary receives the assets when under the terms of the trust. If the grantor dies or they turn 21 or whatever, they get married, have a baby, whatever the requirements are for them to get the money, that's the trust beneficiary. We never deal with the trust beneficiary on a formal trust, okay? Only the trustee. That's our person. So who do you identify? Well, we identify people that are in control. So let's talk about revocable and irrevocable. Those terms sound pretty obvious. A revocable trust can be revoked and an irrevocable trust cannot. What's the difference? We'll talk about it in a couple of minutes because there's a very significant difference between revocable and irrevocable trust other than not being able to change it, okay? So on a revocable trust, this is probably the one you're dealing with the most, where you're probably opening a lot of revocable living trusts. So revocable living trust, the grantor, the giver, and the trustee may or may not be the same person. Very, very often on a revocable living trust, the grantor, the husband, and the wife, their grantors, are also the trustees. Very common. So if the grantor and trustee are different people, though, if we have mom is the grantor and daughter is the trustee, then the grantor still maintains control because they can revoke it. So because the grantor and the trustee is obviously the signer on the account has control, we're going to identify both of them. So identify anyone who has authority. So with the revocable trust account, if the grantor and the trustee are the same person, great, you're going to identify them. But if they're different people, you will still identify the grantor and you will identify the trustee. On an irrevocable trust, the grantor and the trustee cannot be the same person because when somebody sets up an irrevocable trust, it is a completed gift. The money no longer belongs to them. It belongs to the trust. They can't make any changes. They can't change the beneficiaries. Only thing they can change is the trustee, which we'll talk about later. But the grantor and trustee cannot be the same person. So the grantor has no control. So we definitely are going to identify the trustee. That's who we're going to identify is the trustee because the grantor, not a signer on the account, has no control. Okay. So I'm going to walk you through just a couple of examples. In the previous, my previous role at my bank where I was for 22 years, I actually managed the trust department. And so as a financial planner, I met with a lot of clients, helping them understand sort of what a trust is, how it works. I wasn't in the trust department because our trust officers would actually open the accounts. We had a lot of discussions about the benefits of a trust, okay? Because our goal was for us to be named as the trustee. So you have two types of trustees. You can have an individual who's a trustee, which is probably what you're dealing with 99% of the time. Or you can have a corporation like a bank that's the trustee, a corporate trustee. And the pros and cons of that, the benefit of a corporate trustee is that corporate trustees don't die. Individuals do. So that's kind of a nice difference. And corporate trustees might be able to kind of do a lot more things than an individual could. So what's a trust and why do people set them up? Let me give you an example. We had, how many of you play the lottery? You don't have to tell me, but maybe a few of you play the lottery. I usually get 3 or 4 people that admit it in the room. Well, we had a customer who won the lottery. This customer won $30 million. Wasn't a billion, but I'll take $30 million. And what happens when you win the lottery? All of a sudden, everybody on the planet becomes your new best friend. So this individual didn't want anybody to know. So what he did was he took his lottery ticket and he put it in a trust, and he made up a name of the trust. Let's say it's just Made Trust. You can name a trust anything you want. And so what that did, he didn't go pick up the lottery ticket, the trust officer did. So the trusts provide privacy. Okay, they provide privacy. So no one knew that he won it. He was very philanthropic, giving away a lot of gifts. He actually was a CPA in a pretty prestigious CPA firm. He didn't want people to know that his life had changed. Okay, so keeping things private. Trusts are not filed with anybody. When the grantor dies, they're not filed with the court. And that's why people set up trusts. They like the idea that it's private. Had a super wealthy family with 5 children. When we think about trust, we think about rich people. And this dad had 5 kids, 3 of whom were very, very responsible and 2 were not. And so the 2 that were not were calling him constantly wanting money. And it was really becoming a problem for their family. So what he did was, I said he was super wealthy. He put $10 million in 5 trusts for each child. And he had a corporate trustee for all of them. The 3 children that were responsible, so we were the trustee of all of them, 3 that were responsible, he allowed them to have an input on how the money was invested and so forth. The 2 that were not responsible, they did not. And so he made all the trusts irrevocable, okay, all 5 of them. And so those children now, and I say children, they were in their 50s and 60s. The dad was in his 90s. They're calling and needing money. And the trust had very specific reasons they could get it out. Medical expenses, very, very specific reasons. And so all of a sudden they were really, really sick. So they would call the trust officer almost every day, needing money. My teeth hurt, my foot hurts, my eye hurts, my whatever. And so it made for a much more pleasant Thanksgiving for the family, because those 2 could now complain about the bank instead of complaining about dad. Okay, so I know all of us want to control our kids, right? I mean, I know I do, but I can't. The kids are, 30 and 33. But we had a dad who wanted to control his son. And so he put a very specific stipulations in the trust. And you have to understand that as a trustee, the bank would be the trustee. We have to adhere to those. And if there are provisions in a trust that says they only get the money under this situation, and you give it to them under a different situation, the trustee is liable. So his first stipulation was that his son had to graduate from college. We can monitor that as a trustee, no problem. The second requirement was that he could do no drugs. So you're thinking, well, how do you do that? Well, actually, as a trustee, we could do random drug testing on this beneficiary. So yeah, we can. But the third was a little bit of a problem. He said, no tattoos. And we said, nowhere? He said, nowhere. And we said, well, we don't typically strip search our beneficiaries, so we didn't win that account, okay? But those are just examples of why people might set up trusts. The bottom line is it's really all about control. You can say they cannot have the money until. I had a cousin who, when my uncle died, he was like 40, and he left a trust to his son, but he said he couldn't have a dime of it until he was 65. So yay, that was fun. So the benefits of a living trust is that living trusts avoid probate, okay? And we talked about probate earlier. I'm going to give you another example in just a minute. All trusts preserve privacy. It can be an estate planning tool. It protects a grantor in the case of incapacity. Wonderful, wonderful reasons. We see a lot of trusts set up for special needs, where a mom has a special need child, she sets up a trust, and the trust will be funded when she passes away, let's say with their life insurance. And so it's a way to take care of special needs children or minor children and so forth. Okay, so let me see, I got a little comment here. And that control, I'm sorry, and yeah, Michael, good comment. And that control goes to controlling from the death, controlling from the grave. Is that what you're saying? Exactly right. I mean, that is why people like trust, is because they can actually control their children even when they're no longer here. Exactly right. Okay, so we're going to look at comment. Yeah, you got it exactly right, which is probably the primary reason people set them up. But we've got formal trust and informal trust. So a formal trust is created outside the bank, and an informal trust is created in the bank. So we're going to talk about POD accounts and uniform transfer to minor act account. So we're going to start off with formal trusts. So a formal trust can be revocable or irrevocable, and it can be a living trust or a testamentary trust. So what's clever is a living trust is called a living trust because it was created while you're living, okay? A testamentary trust is called testamentary because it's created when the individual dies. So those are really the two type of formal trusts, living trust and testamentary trust. A living trust can be revocable or irrevocable, and a testamentary trust is always irrevocable because once it's created, the individual, the grantor, is no longer living. All right. So the three main reasons that people want to avoid probate and trusts accomplish them. If you have to go through probate, the time to distribute the assets, the potential cost, lack of privacy, you have to understand that probated wills are public information. So we can go look up Elvis Presley's will and see who got what and who didn't, because once a will is probated, it is public information. So I'm going to spend just about 2 minutes talking about gross estate and why we care. Okay, I think this will help you understand why someone would set up an irrevocable trust when they can't change it. That gentleman that we had who had the 5 children, who set up those irrevocable trusts for his 5 children, the $10 million, he couldn't change them. Well, he realized that his kids were figuring out way, the 2 irresponsible ones, to get money out. Well, he wanted to change it. Well, he couldn't. But when we talk about when someone dies, there's this asset, it's called your gross estate. So when an individual dies, the IRS says, if your estate exceeds 11.7 million, that was in 2021, I think this year it's maybe 12.6. But if your estate exceeds a certain dollar amount, anything over that dollar amount will be taxed. Again, because you earned it while you were living, and now you're going to pay tax on it again. So the IRS doesn't care if it goes through probate or doesn't go through probate. So that's why when an individual comes in and closes out their mom's IRA, there could be tax associated with that because it might exceed, the estate could exceed those dollar amounts. So when someone passes away, their gross estate is added up. And that dollar amount, if it exceeds a certain dollar amount, they're going to get to pay estate tax. It's also called death tax. And so again, the IRS doesn't care if it goes through probate or doesn't go through probate. All right. So the way it's distributed does not matter. So I don't want you to think that if an account doesn't go through probate, that it's not part of the gross estate. It is. Everything that an individual owns when they die is added up in the gross estate, except for a couple of things. It's all about control. So trusts can be used to reduce a decedent's gross estate. Well, how do you do that? Well, a revocable trust, remember earlier I said that a revocable trust, the grantor maintains control. Well, because they maintain control, then anything in the revocable trust is added up in that gross estate. So if they have, millions and millions of dollars in their trust, it does not prohibit them from paying estate tax, because they really never gave it up. They have a wrapper around it. It won't have to go through probate, and they've got named beneficiaries that immediately will get the money, but it definitely does not help them from an estate tax perspective because they've not given it up. An irrevocable trust does that. That's the whole purpose of an irrevocable trust. It is to get money out of your estate while you're living. And so if a grantor retains none of the benefits, they can't revoke it, they can't amend it, no right to the income, no right to return of any of the principal, the transfer is complete. And the grantor's property is not included in the grantor's gross estate. I say generally because they have to do it at least 3 years before they die, because the IRS says you cannot on your deathbed. So everybody come in here, $1 million for you, $1 million for you, $1 million. Hey, nurses, get in here, $1 million for you, $1 million for you. You can't give it away, a week before you pass away. You have to plan. That's what estate planning is all about. So you have to plan that when you pass away, this money will be distributed, but you have to give it up while you're living. So that's why you say, why would somebody do that? That's the reason, because their estate is very large and they're trying to prevent from having to pay estate tax. Okay. All right. So revocable trusts are included in the gross estate, irrevocable trusts are not. The whole purpose of that for you guys was just for you to understand why people would do an irrevocable trust. So we're going to cover how to know if a trust is valid, who has the authority to open it, what ID number do we use, what happens if a signer dies, and how do we title the account. So a trust account is just a depository account. You guys are not acting as trustees, you're just opening an account for a trust. Unlike our bank, we had a trust department that actually managed the trust, and we had a bank attached to us. We'd go down and open accounts for the trust, but you guys are just opening an account, and the role of the bank is just to be a depository for those funds. We got the trustee. That's who we're going to deal with, is the trustee. And so when somebody comes in and wants to open a trust account, we're going to ask them, do you have a formal trust agreement? If they say yes, fantastic, then we're going to ask them for, documentation we need. If they say no, or more like, what's a formal trust agreement? Then we're going to proceed with our favorite questions. Is there a specific reason why are you using the word trust? What is the purpose of the account? What are you trying to accomplish? Well, I was at a cocktail party last night. They said trust accounts are great. I want to open one. Okay, so we're going to have to help them understand what are you trying to accomplish here. So if we're opening a formal trust account, there are 6 things that we're going to want to get from the customer. We want to get, these 6 things. We want to get the name and date of the trust, because it's going to be in the account title, the name of the grantors, because we're probably going to use their social security number, the name of the trustees, we're the authorized signers, successor trustees take over in the event that the trustee dies. Is the trust revocable or irrevocable? Because that will decide if we're going to use an EIN or a social security number. And then the powers of the trustee, do they have the power to, handle transactions? And 99% of the time, they always do. And then what about documentation? So some banks require the entire trust agreement. Don't have an opinion on that. If you want it, just read it, okay? But I would venture to say that most of your customers do not want you to have the entire trust agreement because they want privacy. So there are kind of a couple of other options. Many times the customer will bring you what's called a memorandum of trust or a certificate of trust provided by their customers, kind of like the cliff notes of their trust. And it gives us those 6 things we need. It is signed by the grantor and it's notarized. Another option is to take the trust agreement, but just use the first couple of pages and the signature pages to get the information we need. And then you also, I would encourage, have your customer complete an in-house trust account certification form where they are attesting these are the 6 pieces of information and that the trust is, you are still the trustee. And I think I have a sample of that on page 181 in your manuals. It's a sample of a trust account certification. You're still going to get the other stuff, either the first couple of pages, last pages, memorandum of trust, but you also want them to certify that the trust is still valid, that they are still the trustee, okay? So actually opening a trust account, let's kind of walk through the process. So just quickly, trusts are very popular in lieu of a will. And the primary reason is because, as I said a minute ago, a will is public information. It is time consuming. If you've been the executor of an estate, it can be expensive. You got to go, all the assets have got to be renamed in the name of the estate. And nothing goes into effect until the owner dies. Whereas with a living trust, while the grantor is living, they transfer everything into the trust. And so when they die, that's already done. And so they're a named beneficiary. So they're going to transfer not only their bank accounts. I know when living trusts started getting really popular, a lot of individuals would ask, what are people doing? And they're putting money in their living trust to avoid probate, because everything then is passed out to their beneficiaries. So if we're opening a revocable formal trust account, we're going to get the document. We're going to title the account, Bob Doe, Grantor, Doe Family Trust. UTAD stands for Under Trust Agreement 12/28/2002. Or you can just put that date somewhere on the account agreement. It doesn't have to be in the account title. If a trust is amended, the title of the trust name never changes. Okay, if it is Doe Family Trust or Smith Family Revocable Living Trust, that never changes, okay? If a trust is amended, the title of the accounts is the same. They just add amended, as I have the bottom here, a certain date, but the title of the trust will never change. Our trustees are going to be our signers on the account. We're going to use the grantor social security number on the account, and we're either going to get a memorandum of trust, that first couple of pages, and then we're going to get the customer to sign the trust account certification, okay? And so I get this question a lot. Susie, what's the difference between an amendment of a trust and a trust restatement? Sometimes people will just make a couple of changes to the revocable trust. They want to change a beneficiary, they want to change a trustee, they want to change some of the provisions, but it's really pretty much the same. So that's an amendment. A trust restatement is where there are so many changes that have been made, it's just easier to start over. And so they restate the trust, okay? They go through and make a complete restatement and an amendment and complete, or an amendment and complete restatement. Again, the name of the trust does not change, okay? It'll just say Jones Family Living Trust restated this date, okay? So if a trust is amended or restated, I've got this in your book, does the name change? I've said that several times. It does not. The original name of the trust never changes. If it's amended or restated, we just add that to the account title. Amended December 2, 2020, or put it somewhere on your account agreement. Does the name of a revocable trust change when the final grantor passes away and the trust becomes revocable? Get this question all the time. So Doe Family Living Trust, that's not going to change. What is going to change? So we had John Doe, who was the grantor and the trustee of his trust, John Doe Revocable Living Trust, still going to keep that name, but now instead of using a social security number, we're going to use an EIN. So when the trustee goes online to the IRS to get that EIN for the irrevocable trust now, what he's going to do is going to put the name of the trust, and it's going to say, what's the status? And the individual will put irrevocable. It's kind of like me coming in and saying, I want to change my accountant's name is Suzette Jones, and I want to change it to a savings account. It's still going to be, it's just because the type of trust it is changes, doesn't mean that the name changes. The name will never change, okay? So upon the death of the grantor, does the bank need to close the account and open a new one? Well, that depends on you. We typically close them and open a new one, okay? Because the name doesn't change. However, the TIN does. And so here's the challenge. If this account is a checking account, it may not be that big a deal. But if it is a savings account, you're going to have to divvy up the interest between the part where it was a revocable and the part where it was irrevocable. Because when it was revocable, all the income is taxable to the individual, to the grantor on their personal tax return. When the individual passes away, the trust is going to file its own tax return because now it has an EIN, okay? It'll be taxable to the trust, okay? Okay, so it's really up to you. I think it might be cleaner to close it and open a new one, but you're not required to if you don't want to, okay? So when we're documenting changes on a trust, I'm gonna walk you through an example. I've got all this information in writing for you, but let me walk you through an example, okay? We've got John and Mary Doe, they're grantors, Doe Family Living Trust, and John dies. They're the trustees and they are the grantors. John dies. And so what happens if John dies? The trust remains revocable. And all we're going to do is change the social security number on the account because Mary now is a surviving grantor and we're going to put Mary's social on the account. That's all we need to do. Okay. Still Doe Family Living Trust. And then if Mary dies, the trust becomes irrevocable. And so at that point, we need an EIN. And Tom Smith now is a successor trustee. So Tom was their son. We had John and Mary, who were the trustees. They pass away, and Tom Smith is the successor trustee. So now Tom becomes the trustee, and he will either open a new account, Doe Family Living Trust, and put the TIN on it, or just if you allow him, he can change the TIN, the social security number on the account to the trust TIN. All right. We talked about that earlier, so I'm going to skip it for now. Let's talk about opening irrevocable trust because we're kind of running a little short on time here. Okay, so an irrevocable trust, as we said earlier, is a trust that the owner cannot change, the grantor cannot change. It's a completed gift. A testamentary trust is also revocable because once an individual dies, the trust is funded, and that's when it becomes a trust. Okay, sorry, get back here. So the trust is created under instructions of the will, and it's funded with assets from the owner or, life insurance, whatever the case may be. And so examples of account titling, Doe Family Irrevocable Trust, and then for the testamentary trust, Mary Smith Testamentary Trust for the benefit of John Smith. So testamentary trust, that's the beneficiary, John Smith, or just Mary Smith Testamentary Trust. Don't have to have the beneficiary's name in a testamentary trust account. And the authorized signer is going to be the trustee. Upon the death or removal of a trustee, the successor trustee steps in. And we're going to use the trust's EIN on an irrevocable trust. Now, let me give you one little scenario here. Let's say that I set up an irrevocable trust and for you, and it's $10 million. Just, let me just pick somebody here. Who am I going to give $10 million? Well, Teresa, your name is always front and center. So Teresa, I'm going to give you $10 million. Amy, the question is, it does have to say testamentary. If it is a testamentary trust, yes, although it is irrevocable. So kind of divvying up, if it's an irrevocable trust that resulted from a living trust, okay, so living trust was revocable, now it's irrevocable because the grantor died, that's going to have irrevocable in it. Excuse me, it's still going to have revocable in it. I mean, we're never going to change the name of the trust, okay? You've only seen irrevocable. For testamentary trusts, okay, then I've only seen testamentary. So I'm sure both of us are right. I'm sure that you don't have to have testamentary trust. It's just nice to know that it came, because we then know that the document that set the account up as a will, it's not a trust agreement. We're not looking for a trust agreement. We're looking for actually the portion of the will that created the trust. But it's not wrong. I'm just saying that typically putting testamentary helps clarify that it did come from a will, not from a trust agreement, other than that in a will. So that's a great comment. And I'm not going to say it's wrong. I'm just saying, I guess we have the option of doing both. Okay. Because I want to say that I'm not saying this is in stone, that these account titlings are in stone. They are typically what organizations do. But if you open it just Mary Smith Irrevocable Trust, for the benefit of John Smith, it's just Mary Smith Irrevocable Trust, to me, it would look like there's a trust agreement that was created. But anyway, that's great, because I can set up an irrevocable trust while I'm living. I don't have to die for the trust to be irrevocable. Okay, no problem at all. Maybe, okay. So thanks for pointing that out. So for the testamentary trust, the individual, it's created under the terms of the trust. So let me just say this, I can't just bring in the will and say, okay, so my mom passed away and here's the trust. I want to open a testamentary trust. It has to be submitted to court. And then once that will is submitted to court for authentication, and once the will is authenticated, that is the date the trust started, not the date that the grantor passed away, but the date that it was submitted to court and that it actually became funded. Okay. Is this why you have is this why a trust? Why? Oh, if they have a trust, why would they also have a will? This is a good question, Sheila. This is a situation where they don't really have the trust. You're talking about the testamentary trust. You're completely right. If an individual has a trust, they would not have a will. But this is a scenario where an individual is creating a trust in their will. They don't have the money to fund a trust today, and they have a special needs child or a minor child, a mother who is elderly and is, not able to take care of herself. So this is a testamentary trust. That's why I was indicating we like to see the word testamentary in the name of the trust. It tells us it was created in a trust. Okay, so once that mother passes away and her will is authenticated, at that point, the trust is created and it is irrevocable because the grantor is deceased. And the effective date of the trust is the date that it was authenticated, not the date that the grantor passed away. Okay, so very, very, very good question. Okay, so we know that the grantor cannot change anything about the trust except for the trustees. Okay, I'm going to skip employee benefit plans for now. If we have 3 minutes and we're done, you can read about those if you're opening accounts for KEO accounts or 401k accounts. And if you have a lot of them, feel free to give me a call after the session. You'll have my phone number and I'll be happy to go through them with you. So now we have informal trust accounts created in the bank. We have the payable on death account and the UTMA. So here's the deal, guys. A payable on death account is not an individual account. If I have an individual account and I put a POD on it, it is no longer an individual account. It is a revocable trust. It's an informal revocable trust created in the bank. And as a matter of fact, it's separately insured from my individual account. So it is not an individual account. It is a revocable informal trust because there are no documents outside the bank. The Uniform Transfer to Minors Act account is a irrevocable trust set up in the bank for the benefit of a minor. So it's created in the bank with a particular account titling, so it is an irrevocable informal trust account. So what's an informal trust? The payable on death account, the revocable informal trust account. And the UTMA account is an irrevocable informal trust account. So it's going to be important in a minute when we talk about those little POD accounts on sole proprietorship accounts. So we know that POD is payable on death. It's very, very clear what the purpose of this account is. That when an individual dies, they want the money to go to a beneficiary. Now, let me go back to my lovely 20 minutes of training I had 45 years ago. In that training, they said, now, Susie, in addition to the pink card and the green card, in addition to always checking with rider survivorship, we do not want to lose deposits. So if a customer says, oh my gosh, at the time, it was $100,000 in coverage, but now it's $250,000. You know, my money's not insured. What if this bank fails? Well, I would say no problem. We can open a POD account and you can put your 10 grandchildren on the account and your $100,000 account would be totally insured because each beneficiary insures the account for $100,000. Today, you can open an account for $1 million and add 4 beneficiaries and it's insured for $1 million. Oh, but I also forgot to mention that it bypasses your will. They didn't tell me that back then. I had no idea. So I'm setting up POD accounts left and right so the customer is insured, obliterating their estate plan and their will. So, it's the hair on the back of my neck begins to raise up because the lack of education of our customers and of our bankers is really frightening. I mean, it's really frightening because we're pushed to say this without explaining all the pros and cons. Okay, it does avoid probate, and that's great. It bypasses the customer's will, and it increases the insurance. Okay, so it's very important. A customer should establish a POD account first because of their desire to name beneficiaries and bypass their will. And secondly, to benefit additional insurance coverage. It should not be reversed. Don't do it because you want insurance. Do it because you want to bypass your will and you want to name beneficiaries, okay? Many of our customers do not understand. They've just overwritten their will, okay? So we're going to title the account. There are a couple of ways we can do it. John Doe POD, John Doe POD, Kathy Doe, just John Doe. And so if we title it John Doe POD on your signature card on your account agreement, you're going to name the beneficiaries. If it's titled John Doe POD Kathy Doe, the beneficiaries in the account title. Most customers want it just titled John Doe, and then we put the beneficiaries on their on the account agreement. By checking POD on the signature card in your account system on your bank, it is segregating it as a revocable trust account. So if FDIC came in tomorrow and said, give me a list of all your POD accounts, you should be able to do that because it is segregating it. I want all the individual accounts, I want all the joint accounts, and I want all the POD accounts. So even if you just title it John Doe, it's not an individual account, it is a revocable trust account. Okay, so there is no documentation. The titling of the account, checking a box on your signature card creates that. The owner is going to be the signer on the account. And we're never going to use a beneficiary's social security number on an account, but we'd like to get that number as well as your date of birth so we can identify them later when the individual comes in and wants to claim the money. So they can designate as many beneficiaries as they want. To increase the insurance, the beneficiary has to be a person, a charity, or a nonprofit organization. Although I could put anybody as a POD beneficiary, it just may not be separately insured. Okay. Difference between POD and ITF. That's the question. What's the difference between POD and ITF? That is a beautiful question. And here you go. Great question. So ITF is also an informal revocable trust. It's also referred to as a Totten trust. It's exactly the same thing as POD. Great question. Just fed me right in there. This account was created many, many years ago, literally because of Mr. Totten. Mr. Totten went into a bank in the 1950s and said, I want to open an account, and when I die, I want my daughter to get the money. And the bank said, we're going to title the account Bob Totten in Trust for, or ITF, or ATF, or as trustee for Sally Totten. So that's what an ITF account is. And so the problem is that, well, there were two problems. The first problem was that when Mr. Totten died, his daughter went in, and what the bank had said is that when you die, we'll give this money to your daughter. It's a, it's a as trustee account, a trustee account. And so when the daughter came in and said, I'm here for my money, the bank said, we don't know what you're talking about, because the banker that had set it up was no longer with the bank. And so she said, well, I'm going to sue you. And she did. So when she sued and she won, that's where the Totten Trust or the ITF account was created. So both the Totten Trust and the payable on death, the purpose of them is to transfer money upon death to a designated beneficiary. The only difference is the word trustee. Payable on death, or a trustee for B. And so I strongly discourage using the ITF because the payable on death is extremely clear what the intention was. If you use ITF or as trustee for, it can be very confusing. And we don't know if there's a trust agreement outside the bank, because remember, with a trust outside the bank, we never deal with beneficiaries. With a trust in the bank, we always deal with beneficiaries when we have a POD or informal revocable trust account. So I would not use ITF. It's not clear. Like I said, we really never have a problem on an account until someone dies. And this is one of those scenarios that could be very, very confusing. Okay, so we're going to pay out to these POD beneficiaries, get the death certificate. We're going to identify the beneficiaries. Management normally, or supervisors, going to want to review that death certificate and verify the named beneficiary's identity. The POD beneficiaries now become a party to the account, and they can actually withdraw the money. And so once we verify, the bank will issue checks payable to each beneficiary. Okay. So it does make a difference, though, when the beneficiaries died. Okay. Let me look at one thing here. Yeah. So let me use this example. So mom is the account owner, and she divides the account equally between her three daughters. She's got mom POD to her three daughters. And so scenario one is mom passes away and all three of her daughters are living. So that means that each of them get a third, a third, a third. Okay. And then scenario number two is one of the daughters passes away and then the mother passes away. So if a beneficiary predeceases the owner, then the account is only divided 50-50 among the two surviving daughters. However, if the mother passes away and then one of her daughters passes away, it's divided a third, a third, a third. A third to the two surviving daughters and a third to the daughter's estate, because she was alive when her mother passed away. So the timing does matter. So we may need, if they say that one of the daughters is deceased, we are going to need a copy of her death certificate to see that she died before the mother died or after the mother died. Okay. Okay, can a sole proprietor add a POD beneficiary to their account? We talked about this earlier. But what I want you to, I'm not going to read all this. We talked earlier about how it's not really a good idea, but here's the deal, guys. Most of us open sole proprietorship accounts as a business account. When you add POD to an account, it becomes a revocable trust account. It's a POD revocable trust account separately insured from the individual's personal accounts. So if you put POD on a business account, first of all, is it even going to be reflected as a POD account? And then secondly, this is a business account. Do you even have, some banks do set up sole proprietorship accounts on their consumer platform. And if you do that, you might be able to figure out a way to get POD to attach to that account. Because you're not going to check individual, or maybe you are. I've had banks that actually do. They check individual and then they add a POD beneficiary. But I just think trying to work around all that is really not the most effective way. And many times our customers don't understand what they're doing. They inadvertently put POD on the account and they just don't understand the consequence of that. And so I just think, from your perspective, I wouldn't do it. We did not allow it in our organization because it was complex. And we didn't want the owner to think that he was leaving the business to his wife, because he's not. She's getting the money in the account, but that account, that business can't be given away on a signature card. So it just has lots of hair on it, is what I say. That's what we say down here in Texas. Okay, so on our form here, let's take a look. We've got look at number 5. This is the usual revocable savings trust, like a POD account or Totten trust. Usual revocable savings trust, that's the grantor is also the trustee. That's a payable on death account. Use the grantor's social security number. Look at number 6. This is for the revocable living trust, sole proprietorship or disregarded entity by the individual, by an individual. The IRS says you've opened a revocable trust. That's revocable living trust. That's fantastic. When you die, the money is going to be distributed to your beneficiaries. It is going to bypass probate, but those assets are part of your gross estate. You have not given up control. Everything coming out of that account interest-wise is taxable to you. So you're going to use your social security number on a revocable living trust, okay? Because they haven't given up anything. They benefited because they can go through probate and have not go through probate and have named beneficiaries, but that's the only benefit. So yeah, we're going to use the owner's social security number. It is a disregarded entity from the IRS perspective when it comes to taxes. The grantor trust filing under optional method. This is where a grantor, I forgot to use my example. I give you $10 million. I think I dropped that ball. I give Teresa $10 million. You're going, yeah. Can you tell me more? Can you tell me more? I give Teresa $10 million. And I say to her, Teresa, this account earns a lot of interest. It's taxable to the beneficiaries. And so I'm not going to make you pay that tax. So the grantor, as the grantor, I could alternatively say any income that's taxable to Teresa, I will pay. So in that very rare scenario, we'd actually put the grantor's social security number on the irrevocable trust account. Doesn't happen often, but it does happen on occasion. A valid trust estate, this is just a normal trust account. We're going to use this is where you have a valid trust account that is irrevocable, just a good old all-American trust account. And so we're going to use the trust's EIN, and at the bottom the same thing. This is a irrevocable trust. We're going to use the trust's EIN. Okay. All right. Okay. Let's talk about opening accounts for children. So can you open an individual account for a minor? Your statute says you can. When any deposit of money shall be made in any bank or trust company by or in the name of a minor, the same should be held for the exclusive right and benefit of such minor and shall be paid together with the dividends of interest thereto to the person in whose name the deposit shall have been made, and the receipt or acquittance of such minor shall be valid as sufficient release and discharge of such deposit and thereof to the corporation. So basically, if a bank wants to allow a minor to open an individual account, they can. I don't find a lot of banks that do. They typically would prefer that the minor open a joint account. Now, there's always that exception if they're 16 and they're working and they have a driver's license. But I do find that most banks really want to open a multiple party account with the minor and have the minor social on the account, that's fine, but have mom and dad or mom sign on the account as well, okay? So here's the question. Get this a lot. So Susie, we open accounts for minors and the minors don't sign on the account, but we use their social security number and mom signs for the minor. So what the FDIC says is in order for an account to be a joint account, that all the signers have to have equal access, anybody can withdraw, and they must sign the signature card. However, a recent amendment to the FDIC regulations has changed the definition of what it means to have signed a signature card. What they've said is that if the FDIC comes in and they see a signature card a child has not signed, then if the bank can prove that the child accessed the account using an ATM or accessed the account with their own login online, that would be considered they are a joint signer on the account. Most of us are not going to do that for a 2-year-old or a 5-year-old. So, it's not a joint account. Now, that means it's not separately insured for FDIC. And so if that's not a big deal, if your bank wants to continue to do that, I wouldn't recommend it. What I would recommend is we look at doing the Uniform Transfer to Minors Act account. So the UTMA account is a way for a bank to open an account for the benefit of a minor. And so the way this account is created is with the account titling. So Billy Smith, minor, Mary Smith custodian under Michigan Uniform Transfer to Minors Act account. And so grandma comes in, she wants to open an account for her grandson. That's me. I want to open an account for my grandson, Jay. He's 2 years old. He's adorable. And so I am the transferor. I'm transferring the money to him and I put my daughter on as the custodian, or I can be the custodian, okay? And so once the child turns 18, the child has access to the funds. So the funds will be turned over to the child when they turn 18. There is no documentation. The account titling creates it. The statute allows one custodian on the account, although the custodian, the transferor, can certainly add a successor custodian on the account, okay? And then when the custodian dies and resigns, and let's say that what if the custodian dies, resigns, and no longer can serve without, and did not name a successor custodian? If the minor's 14 years or older, they can designate a successor custodian, an adult member of their family, a guardian, or a trust company. If the minor is younger than 14 years old or fails to act in 60 days, then the guardian, the minor's guardian becomes a successor custodian. And if there is no guardian, then the legal representative of the transferor, my executor, could name someone, or an interested party could go to court. Okay, so it gets a little hairy there. Can the custodian close the account? Yes, great question. Can the custodian close the account before the child is 18? Yes, they can. They cannot give it to them after 18, but they could release it to them before they're 18. Okay. So if you're going to close an account, I would suggest that you make the check payable to the account. So custodian comes in, wants to distribute the money to the child. The custodian withdraws the funds, and we'd make the check payable to Johnny Doe, minor by Sam Doe, custodian under Michigan UTMA. The custodian would endorse the check just like that. Johnny Doe by Sam Doe, custodian under MUTMA. And then they would then further endorse it, pay to the order of Johnny Doe by Sam Doe, custodian. The child would endorse it. They can either cash it or open an account. It's a nice, clean trail of how the account was closed and who closed it. Okay. Okay. We've got looks like about 10 minutes. I'm going to go through estates and guardianships. The information for these accounts is really pretty simple. An estate account, obviously, open when someone passes away. And what I like about opening estate accounts is it's pretty black and white. There are documents we can request. In your state, the individual who handles the estate of an individual is called a personal representative or a PR. And that person is approved by the court to handle the estate of the deceased person, okay? Now, if the estate's very, very small, they're not going to go through probate. The family members can actually go through an expedited small estate probate process. And they would actually bring you a copy of this document, affidavit of decedent successor for delivery of certain assets owned by decedent. So if the decedent's estate is less than $15,000 or less in assets, it's been 28 days since the individual died, and no one has applied to be a personal representative, the simple affidavit to claim the assets can be presented and distributed to the individual. Okay, so that's a small estate affidavit where the individual is not going to go through probate. But if they are going to go through probate, then the estate's been probated, then we're going to get letters of authority for the PR. And so the PR is going to bring in the documentation. We're going to title the account Mary Doe Estate Account, Sam Smith PR. We're going to use the EIN of the estate, never use the deceased owner's social security number. We're going to ask for the affidavit of decedent successor. Now, actually, ignore that because those individuals rarely open an account. If they do open an account, then we are not going to put estate in the account title, okay? But letters of authority for personal representative, you're just going to ask for the affidavit if they're not opening an account and just want to close it. Authorized signer is going to be that PR, and we are going to add or delete signers only with an amended court order. Sam Smith, who's the PR, can't say, I travel a lot and I want to add my sister to the account. If they're not on the letters of authority, they cannot be added to the account. Okay, so estate accounts are pretty simple in that you're either the PR or you're not. I'm going to ask for that court order. And sort of the same thing for guardianships and conservators. Now, a guardian is someone who is appointed typically to handle the person's needs, and a conservator typically handles the assets of the person. But a guardian can apply to the court to be both. But normally it's a conservator we're dealing with when it comes to the assets of an incompetent person or a minor, and the guardian takes care of their welfare, but a guardian could be also taking care of their financial affairs as well, okay? So we're gonna get a document called guardian of the person, guardian of the estate, where they can manage the financial affairs, and guardian of both the person and the state. So if it's a guardian, it's got to be either number 2 or number 3. We cannot accept a guardian of the person to open an account or handle an account for a guardian, okay? And a conservator is limited to handling the financial affairs. So we're going to ask for letters of guardianship or letters of conservatorship. We're going to use the minor or the protected person's social security number, and the authorized signer is going to be that guardian or that conservator. If they want to add somebody to the account, they're going to have to get those letters of guardianship or conservatorship amended. And then the last account we're going to look at is Social Security Representative Payee and Veterans Affairs Fiduciary. So this is where we have an individual. There's sort of 4 potential fiduciaries. We have a Social Security Administration, a fiduciary who's a representative payee, supplemental security income, which is disability income, representative payee, Veterans Affairs, which is a federal fiduciary. They handle money for those individuals, and then an organization serving as a collective account. So we probably see these a lot where we have an individual coming in. So again, I'll use my husband as an example. Let's say that he has had some disability issues, and now I'm going to be taking the money for his Social Security, and I'll be handling it for him, or his veteran. He's not a veteran, but let's say he was, his veteran payments. So I'm going to take care of those for the benefit of him. So I could, because he is my spouse, commingle that with my Social Security account. So that's an option for Social Security Representative Payee. A mom who's getting payments, or she's getting payments for 3 children, she could combine those for her children, okay? And sometimes they'll come in and say, I could come in and say, I have a dedicated account. My husband was deemed disabled. It took 6 months for that to happen. And so during that time, payments are accruing. So I applied for disability 6 months ago, it got approved, and they might give me one big fat check. Okay, so that dedicated money needs to be put in a separate account from the month-to-month payment that I'm going to be receiving. And then for Veterans Affairs, they can't commingle money with anyone except a spouse. They could commingle the money with the spouse. Okay. And a nursing home, might be handling Medicaid patients who are paying for their stay at this nursing home with their Social Security. That money goes to Social Security, so it might be a collective account where they're coming in. So the account titling for me, Susie Jones, Randy Jones by Susie Jones, representative payee, or just Mary Jones, I put it in a common account. For Veterans Affairs, Mary Doe by John Doe, federal fiduciary. And then for a collective organization, Sunnydale Nursing Home for Social Security beneficiaries, or Sunnydale Home Resident Trust Account. Okay, so that is how those accounts can be set up. And then we're going to identify the representative payees. We're going to use the individual Social Security number, or we're going to use the collective agency Social Security number. And then we're going to ask for a benefit letter from Social Security or the Veterans Administration. In the nursing home, we're also going to identify that legal entity, if it's an LLC or corporation. And then they're going to sign the signature card. And upon the death of the beneficiary, any money remaining in the account belongs to the decedent's estate. And any funds received after that individual dies need to be sent back to Social Security or the VA. And if the representative payee dies, a successor payee will be appointed. All right. Okay. So we talked about a lot today, right? Y'all want to, can we open up the, if you can open up your microphone, feel free to do so. If you have any other questions, comments, if you want to chat any questions or comments, feel free to do that. Trying to open this up. Any questions, guys? So I hope this has been helpful. I got a question. Who can see your message? Recording on. Oh, thank you. Thank you, guys. Thank you. Thank you. Thank you. I appreciate that. A lot of information. I know it's a lot to cover in one day, and that's why I really give it to you in writing. I hope the manual will be helpful for you. I am more than happy to answer any questions for you. You're so welcome. Quick question. Yes, David, feel free to type your question, or if you want to unmute, you can do that as well. You guys are very kind. Thank you very, very much.
Can you hear me, Susie?
I can.
We recently got a guardianship order for, sounds like a temporary guardianship order, somebody that was hospitalized. So we received that in the mail, and then on a week or so after that, both parties came into the branch, and they wanted to make sure that we did not accept that order. The gentleman was now out of the hospital, and the person who was appointed temporary guardian did not want that responsibility. So we had some internal communication about, like, what's the right thing to do? Are we supposed to honor that order because we were given it, from the court, or since both parties were like, hey, disregard it, I'm out of the hospital, and the other person saying, I want nothing to do with this anyway. So more or less, we just said, okay, we're just going to kind of operate like we never received this, and just send them on their way. Was that the correct way to handle that?
It is. I mean, did the temporary order have any sort of expiration date? I guess it didn't.
Yeah, no, there was an expiration date. It was only, I want to say maybe 30 or 60 days down the road. It was just a short order. But then, they both said they didn't want to, for us to honor that or accept it. So we didn't. I just didn't know if that was a, in my mind, it made sense not to accept it since they were both saying, hey, we're good to go. But I didn't know if there was a regulatory concern there or not.
I think you just need to read the order. And if it says that, specifically, did it give any sort of instructions and perhaps why they were, because they're in the hospital or something like that? Huh?
Yeah, it was giving the guardian just temporary control over finances while the gentleman was hospitalized.
Okay, well, what I probably might consider doing in that situation is have both of them sign something.
Okay.
Instead of just taking it verbally, that we would have them sign saying, we understand the bank has received a court order. I, Mary Smith, am no longer in the hospital. I authorize the bank not to accept, this document because it was a court order. And I think you're fine. I don't think it's a big deal. But I think in the future, it might be helpful, just
paper trail.
Yeah, just get some in writing where both individuals are saying, really the temporary order, we didn't need it as long as we needed it type thing. So yeah.
Gotcha. Thank you so much.
Okay, you're so welcome. Any other questions, guys? Okay, well, Stephanie, thank you so much for having us.
Thank you. I'm glad it all worked out. It was our pleasure. Thanks everyone for your flexibility with joining us virtually. And thank you, Susie, for all the great information. Appreciate it.
You're welcome. Thank you. You guys have a
Thanks.
great rest of your week.
You as well. Take care.
Thank you. Bye-bye.